And good morning. I'm John Licker in the 7 News newsroom. It is 8:33. We're day 27 of the Aurora Theater shooting trial. Late last week, we wrapped up a long bout of testimony from Dr. William Reed, the state psychiatrist. Remember, Reed went over this 22-plus hours of videotape testimony by the shooter himself, and that cross-examination and questioning of Dr. Reed finally wrapped up on Friday. In fact, we want to play a little bit of a video here. This is of a cross-examination of Dr. Reed by the defense, asking whether the mental illness on behalf of the shooter led up to or somehow contributed to the shooting, the crime itself. Let's listen in.
I want to start where Mr. King left off last night, okay?
Okay.
Do you remember the question that was posed to you was, but for the defendant's mental illness, whatever that may be, this crime wouldn't have been committed and we wouldn't have been in this room. Do you remember that?
I remember that.
The question is not, did the mental illness affect Mr. Holmes' thinking on July 20th, but to what extent did it affect his thinking and functioning, correct?
That's fair to say, yes.
And it's your opinion, sir, that absent his mental condition, we wouldn't be here at all, would we?
That's a true statement.
This crime would never have taken place without this mental illness.
That's true. In my opinion, yes.
Thank you. I have no questions today. This is a good place to break, Judge.
Yeah. Tell us, are you saying that this mental illness caused the crime and caused us to be in this room?
Without the mental illness, we wouldn't be here, just as without his moving to Colorado, we wouldn't be here, or without his being accepted for the grad school, we wouldn't be here.
Well, let me go a little bit further. But for his girlfriend dumping him, and maybe had she still been in a nurturing, long-lasting relationship through May, June, and July, could we say that this wouldn't have happened?
I wouldn't go so far. He was planning pretty carefully. Anything's possible. Certain things may have changed, but I don't think that was a big part of why he did this.
But for his conclusion that he had no career in science.
It's part of the overall picture. I don't believe, once I say anything's possible, I don't believe that his ending up with that thought, particularly as of June, that would have stopped what was already started.
In terms of there is nothing else that would have stopped this.
I'm not sure I understand.
Well, I guess I'm asking, look, if his girlfriend's with him and they're in a long-term nurturing relationship through May, June, and July, is he able to pull this off?
Objection calls for speculation.
Sustained. And forgive me, Your Honor, I'm asking in the context of his but-for analysis.
Rephrase the question.
In terms of this but-for analysis, had but for his girlfriend not being close to him and in a nurturing relationship through May and June and July as he planned for this massacre, it might not have happened, right?
Objection. Asked and answered. Leading.
No, it's not asked and answered. It's a little different than the question that was asked and answered. So that objection is overruled. It is leading, so I'll sustain it on leading, but you can rephrase the question.
I get it. I think I know where we're going. In your report, the one that the question got asked from yesterday, talk to us about whether or not you think there's a direct causality between the mental illness and the voluntariness of the defendant's actions on July 19th and July 20th.
I do not believe there is a direct connection between the mental illness and the voluntariness. I believe there is a substantial relationship between the presence of the mental illness and the eventual carrying out of the event.
And in part, it's because his desire to murder was something that we've determined was delusional.
Objection. Leading.
Sustained.
Is it because part of his, or a big part of his motivation to want to murder was something that we've determined was, or you've determined was delusional?
Some part of it was, and if I'm understanding your question right, that's related.
Understood.
But my main thing that I think goes to this is that the mental disorder that I believe he has affected the course of events. It did not affect, in my opinion, his capacity to voluntarily or knowingly, the capacity to do those things.
And when you say capacity, are you talking about the capacity to know right from wrong based on societal standards of morality?
Yes.
And the capacity to form the intent to murder after deliberation and to act knowingly in setting up the booby traps in his apartment?
Yes.
The mental illness didn't impact that. It didn't interfere with it.
Objection leading.
It's a follow-up to the question that has already been answered, overruled. Go ahead.
It did not interfere with that, in my opinion.
There again, some of the last questioning of Dr. William Reed from last week, the state psychiatrist. So this week we anticipate seeing Dr. Jeffrey Metzner. That's the first psychiatrist that did an evaluation of the shooter. As you may recall, the prosecution had felt that his, Dr. Metzner's evaluation was incomplete. So why would they bring him to the stand? Well, Dr. Metzner, in his evaluation, however you feel about it, did think that the shooter did have a mental illness, but also said that the shooter was legally sane at the time of the shooting. So we should see Dr. Jeffrey Metzner sometime this week, if not today. By the way, because we went through this more than 22 hours of testimony from Dr. William Reed over the last several days, including all last week, there was so much ground covered. The defense had mentioned to the court last week that it feels now it only needs about 2 weeks for its part of the case. So what's that mean to all of us? It means if the prosecution stays on target, then we actually should be a little ahead of schedule in terms of how long this trial would last. Do we look like we have a court in session? Not just yet. So in other words, if the defense takes just its 2 weeks, that would put us being done at about mid-July, which means the jury would have it in their hands by the end of July. Of course, this all remains to be seen, but right now it does appear as though that we're a little ahead of schedule. Again, largely because of that extensive questioning and all those hours, again, more than 22 hours of testimony from Dr. William Reed, where the prosecution trying to prove that although the shooter may have a mental illness, was legally sane at the time of the crime, the heart of the prosecution's case. So it'll be interesting to see what the defense does in the days ahead. And it looks like court, is that about to start? It is indeed. They are entering the courtroom, so let's let you listen in to day 27.
Number 12 CR 1522. The records reflect that Mr. Holmes is present with his attorneys, Ms. Brady, Mr. King, Ms. Nelson, Ms. Higgs, and Ms. Spengler. And the people are represented by Mr. Brockler, Mr. Orman, Ms. Pearson, Ms. Tish McGuire, and Mr. Edson. We are outside the presence of the jury. We're still waiting for one of the jurors to get here this morning. So, but I thought I'd come out and see if there was anything we needed to talk about. I also wanted to ask you about Exhibit P-TR-1227 in terms of when you're anticipating that coming up. When are you anticipating moving its admission? That's the emails we talked about on Friday.
Your Honor, probably tomorrow.
Tomorrow? Okay. All right. I'll give you my ruling at some point today then. Is there anything we need to talk about at this time on behalf of the people? Mr. Brockler, do you have anything?
Your Honor, thank you.
All right. On behalf of the defense, Mr. King, do you have anything?
I don't, but Ms. Nelson does, Your Honor.
Okay, Ms. Nelson?
Thank you, Your Honor. In anticipation of Dr. Metzner's testimony this morning, I reviewed his report last night, and I confess it had been a while since I had done that, and certainly since the litigation that we had engaged in motion D-264A and the court's rulings in D-264A3. So I was reading his report with that lens or those rulings in mind last night, and I came across some specific statements that Mr. Holmes made to Dr. Metzner, that Dr. Metzner referenced in his report, that I wanted to bring to the court's attention and move to exclude. As the court knows, we previously moved to exclude all of Mr. Holmes' statements made to Dr. Metzner in motion D-187, based on the fifth of the constitutional arguments we had made about the statute before the NGRI plea had even been entered, but we didn't file a videotape or a transcript of specific statements that Mr. Holmes had made to Dr. Metzner. But now that we've been through all that with Dr. Reed, in reviewing Dr. Metzner's report, I wanted to bring some specific statements that we have some issues with to the court's attention, mainly to make sure that we're being consistent, and my goal in making this record is to be consistent with the objections that we raised in motion D-264A. We would object and move to exclude any testimony by Dr. Metzner about Mr. Holmes's statement referenced on page 4 of his report, in which Mr. Holmes tells Dr. Metzner he's a bad shot. That's similar to something that we moved to exclude with respect to Dr. Reed in D-264A, and we would rely on all of the arguments that we made in that motion with respect to that statement. We also obviously are concerned and object to any statements made by Mr. Holmes to Dr. Metzner specifically about what occurred in the theater. There's some statements that are mentioned and referenced by Dr. Metzner that are similar to some of the statements that we identified in motion D-264A, including shooting at people running out of the theater, diverting the police to the apartment so that he could kill more people in the theater. Our position on those statements, as the court well knows, is that they violate the 5th, 6th, 8th, and 14th Amendments and their Colorado counterparts, and also violate or don't survive a 401, 403 analysis because they're more probative of guilt than they are of sanity. As well, Dr. Metzner mentions Mr. Holmes's religious history on page 48. We made an objection to similar information elicited from Mr. Holmes by Dr. Reed in motion D-264A, so we would rely on all of the arguments that we made in D-264A with respect to those statements. And then there are actually 3 issues discussed in Dr. Metzner's report, including statements by Mr. Holmes on topics that the court has the statements that were made to Dr. Reed. Would the court consider allowing me to approach with counsel to discuss those with the court at the bench? I know that the jury's not present, but out of an abundance of caution, because we have media present, I'd prefer to do this at the bench.
No, I think we should do it in open court.
Very well. So there's a statement on page 50 in which Mr. Holmes informs Dr. Metzner, or Dr. Metzner quotes Mr. Holmes as stating that he continues to have chronic homicidal thinking, very similar to the homicidal thinking that has been present for most of his life. That statement is very similar to a statement that the court excluded from the videotape, or ordered redacted from the videotape of Dr. Reed's interview with Mr. Holmes. There's a statement about remorse on page 18. It's a response by Mr. Holmes to a question posed by Dr. Metzner about regrets about the shooting, in which he says yes and no. That's very similar to an exchange that was excluded from Dr. Reed's video. I think that was paragraph 60 of motion D-264A. And then on page 9 of Dr. Metzner's report, there is a discussion, there was apparently a discussion between Dr. Metzner and Mr. Holmes about his invocation of his Miranda rights. Dr. Metzner states, after Mr. Holmes was arrested and during the initial interview by detectives, he was read his Miranda rights. Mr. Holmes requested an attorney because, quote, that's what you're supposed to do. So he knew he was in trouble because there was a statement on page 19 of Dr. Metzner's report that was similar to a statement that Mr. Holmes made to Dr. Reed, that Mr. Holmes is not concerned about the death penalty because, quote, there's no reason to live. We didn't move to exclude this from the videotape from Dr. Reed, frankly, because we missed it the first time, Your Honor. And but that obviously doesn't preclude us from objecting to it now. I think it would be cumulative, among other things, but I don't think this is relevant to sanity, and we would object under 401 and 403. So those are the specific statements that we have some concerns about with respect to Dr. Metzner, to the extent that we're aware of which statements Mr. Holmes made to Dr. Metzner, and to the extent that any of these are going to come up during Dr. Metzner's testimony, I wanted to bring them to the court's attention.
Okay, thank you. Response? Mr. Brockler, you're going to respond?
And I would add, Your Honor, I'm sorry, I brought this up with Mr. Orman this morning because Mr. Brockler was otherwise occupied, so I did give the prosecution a heads up. It was a bit last minute, but so was my discovery on these issues, so.
All right. Mr. Brockler.
Yeah, Your Honor, I was handed a sticky moments before you took the bench that has a sort of a generalized list of what Ms. Nelson had told the court. I can't go into detail on all of them because I haven't had the opportunity to go through the report looking at these individual ones, but I am aware of the subject matter. And I think that the one that Ms. Nelson directed the court to about being a bad shot and all the statements about the theater, the court's previously ruled on those in relation to a specific objection or motion that the defense filed regarding Dr. Reed. Those same arguments that we made would apply, and I'd ask the court respectfully to rule as it had in Dr. Reed's video. The still having homicidal thoughts part, Your Honor, I mean, the issue of whether or not this delusion exists and is ongoing has been something that both sides have talked about. In fact, Mr. King even got out of Dr. Reed that he still believes today these things. And so I think it's not only relevant, but there can't be a prejudice to something that was addressed not only in that cross, but in opening. This goes to remorse. Mr. King had referenced that he regrets it. He referenced that his client regrets what he did. And now we have a forensic psychiatrist appointed by the state who factors that into his decision about whether this guy has the capacity to know right from wrong based on societal standards and morality, and I think that's part of it. The religion part, Your Honor, I was able to look that one up, and what it looks like is there's a reference to the defendant saying that he's agnostic, but then goes on to clarify that what he means by that is something very akin to moral relativism, which is you just believe whatever it is you want to believe. And so that would be how that factors in. As for the page 9 invocation of Miranda rights, Your Honor, I've already spoken in detail about that with Dr. Metzner. And I should put on the record, Judge, Dr. Metzner is present in the court. We asked him to be here to listen to these in case the court ruled in a certain way on statements, so he would be aware. While I think it shows an absolute rational and logical way of thinking, and it certainly shows his presence of mind immediately after the shooting to have requested an attorney, I also think that based on some of the other things that we've agreed to keep out in sort of this third rail nature of Miranda invocation, that I don't have a problem if the court excludes that one. And in terms of not being concerned about the death penalty, while it's consistent with a topic that was addressed and not objected to at Dr. Reed, I don't think it's objectionable, and I don't think it's cumulative. Much of the information that Dr. Metzner got may sound similar or even completely consistent with what he told Dr. Reed, but it factors into a completely different expert who is analyzing this and frankly comes to some different conclusions along the way before we get to the sanity determination. And on that short notice, Judge, that's all I have.
All right, thank you. Yes.
May I make one brief response?
If you go to the podium, please. Yes.
Just on the topic of continuing chronic homicidal thoughts, that's very different than the testimony that from Dr. Reed about Mr. Holmes's continuing to believe in the delusion. There's a distinct difference between testimony that he continues to believe his delusion and that he continues to have chronic homicidal thoughts. It was paragraph 92 of motion D-264A, and for the court's reference, the pages of the transcript of the videotape that the court excluded were pages 515 to 17. And I think if the court reviews that portion of the transcript of Mr. Holmes's interview with Dr. Reed, those statements are very similar to that quotation from Dr. Metzner that I mentioned earlier. So that's something the court has already ruled should be excluded from this phase of the trial, and so we would ask the court to issue a similar ruling that's consistent with its ruling in D-264A3.
What page of my order is it?
Oh, of your order? I can look that up real quick. Hold on. I apologize, Your Honor, if the court would just give me just a moment. I know that there were two different parts of the videotaped interviews that the court excluded on this basis. One of them is referenced on page 26 through 34 of the court's order.
26 to 34, you said?
Yes, and then I think there's another one. Oh, yes. The one I was actually referring to, though, starts on page 40 of the court's order and continues to page 43.
Okay, give me just a moment, please.
Okay. And when the court's finished, I have one more thing I forgot to say.
Okay. All right, Ms. Nelson, what else did you want to add?
I don't think this is going to be an issue, but out of an abundance of caution, the court ruled in D-246 that Dr. Reed's testimony needed to be consistent with the Colorado Court of Appeals decision in People versus Herrera. Obviously, Dr. Metzner is familiar with the Colorado's insanity statute and the standards for assessing sanity in Colorado. But because D-246 pertains specifically to Dr. Reed and not Dr. Metzner, I just wanted to make a request or confirm that he's familiar with the court's order in D-246 and intends to frame his testimony in the terms consistent with that court's order on that motion.
Yes, thank you. I brought this up on Friday at the end of the day, and the prosecution represented to me that they would talk to Dr. Reed and that they had shared with Dr. Metzner all of my orders that are relevant to his testimony. A couple of highlights include the one that Ms. Nelson just mentioned, that Dr. Metzner can testify about the defendant's capacity to distinguish right from wrong based on societal standards of morality, and whether the defendant lacked the capacity to form the culpable mental states required by the crimes charged. But he cannot testify that the defendant actually could distinguish between right and wrong, or that the defendant actually had that the defendant actually formed the culpable mental states. And so that's the difference. The difference is between capacity to do it and actually doing it. Whether the defendant actually distinguished right from wrong and whether the defendant actually formed the culpable mental states will be questions for the jury. And all the experts can talk about in the Colorado law is capacity. And so that ruling with respect to Dr. Reed applies equally with respect to Dr. Metzner. Additionally, Dr. Metzner cannot talk about the fact that I found his examination to be inadequate and incomplete, and therefore appointed a second examiner to conduct a sanity examination. So that whole topic must be avoided. There should be no mention at all of any of the court's findings with respect to the first examination. The fear is that the jury will hear what the court thinks about Dr. Metzner's evaluation, and that's what we're trying to avoid. So anything having to do with the court's credibility findings or the court's findings of the adequacy of Dr. Metzner's examination, all those topics should be avoided. And by the way, Ms. Nelson, I'm assuming the defense is not objecting to Dr. Metzner being called to testify about his examination by the prosecution on the basis that I found the examination to be inadequate. Is that correct?
Yes.
Okay, all right, thank you. So these are a couple of the rulings that come to mind, but whatever other rulings I have issued that apply to Dr. Metzner's testimony. In terms of the objections raised or the motion to exclude that was raised earlier this morning, it would have been nice to have this raised earlier. We had a lot of litigation in this case, a ton of pretrial litigation. I have ruled on hundreds of motions. I think the defense was up to about 300 or close to 300 motions. The prosecution filed more than 100. I've issued hundreds of orders in this case. I've made thousands of rulings in this case. And during the 2 years before the trial, more than 2 years before the trial, this should have been raised. Raising it on the morning before Dr. Metzner takes the stand makes it difficult on the court. Dr. Metzner wrote, I think, a 69-page report, including, I think, some of the actually, that may not have included the attachments. I can't remember now, but I remember that it was a very lengthy report he submitted. And there's no way that on the morning of trial, minutes before he takes the stand, I can go and review that again. I've reviewed it in the past, but I can't take the time to do that now. I can't take the time now to review my order that I issued with respect to Dr. Reed, Order D-264, small a-3. That's a lengthy order, over 50 pages long. I've reviewed it a few times. I reviewed it recently, but had I known that this motion to exclude was going to be made, I would have taken the time to go through it again. I would have taken the time to go through the transcript of Dr. Reed's interview again. Even if it had been raised on Friday, it would have given me a little time to do some of that, but it's being raised on the morning of the testimony, minutes before Dr. Metzner takes the stand. Dr. Metzner is here actually in the courtroom just waiting to take the witness stand. And so it's untimely in that sense. It's not untimely in the sense that Dr. Metzner has not testified yet, but I haven't heard of the reason why this wasn't raised earlier in a timely fashion. So that's the first thing. The second thing, in terms of the merits of the request, I'm gonna be consistent with my previous rulings with respect to Dr. Reed, and I'm gonna try to do my best to be consistent. Again, given the short time that the defense has given me, and given the fact that I don't have time right now to review all these things that I mentioned a moment ago. There were a few things or maybe more than a few things, there were some things that I ordered redacted with respect to Dr. Reed's examination of the defendant at the defendant's request, in an abundance of caution under Rule 403. And with respect to some of them, I could have allowed them, and I specifically found that they were probative, and that they were relevant and admissible under Rules 401 and 402. But in an abundance of caution, I kept them out under Rule 403. And some of these things could have been allowed also just to show the type of evaluation that Dr. Reed conducted, not for and not for any other purpose, but for that purpose itself. But in the end, I concluded that there was certain information that I thought I needed to redact in an abundance of caution, and so I ordered that. And I'm gonna try to be consistent here. But I wanna make sure that I think as my order shows, and I'm referring to my order D-264 small a-3, these were close calls for me, and this, I was again, in ordering redactions, proceeding in an abundance of caution and trying to be careful in terms of what information might have an undue prejudice for the defendant, or what information could have an inflammatory effect on the jury. And comparing that to the probative value of the information, keeping in mind that frankly, all of the questions by Dr. Reed were questions that were asked as part of his examination, and I think theoretically, I could have allowed the whole thing without any redactions, because it went to the evaluation that he conducted, whether some of the questions bore fruit or not, and whether some of the questions ended up providing or eliciting answers that he later found to be significant or not. They were still questions that he asked as part of his examination, and the jury, I think, was entitled to know what questions he asked and what type of examination he conducted in order to assess the reliability of his examination and in order to evaluate his opinions. With that being said, the first request is to the defendant's statement that he's a bad shot. I allow that with respect to Dr. Reed. With respect to Dr. Reed's examination, there was an exchange with Dr. Reed about the defendant not getting better. I think the question was, did you get to be a better shot from the beginning to the end? And the defendant responded, no, I stayed a terrible shot. And then he chuckled at that point, and then Dr. Reed asked, stayed a terrible shot? Okay. So that was the exchange that was in question in motion D-264 small a-3. And to the extent that Dr. Reed asked the defendant about this in terms of the defendant's activities at the shooting range in preparation for the shooting at the theater, then my ruling is the same as it was with respect to Dr. Reed, that it's part of that discussion about the defendant going to a shooting range on more than one occasion and practicing. And I think the common sense question is, did you see any improvement in your shooting? Did you, as time went on, based on your activities, was the practice effective for you? And I think it's part of the sanity examination that each of these doctors conducted, each of these court-appointed experts conducted. I mentioned in my order that the defense was not contesting Dr. Reed's inquiry into the defendant's activities at the shooting range in preparation for the shooting at the theater. Instead, the defense was arguing that the defendant's current perception as to whether his aim improved after practicing at the shooting range was irrelevant to his mental state at the time of the crimes charged and was not relied upon by Dr. Reed in his report. And the prosecution responded that the discussion in question was relevant to the defendant's thought process about the crime that he would later commit, the amount of time, the planning, and the preparation that he was putting into it, and that these things are by extension directly related to sanity, to the issue of sanity. And I agreed with the prosecution and therefore denied the request. Same ruling applies here. Now, Dr. Metzner shouldn't just go out of his way to say that. I'm allowing it to the extent that this was part of his examination and that he felt it was something important to inquire about, and then he can explain why he asked about that, or he can explain what significance this had and his opinions. That's what how I treated the objection with respect to Dr. Reed, and I'm treating it the same way here. So this isn't an opportunity to gratuitously add, oh, the defendant said that his shot never improved. There has to be some reason for it. And so to the extent Dr. Metzner asked about this because he felt it was an important question to pose to the defendant as part of his examination, and or to the extent that the defendant's answer is of significance in some way to Dr. Metzner's opinions, then I'm allowing it. Number two is the defendant's statement about what occurred inside the theater, and this is objected to on constitutional grounds and also on evidentiary grounds. I plan to give the jury the same limiting instruction that I gave the jury with respect to Dr. Reed, and if Ms. Nelson wishes, I could expand it even further. She said that some of this testimony is more probative of guilt than it is of sanity. If you want, I can explain to the jury when I mention that this evidence, and when I say this evidence, I'm referring to Dr. Metzner's testimony and the defendant's statements to him, is only being admitted for the limited purpose of considering the issues raised by the plea of not guilty by reason of insanity. I can not only explain what I've explained before to the jury, which is that issues related to the plea of not guilty by reason of insanity refer to the capacity to distinguish right from wrong and the capacity to form the culpable mental state, or the culpable mental states that are elements of the crimes charged. But I can add to that I've mentioned to the jury before that each crime charge has elements, and one of those elements is sanity. And so this testimony only goes to that one element of sanity. It doesn't go to any of the other elements. The jury has heard me talk about elements. I talked to them about that in individual voir dire, in general voir dire, and then right before opening statements once we had a jury selected already. So they know about elements. I've explained that concept to them. I specifically told them what elements there are for each type of crime charge in this case. And so if Ms. Nelson, if you would like, I'll give you an opportunity to request that type of instruction. I'm happy to expand on that if you wish. But having said that, I will allow it. These are the defendant's statements in a sanity evaluation are, in my view, among the most important portions of that evaluation. I don't see how an expert can conduct a sanity evaluation without asking the defendant about the crimes charged and what he was thinking as the crimes charged took place or allegedly took place. Nor do I think that an expert can offer expert opinions about sanity without getting into what the defendant said about the crimes charged. To me, this is necessary for an expert to be able to opine on sanity. So the objection is overruled. Number three is the defendant's religious history. And Mr. Brockler said that after the defendant says that he's agnostic, that he then clarified that he was referring to moral relativism. I have previously excluded the defendant's declaration in an exhibit. I think it was one of the either Match.com or AdultFriendFinders.com exhibits where he declared that he was agnostic. And to me, there is some probative value to him saying that he's agnostic, but Given what the jury has already heard from Dr. Reed about religion and the defendant's religious beliefs or lack thereof, I don't think allowing information that is agnostic adds all that much probative value. So I will sustain the objection as to use of the word agnostic. And Dr. Metzner is here in the courtroom. Obviously, he can speak about moral relativism to the extent that the defendant said that that's something that he believed in. He can speak about other things related to religion. I allowed the videotaped interview Dr. Reed did to include some discussion of religion. There was a lot of discussion of religion, but never anything where the defendant just said, I am agnostic. I think the defendant talked to Dr. Reed about how when he was younger, he went to church with his parents. His parents used to have to bribe him, as he put it, to go to Taco Bell afterwards to get him to go to church. His mother was particularly religious, but his father wasn't really into it, and he himself was never really into it. That kind of thing. I think that kind of discussion is okay, but saying that he was agnostic, given the rest of the evidence that has already been introduced and the rest of the discussion on religion that may be introduced, I think is unnecessary and has little probative value. And I'm concerned that someone on the jury who is particularly religious may find that to be upsetting, or may find that to be something that has an inflammatory effect. And so I am keeping it out under Rule 403. Under number 4 in my list, the next thing I have is the request to exclude the statement by the defendant to Dr. Metzner, in which he says that he continues to have chronic homicidal thinking. And I looked up my order on Dr. Reed, again, order D-264, small a-3, and Ms. Nelson pointed me to page 40. And this was a section on thoughts of hurting people. And although I kept out the information the defense asked me to keep out from Dr. Reed's evaluation related to this topic, one of the reasons I granted the defendant's request is because before the challenged exchange, the defendant had already indicated to Dr. Reed that the shooting did not stop his suicidal or homicidal thinking. That's on page 42. So part of my reasoning was, well, the defense isn't objecting to him saying, the defendant telling Dr. Reed that the shooting didn't stop his suicidal or homicidal thinking. Therefore, the challenge exchange has little probative value because it doesn't add a whole lot. It adds something that's marginal. Same thing as the comment that I was making a moment ago about the agnostic term. And so, same type of ruling here. And by the way, my recollection is similar to Mr. Brockler's, and that is that during Dr. Reed's examination, both sides went into this, not only in terms of what the defendant was like at the time of the shooting and before the shooting, but also what's happened since then. The fact that he's on meds now, the fact that he's been in jail, and he was in jail at the time of the interview, the fact that even now he continues to have this delusional belief. I don't see a whole lot of difference between saying that the shooting didn't stop his suicidal or homicidal thinking and saying that he continues to have chronic homicidal thinking. The word chronic is the only difference, and I'm not sure what unfair prejudice that has. The defense didn't object or didn't ask me to request that specific part of Dr. Reed's examination where the defendant said that the shooting didn't stop his suicidal or homicidal thinking. I think Dr. Reed talked about how the defendant's belief or delusion about human capital continues to exist today. Well, that means that he continues to believe that he has to kill people to increase his self-worth and to avoid committing suicide. I don't see a whole lot of difference between what has already been allowed, what Dr. Metzner apparently said in his report. So that request is denied. The next one is the statement about remorse or regrets about the shooting. And I did say in order D-264 small a-3 that this had probative value and was relevant. But in an abundance of caution, I kept it out on the Rule 403. And so I'm gonna do the same thing here. Same type of ruling, so I'm gonna be consistent again. And again, this was a close call for me, and someone else would have let it in. I could see it going both ways. I erred on the side of keeping it away from the jury, at least during the guilt phase of the trial. If there happens to be a sentencing hearing, then this may be something that is admissible, but that question isn't before me right now. So to be consistent, that request is granted. The next one is a discussion about Miranda rights, and that request is granted as well. So Dr. Metzner, anything related to Miranda advisements is out. So no comments about how the defendant invoked his Miranda rights or how he asked for a lawyer. No comments about any of that stuff. I think best to try to stay away from any interrogations. And to the extent that counsel wish to ask him questions about any interrogations, they should ask leading questions that stay far from my rulings. And by the way, there's no objection to this particular request, so this request is granted without objection. And the final one is the defendant saying that he's not concerned about the death penalty because there's no reason to live. Frankly, when I saw that the defense didn't object to a similar discussion between Dr. Reed and the defendant, I was a little surprised. And had the defense requested this to be redacted from Dr. Reed's examination, I would have granted their request. I'm not saying that there was anything wrong with it. I'm just saying that I would have granted it for some of the same reasons that I granted other requests to redact. But it's not up to me to decide what redaction should be made. It would be improper for me to even suggest what redaction should be made. And I realize that counsel sometimes have strategic reasons for not requesting redactions or for requesting redactions. Other times it's based on whether counsel believes they have legal grounds to seek redactions or not. And I figure that counsel either made a strategic decision about it or concluded that there were no legal grounds to request a redaction. But given that it's already played with Dr. Reed without a request for that to be redacted, I'm not going to allow it here. I don't think it's necessary, and the defense is requesting that it be redacted now, and so I am going to order not be redacted, but the defense is asking that it be excluded, so I'm going to order Dr. Metzner not to talk about the defendant discussing the death penalty and how he wasn't concerned about it because there's no reason to live. Now, same thing I said with respect to Dr. Reed's interview of the defendant. You have to be careful not to open the door on some of these rulings that I have made. To the extent that I've excluded these things, you can't ask a question, whether intentionally or inadvertently, and open the door. If you do, then I may have to change my ruling and I may have to allow what I have ordered to be excluded. So those are my rulings with respect to Dr. Metzner's testimony. Is there anything else, Ms. Nelson?
Not at this time, Your Honor.
All right, thank you. Is there anything else from the people?
No, Your Honor, thank you.
Do we have all the jurors here now? Yes. Okay, the jurors are all here. So with that, then, let's go ahead and bring the jury in. And Dr. Metzner, if you're asked a question that you're not sure you can answer without running afoul of one of my rulings, just say that. Just say, I don't know if I can answer that question based on the court's rulings or something. And then counsel will know that they can lead you or change the question. If we need to take a break, we will. If we need to have a bench conference, we will. And we'll go that route, okay? Thank you. All right.
So, Your Honor, while we're waiting for the jury,
Yes.
with respect to the limiting instruction, the expansion on the limiting instruction the court proposed, without waiving any of our objections and maintaining our position that a limiting instruction is insufficient to cure the constitutional issues, we would respectfully request that the court give the limiting instruction as expanded and proposed by the court.
Okay, I will, and I'll tell them that this applies the same to Dr. Reed's testimony. Please be seated, everyone. Good morning, members of the jury. How was your weekend? Good, great, okay, I'm glad. We had good weather for the most part. It seems like it rains every day or every other day, but for the most part, we had good weather. Thanks for coming back. Thanks for your patience this morning. As I have mentioned before, there are times when the lawyers and I have to talk outside your presence about administrative or scheduling or legal issues. And so we do it, and I appreciate your patience. Thank you for being as patient as you are. All right, with that then, Mr. Brockler, you may proceed by calling your next witness.
Thank you, Your Honor. The people called Dr. Jeffrey Metzner. There's an updated one of those.
Good morning, doctor. Good morning. You solemnly swear affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I do. Okay, please be seated. Could you please tell us your full name for the record and spell your first, middle, and last names?
Jeffrey Lee Metzner, Jeffrey Leemetcner.
Mr. Brockler, you may proceed with your direct examination.
Thank you, Your
Actually,
Honor.
before you do,
Yes, sir. Yes, sir.
I'm going to give the jury a limiting instruction. Members of the jury, the court has admitted the testimony of Dr. Metzner only for a limited purpose. You may consider this testimony only as to the issues raised by the defendant's plea of not guilty by reason of insanity. You shall not consider this evidence for any other purpose. As I have mentioned to you before, when I say or when I refer to the issues raised by the defendant's plea of not guilty by reason of insanity, I mean issues related to two questions. Number one, whether the defendant was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act. And the word wrong there refers to moral wrong as measured by societal standards of morality. And number two, whether the defendant suffered from a condition of mind caused by a mental disease or defect that prevented him from forming a culpable mental state that is an element of a crime charged. And as you know, there are two culpable mental states that are elements of the crimes charged in this case. After deliberation and with intent is one of them, and the other one is knowingly. I explained to you at the beginning of the trial that each of the crimes charged in this case is made up of elements. Do you remember that discussion about elements? One of the elements of each crime charged in this case is sanity. The prosecution has to prove beyond a reasonable doubt that the defendant was sane at the time of the commission of the act. This evidence by Dr. Metzner, and same as the evidence, the testimony of Dr. Reed, and same as the defendant's statements in the videotaped interview by Dr. Reed, I said all of that evidence can only be considered by you for limited purposes, and that is only as to the issues raised by the defendant's plea of not guilty by reason of insanity. So you can only consider it as to that one element of sanity. You cannot consider it with respect to any other elements in each crime charge. Does that make sense to everyone? Yes. Yes, and everyone's saying yes and nodding their head yes. Wonderful, thank you. With that, now, Mr. Brockler, you may proceed with your direct examination of Dr. Metzner.
Thank you, sir. Sir, would you please tell us what you do for a living?
I'm a psychiatrist with a specialty in forensic psychiatry.
Does that mean you are also a medical doctor?
That is correct.
Dr. Metzner, were you asked to conduct a forensic psychiatric evaluation of the defendant and render an opinion about whether or not he meets the definition of insanity under the laws of Colorado?
I was.
Okay. I want to talk to you about a couple different things. One, I'd like to start off with talking about how you get to be a psychiatrist and how you got to be in a position to do this. We're going to then talk about your methodology for how you conduct and how you did conduct this, and we'll talk about some opinions as well, okay?
Yes.
First thing I want to ask you, though, is were you hired by the prosecution to conduct this psychiatric evaluation?
No, I was court appointed, and the appointment came through the Colorado Mental Health Institute at Pueblo.
Is that what we might colloquially call the state hospital, the state mental hospital?
That is correct.
Okay. What I'd like to do, sir, if I could, is approach with People's Exhibit 1226, Your Honor, if that's permissible.
Yes.
Take a look at that, sir, and tell us if you know what that is.
Yes, this is a copy of my curriculum vitae.
Is it current?
Yes.
Now, is this a fair and accurate representation of the education, publications, honors, committees, all the things that make up your expertise?
Yes.
Your Honor, I'm going to move for the admission of People's Exhibit 1226 into evidence.
Is there any objection, Mr. King?
No, Your Honor.
All right, without objection, People's Exhibit P-TR-1226 is admitted.
Now, Doctor, while this may contain the listed items, what it doesn't do is help us to understand what they mean or what their significance are. Would you agree with that?
Correct.
Let me ask you to start off with this. How did you become a psychiatrist?
Well, first I had to get go to undergraduate school. I then went to medical school. I went to the University of Maryland Medical School, and I graduated in 1975. I then did a psychiatric residency and medical internship at what used to be called the University of Colorado Health Sciences Center. And that was for 3.5 years. I did an additional year, optional year, at the forensic division of what used to be called the Colorado State Hospital, where for a year I was treating people who had been found not guilty by reason of insanity or had been found incompetent to proceed. I did that for a year. When I finished my residency in July of 1979. After that, I became board certified by the American Board of Psychiatry and Neurology with a specialty in psychiatry, and that was during, I think, 1981. I subsequently became what's called board certified or additional qualifications in forensic psychiatry by the same board, and I think that happened around 1991. Yeah, so that's what I needed to do in order to become a psychiatrist.
Let's back up and talk about a little of that. If we were going to say globally, how long have you been practicing psychiatry? You would say how long?
Well, if you don't count my residency, it would be 35 years. If you count my residency in which I was practicing psychiatry, it'd be close to 40 years.
And if you got that board certification in forensic psychiatry in 91, is that right?
I think it was 1991.
Have you been a specialist, at least in the area of forensic psychiatry, for 24 years?
Well, I actually was a specialist in forensic psychiatry beginning in 1979. The reason I didn't get the additional qualifications in forensic psychiatry is that additional qualification criteria was not in existence until I think about whenever it became in existence, I got it the first year.
So you've been doing forensic psychiatry for over 35 years?
Yes.
Now, one thing that we might ask of experts is where they're
Well, good morning, everyone. And I do apologize. I just ran back here to our newsroom from our engineering control room, where our expert engineer, Mike Shanahan, has informed me that there is someone who has activated a microwave signal on the channel adjacent to the channel that we use to receive our signal from the court. And as a result, we're getting interference, and the decoder can't distinguish between these two signals. So that is why we had the blue screen of death there for a minute, but I can assure you that Erica and Brian and Mike are working their butts off to weed out the interference, figure out who's on that channel, and get it all restored to normal. The good news is we are in the middle of a process that, if you remember 2 weeks ago with Dr. Reed, this process of identifying and certifying Dr. Metzner as an expert will take some time. So we'll have plenty of time to rejoin this before we hear any of the interesting testimony, the testimony that actually pertains to this case. So in the meanwhile, I am up here rambling, and I've got the notes here from Brian on my phone so that I can try to keep up with the logs and things as that process continues. So what we know about Dr. Metzner: we have never heard him speak before, so today is the first time we've heard this. He was originally assigned to the case as the very first doctor assigned to conduct a sanity examination of the defendant. So Dr. Metzner's examination began nearly a whole year before Dr. Reed's examination. It was eventually protested, and the court agreed, with the phrase being incomplete and inadequate. However, we've heard from District Attorney George Brockler that he did reach the same conclusion that Dr. Reed reached. Their diagnoses were apparently different. We'll hear more about that in the coming day or day and a half, I'm sure. But the court may be returning. But anyway, let's go back to the courtroom, and if this problem persists, we'll be here to rejoin you in a few minutes.
80s, I had a fairly large inpatient practice. I've continued to have a very small outpatient practice now. Most of my work now involves what's called correctional psychiatry, and correctional is referring specifically to mental health services in jails and prisons. And I work for predominantly federal courts around the country in developing and monitoring mental health systems within jails and prisons. And although within that work, I'm not specifically responsible for the care and treatment of detainees or inmates, I talk to thousands of them, and I review the clinical work that's being done.
In your clinical experience, ballpark, how many patients have you treated? Is that the right word? Is it treated?
Yes. I thousands.
Have you seen people who you have concluded were schizophrenic?
Yes.
Delusional otherwise?
Yes.
Psychotic, all that?
Correct. And just to remind you, when I did a year on the forensic division of the state hospital, the bulk of the people I saw had either been found not guilty by reason of insanity or incompetent to proceed. Both of those categories, people had chronic and severe mental illnesses. But also in my private practice in the 80s, I've treated people who have had severe mental illness, and through the work that I do in jails and prisons, the mental health system that is set up, the specific target population is for people who have serious mental illnesses.
Now, I see there's pages of publications here, but I really want to ask you to only, as one measure of your expertise, to ask if you have published peer-reviewed articles in the area of psychiatry and forensic psychiatry.
I have.
Are there some that are particularly relevant to what you did in this particular case?
Well, the bulk of my publications have to do with mental health systems in jails and prisons. And it's relevant to the extent, as I mentioned before, that those services are targeted for people with serious mental illnesses.
Are there other activities that you're engaged in that touch upon what you did here, or at least the forensic aspect of this?
Yes. Part of my forensic practice, in 1979 is when actually it was 1978, when I spent an optional year in the forensic division of the Colorado State Hospital. And when I talk about forensic division, I'm distinguishing that from the civil division. Civil division are people who don't have criminal conduct or alleged criminal conduct that resulted in their commitment. That's the civil division. The forensic division is if you have criminal conduct or alleged criminal conduct related to your mental illness that requires hospitalization, you would go to the forensic division. So part of what I did during that year is, besides providing treatment, I would do what's called observation cases. And what that means is courts from around the state would send people to the forensic division to do sanity or competency evaluation. And so I did many of them during that year, but once I finished that year and finished my residency, I have consulted to the state hospital ever since that time, generally on a monthly basis. During the 1980s, most of my consultation was doing sanity evaluations or competency evaluations. And between doing that down at the court, down at the hospital, and in Denver, part of my private practice involved doing sanity and competency evaluations that were either court-ordered or were at the request of defendants or were at the request of the prosecution. And so I've done hundreds of sanity and competency evaluations, which obviously have some relevance to being able to do this kind of sanity evaluation.
The bulk of those, if not all those sanity evaluations, are applying Colorado state law about sanity to what you were doing?
All of them. When I talk about doing hundreds, I'm talking about in the state of Colorado.
Just to touch real quickly, I see a bunch of pages here on book chapters you've done too. Do those also get peer reviewed?
Book chapters get peer reviewed, but not with the same intensity as journal chapters.
Okay. Have you received honors in your field for what you do? Ones that you think are particularly highlightable?
Yes, I have. I've received national honors by the American Psychiatric Association, by the American Academy of Psychiatry and Law, and by the National Commission on Correctional Health Care. And most of those honors have focused on my work within correctional psychiatry.
Now, you've talked about doing hundreds of sanity evaluations. Have you ever been recognized as an expert in a court in the areas of psychiatry and forensic psychiatry?
I have.
How many times?
I've lost count, many times, well over 50.
And in courts other than just Colorado state courts?
Yes, I've been, I'm trying to think what states, California, New Mexico, Hawaii, state of Georgia, New York, Massachusetts, New Hampshire, they're the ones that come immediately to mind.
In addition to state courts, federal as well?
Yes, and the other states that I mentioned, they were all federal courts. The other state court is South Carolina.
Have you ever been mentioned in a U.S. Supreme Court opinion?
I have been mentioned in a U.S. Supreme Court opinion. There was a case called Colorado v. Connolly, and it had to do with defining various aspects of Miranda rights.
Okay. Let me ask you this. You've talked about the different ways you've come to cases to do evaluations. You reference the court, you reference the defense, you reference the prosecution. Can you give us some estimate by percentage of how many times you've been appointed by a court like you were in this case?
Yes, and I'm assuming you're asking me specifically in the context of sanity evaluations.
Yes, doctor.
Within sanity evaluations, well over half of my examinations have been requested by the court. And I think if you look at the remaining, whether it's 40%, I think it's pretty equally divided between between defendants and DAs. And you may go in one jurisdiction where the DAs send me a lot of cases, and then go in another jurisdiction where the public defenders send me. But it's been primarily court appointments.
Have you found and testified that criminal defendants were insane under Colorado's laws based on your forensic evaluations of them?
Objection, relevance.
Overruled.
I have.
And you've also I'm sorry to catch you in mid-drink. You've also testified that when appropriate, they've been sane.
Correct.
Leading.
Overruled. It's a follow-up to the last question.
Correct.
Your Honor, at this point, I'm going to offer Dr. Jeffrey Metzner as an expert in the areas of psychiatry and forensic psychiatry.
Do you have any objection?
I do not.
Without objection and pursuant to Rule 702 of the Colorado Rules of Evidence and the decision in People versus Shrek, 22 Pacific 3rd 68, Colorado 2001, the court qualifies Dr. Metzner as an expert witness in the fields of psychiatry and forensic psychiatry. That means, members of the jury, that he now has been qualified to render expert opinions. Let me give you in the fields that I mentioned, let me give you the instruction that I've given you in the past with respect to expert witnesses. You're not bound by the testimony of a witness who testifies as an expert. The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of an expert witness's testimony, part of it or none of it. The weight that you give the testimony of an expert is entirely your decision. All right, with that, you may proceed.
Thank you, Your Honor. Doctor, I promised you I was going to ask you this. Now we're here. Tell us what the distinction is to be made between general clinical psychiatry and forensic psychiatry.
Well, it's a different approach. When you're doing general clinical psychiatry, you have someone most of the time who's coming to you because they recognize a problem and they want to get help. And I say most of the time because sometimes you get people who are brought in by family or court ordered because they're having problems but they don't recognize the problem. And so one of the goals that a treating clinician would have is to establish what's called a therapeutic relationship with the patient, and they're a patient, and you have a doctor-patient relationship in which the assumption is, if I'm the treating doctor, I'm here to help you, and the other assumption is that what you're telling me is accurate because you want to get help. And my ethical duty is to do what's in your best interest. That's a clinician, whether it's a psychiatrist or a psychologist or other mental health clinician. A forensic psychiatrist in the context, and I'm going to make it in the context of doing a sanity evaluation,
Yes, sir.
because there's other contexts. In the context of doing a sanity evaluation, it is not a doctor-patient relationship. That the person I'm evaluating, I am not their doctor. And it's very important ethically to make it clear during the examination that I'm not your doctor because I'm going to be addressing some legal questions. And my opinion may or may not be in your best interest from your perspective. And your approach is very different. In doing a sanity evaluation, for example, it's extremely important to have face-to-face interviews with the person that you're evaluating to ask relevant questions. But you don't stop there. You got to get as much information from other sources to help not only structure your interview, but also to help determine the reliability of the information that you're getting from that person.
So is there a different approach in terms of preparation to how you conduct the sanity evaluations for a forensic setting versus how you would deal with a patient on a clinical level?
Yes. So, for example, when I see someone from a clinical perspective, I may have only had a brief phone contact with them to get a very general idea of why they're coming to see me. And then I don't know anything about them in general until they show up. And then, I start the diagnostic evaluation, which may, maybe I'll have 3 interviews and maybe it will be 3 hours, and that help me formulate a diagnosis and formulate a treatment plan. In a sanity evaluation, it's extremely uncommon that before I go see someone that I haven't gotten police reports and reviewed police reports and had past medical records, past psychiatric records before I even start the examination to help me prepare to structure my interview to highlight some questions. And I don't go in assuming that everything that I hear from the person that I'm interviewing is going to be reliable.
Let's talk about that. Now, did you generate a 69-page report that covers what you did and your opinions in this case?
It was actually a 128-page report. It was 69 pages of a summary of my examination, and then I had appendices that were relevant to my examination, that some of which I relied on.
Okay, let's then start talking about methodology here. Do you remember when you were appointed to conduct the sanity examination of the defendant in this case?
I think that the appointment occurred in April of 2013, is my memory.
Tell us what you did and how you went about doing it leading up to ultimately the decision to interview the defendant and assess him face to face.
Well, the first thing I did is reviewed the court order to make sure I was clear on what I was being asked to do.
That's a great place to start then. Tell us what your understanding of, from the aspect of determining sanity under the laws of Colorado, what it was you were tasked with finding. What's the standard for sanity?
The standard for sanity, as I understand it, is there's multiple prongs to the sanity statute. The first one is, did the defendant have a mental disease or defect? That's really the first question you got to address. What at the time of the commission of the alleged crimes is, at the time of the commission of alleged crimes, the defendant suffer from a mental disease or defect. And then the statute gives you some guidelines about what mental disease or defect means. And rather than paraphrase, I want to be very accurate on it.
Would you tell us, Doctor, if you're going to read something, just make sure you tell us on the record what
Okay,
that is.
I'm reading from CRS section 16.8-101.5, which is the applicable sanity test. And so the sanity statute gives you guidelines about what mental disease or defect includes. And it says it includes only those severely abnormal mental conditions that grossly and demonstrably impair a person's perception or understanding of reality, and that are not attributable to the voluntary ingestion of alcohol or any other psychoactive substance, but does not include an abnormality manifested by only repeated criminal or otherwise antisocial conduct. So to translate that
and I'm
in
sorry to
English-
interrupt, is this the standard then that you went into this evaluation with?
Yes.
Okay.
And then to translate that into English, what it basically means is, in clinical terms, a mental disease or defect generally means that someone had a serious mental disorder. And it excludes what's called an antisocial personality disorder. It also excludes an abnormal mental condition that was caused by the ingestion of alcohol or illicit drugs.
Okay, what were the other prongs that you took into this evaluation with you?
So the first prong is, did the person experience a mental disease or defect at the time of the commission of the alleged acts? Then there's the next prong is, if the answer to that is yes, did that mental disease or defect cause the defendant to not have the capacity to distinguish the difference between right from wrong with respect to the alleged crimes? And that, the capacity to distinguish the difference between right from wrong, there's two prongs of that. There is right from wrong from a legal perspective, meaning did...
May we approach, please?
And while a witness may tell you what his understanding of the legal standard is as he went about completing his sanity examination, in the end, I'm the one responsible for giving the law to you and explaining it to you. And so you are only to follow the instructions of law that I give you. I'm the one who does that. That's my responsibility. Although I think it's appropriate for a witness to talk about his understanding of the legal standard. Does that distinction make sense? All right, and so in terms of Dr. Metzner interpreting the law to you, you should consider that only as his understanding. In terms of the last part of the, or the last exchange, because I've stricken the answer, let me just clarify for you that under Colorado law, the test for insanity is a two-part test. We've talked about this before, and under Colorado law, the questions are, under the issue of insanity, number one, whether the defendant was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act. And when I say wrong there, what that refers to is a moral wrong, as measured by societal standards of morality. And number two, whether the defendant suffered from a condition of mind caused by a mental disease or defect that prevented him from forming a culpable mental state that is an element of a crime charged. And as you know, there are two culpable mental states that are elements of the crimes charged in this case. One is after deliberation and with intent, and the other one is knowingly. So that's the legal standard, and because the prosecution has the burden of proof with respect to each and every element of a crime, of each crime charged, it's the prosecution that has to prove beyond a reasonable doubt that the defendant was not insane at the time of the commission of the act. And that means that the prosecution has to prove both. Number one, that the defendant was not so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act. And number two, that the defendant did not suffer from a condition of mind caused by a mental disease or defect that prevented him from forming a culpable mental state that is an element of a crime charge. They have to prove both of those prongs beyond a reasonable doubt. Everybody understand that? Okay. And when I say they, I'm referring to the people. All right. With that explanation, Mr. Brockler, you may proceed.
Thank you. Doctor, let me do a better job of asking you the question in terms of what your understanding was. And we just went through it with the judge, but was it your understanding that as you went into this evaluation, you were determining whether or not the defendant on the 19th and 20th of July had the capacity to be wrong based on societal standards and morality?
Yes.
And then in addition, determining whether or not, in your opinion, that the defendant in 2012 had the capacity to form the intent to murder after he deliberated on it and to act knowingly with regards to his criminal conduct?
Correct.
Mr. Brockler, you may have forgotten to turn your mic on.
Redo it?
No, that's okay.
Kidding.
We all heard you. There you
There.
go. All right.
When you go into, I hear the difference already. When you go into a process like this, Dr. Metzner, we heard from Dr. Reed, for instance, that he says he goes into it looking for evidence of insanity. Do you take a different approach?
Well, yes, a somewhat different approach, although I don't think the methodology between us is that much different. I look for not only whether someone lacked the capacity, but at the time of the commission of the alleged acts. I also look for whether they had the capacity at the time of the commission of the alleged acts. Because if you had the capacity, then you didn't lack the capacity. Sometimes it's hard to prove that you lack the capacity, but if you can show that the capacity was there, that answers the question. And obviously, if you can show that they lack the capacity, that also answers the question.
With that in mind, tell us how you started to move through this appointment to do this sanity evaluation for the defendant.
Okay. So the first things that I did, and part of the court order was for the parties to provide me with all the discovery. And so I began getting discovery. So, for example, I had one DVD that was only about 1/3 filled, and it had 55,000 pages of discovery on it. Then I got approximately 250 CD DVDs, in which a large part of those DVDs were videos of Mr. Holmes during his incarceration at the Arapahoe County Jail. Then a lot of those DVDs or CDs contained discovery that were on the DVD that had the 55,000 PDF pages. And then some of them had other information, such as all the medical records of all the victims in this case were on those DVDs. So I got all that, and then there's also the CDs and DVDs also had audio tapes of various interviews and 911 calls, etc. And that was a little overwhelming initially to get all that material. And so the next thing that
Doctor, forgive me for interrupting. Have you ever, in these numbers of cases you've talked to us about, have you ever received this much information in advance of a forensic interview of a defendant ever?
Not for a sanity examination, nothing ever even close to that.
And frankly, in terms of the report that you described, have you ever generated a report that big?
No.
Okay. So you have this size of stuff you've described. How did you tackle it?
So what I then next did is I contacted both the public defender's office, the attorneys, public defenders, and the district attorneys, and said I would like to meet with them to talk about the discovery, talk about from their perspectives what are the key issues. So I did that next. I happened to meet with the DAs first because the DAs called me back first. And so I met with the district attorneys, and one of the more useful documents I initially got was a transcript of the preliminary hearing, and which gave me a pretty good summary of the events. And then I asked both the DAs and I also asked the public defenders to highlight for me in this discovery things that I should be sure not to miss, and to hear from what their concerns are. And when I say concerns, what's favorable from their perspective, what's not favorable from their perspective. So I would have that in my mind in preparation for my evaluation.
You did not just rely upon what attorneys told you to do in terms of what to look at, right?
That's quite correct. And then, and included in this massive discovery was past healthcare records, and not just past healthcare records, past, and I know the jury's heard some of this, interviews from the graduate school applications, interviews with school teachers in college and in elementary school. And I then also compiled a list of any mental health clinician who had, at the time prior to my seeing Mr. Holmes, had either treated or evaluated Mr. Holmes.
Why was that important, Doctor? I'm sorry to cut you off.
Well, because they saw him at a time closer to July 20, 2012 than myself. My first interview, which I'll get into in a minute, wasn't until I think it was August 7th of 2013. So it's important to hear the closer to July 20, the more accurate you can get of his mental state at that time. So I decided I wanted to call them all and talk with them. And that included, obviously, Dr. Fenton and Dr. Feinstein. And it included, I think it was about 9 psychiatrists at Denver Health Medical Center where he was treated beginning, I think it was November 12 of 2013.
After this event?
After that event.
I'm sorry, did you mean 2012?
Yes, thank you, 2012. And that was no small feat at that time to contact, it was easy to contact the clinicians. It was difficult initially for them being willing to talk with me because there was all sorts of legal issues. But through the court, that got settled, and I eventually, prior to my first interview with Mr. Holmes, I talked with all the treating clinicians, including Dr. Mosier and Dr. Sather from the Arapahoe County Jail, all the clinicians at Denver Health Medical Center. I also was given permission by the defense to contact Dr. Rachel Gurr, who had performed a psychiatric examination. I also contacted Dr. Robert Hanlon, who was a neuropsychologist who, at the bequest of the defense, had done neuropsychological testing. I also contacted Mr. Holmes' parents and were...
I'm sorry, and I don't mean to cut you off, but I want to ask you, why was it important to you to speak to his parents?
Well, his parents obviously knew him the longest, and should be able to provide a lot of information around his mental state.
Doctor, did you feel like it would have been sufficient for you to just rely upon just all that 50,000 pages of discovery you described and the videos and the pictures without talking to any of the people you talked to?
No, for a number of reasons. For example, there in those 55,000 pages, and just as an aside, it was 55,000 pages that I reviewed as part of my examination. Since I've completed my examination, I've looked at another 40,000 pages of discovery that has subsequently come up. But to answer your question about the 55,000 pages, there are clearly things in there from witness statements and police reports that turned out to be inaccurate. And so that's why you want to follow up on, certainly if there's a particular statement that looks very relevant, to the extent that you can follow up on the reliability of that statement, that's important. And that's why it's helpful to interview the people that I talked about.
When you talk about earlier about the difference between forensic psychiatry dealing with someone and clinical psychiatry dealing with a patient, is this part of that, I guess, pre-interview corroboration that you're looking for to help you figure out where you're going to go with the defendant?
Yes. You learn in forensic psychiatry to take somewhat of a detective approach, meaning you want to make sure the information that you're getting is reliable, and the more sources of information around a particular fact that you get helps ensure helps increase the reliability of that information.
Was there anything else that you did other than what you've told us so far leading up to the interview that you conducted with the defendant?
Well, I just want to highlight in the discovery, and I know that the jury has been exposed to what's been referred to the notebook, for lack of a better word, the journal that Mr. Holmes kept between June and July of 2012. I found that to be a very important piece of information that helped structured my approach to the interview and turned out in my mind to be a very important component of my eventual opinions.
How much time did you spend in terms of hours, and I'm not looking for precision here, Doctor, preparing for the interviews that you conducted with the defendant in August of 2013?
Over 100 hours.
Now, how many times did you go see the defendant to interview him?
I saw Mr. Holmes, I think it's 5 times. Let me just...
And again, you're referring, sir, to either a report?
I'm looking at my report, and it was 4 times. It was August 8, 9, 10, 17 of 2013, and I met with him at the Colorado State Hospital, and I met with him for a total of 25.5 hours.
In terms of deciding how you would do this, the number of days, the amount of time, did you give yourself a cutoff, like, hey, when I reach 25 hours, that's it, I'm done? Or did you say, this is going to go as long as I need it to go?
This was going to go as long as it needed to go.
Did you feel like you were being rushed in any way? Did you cut any corners that you can think of?
Well, I didn't cut any corners. I felt there was a court order that this is when it should be done by, and I'm aware, working with other courts, that if you need an extension, you can get an extension. But I was also aware that there'd been a lot of extensions, and I felt some internal pressure to do this within the time limits that was asked by the court, but that didn't result in me cutting corners or not doing something that I should have done.
And that 25 and a half hours that you talked about, did you feel like that was a full and fair opportunity to conduct the forensic examination you wanted to conduct of the defendant?
Yes.
Okay. Let's talk about a couple things. You talked about where it was. What I want to ask you about is it your practice in your normal not doing sanity evaluation practice to videotape your interviews with either clients or people that you are doing sanity evaluations for?
Okay. It is not my practice. I'll talk specifically about sanity evaluations because clinical evaluations, I would never videotape a clinical evaluation. It has not been my practice to videotape sanity evaluations for a number of reasons, and they include the following. On my computer, I have voice software, which enables me to dictate notes while I'm doing an examination. And it's been extremely hard. Most sanity evaluations that I've done is not at the state hospital, but going to a jail. And it's extremely hard to get any kind of recording device into a jail because they have security reasons for not wanting recording devices in, let alone bringing video cameras and recordings into the jail. And even if you could do that, most jails don't have, logistically, it's not possible to do. You got to make extreme exceptions to get the right room and the right time and all that. Not to mention, it doubles the cost of doing an examination. And I'm not talking about this court, but other courts, you want to be reasonable in what your costs are. So it's never been my practice to videotape sanity evaluations. On this particular evaluation, I determined that to the extent possible, I want to use my usual technique in how I do sanity evaluations, and I don't want to do something that I'm not familiar with. And the other reason I haven't done videotaping is I've had too much experience with technical problems where where you videotape something and it turns out you have the video but you don't have the sound. And so I determined I wasn't going to do a videotaped examination.
It sounds like it was important to you to continue to do what you'd been doing for risk of not putting out your best product.
Correct.
All right. Talk to us a little bit, though, about how you talked about this voice recognition software. How do you make sure that you're getting down the notes that you need from the defendant without, messing up the evaluation, I guess?
So here's my style when I do any kind of forensic evaluation, whether it's a civil evaluation or a sanity evaluation. I've developed over time my own shorthand in which I can read my notes pretty well, certainly for the first 24 hours. And so I will take notes as I'm talking with whoever I'm interviewing. And then periodically, I will stop the interview and I will say to them, I have voice software on my computer. I'm now going to dictate what we just talked about. And I want you to stop me if I say anything inaccurate. So I'll go to my computer and I will use my notes to dictate what we just talked about. And what frequently happens, it's not uncommon for someone to say, I didn't say that, or that's not accurate, and so I'll correct it. It's more common that they don't say that, but they want to expand on something, that I will say something, they want to give me more information. So I'll allow them to give me more information. And so what I do two kinds of things when I'm preparing a report. From this dictation is how I will subsequently do my report. And I now have notes that I can read very clearly, that 3 years from now I can still read very clearly. What I don't put in my report from this dictated notes, I keep those notes so they still may have relevance, and it's much easier to read, and it's legible a year later or 3 years later. So that's how I do in my interview, and that style works for me. If you talk to forensic psychiatrists, you'll hear all different kinds of styles. You heard Dr. Reed's style where he videotapes and doesn't take notes. And then there's other people who take handwritten notes and does the report after the evaluation, after the interview. I just find it's more efficient for me and more accurate if I do it the way that I just described.
I wanted to ask you, I'm sorry to go backwards on you. You talked about the notebook. You talked about speaking with Drs. Fenton and Feinstein at length. How about, was it important for you, and we'll get into why later, but was it important for you to consider the Google chats or G chats between the defendant and his now ex-girlfriend?
Yes. When you later asked me about why in my opinion Mr. Holmes had a delusional belief, it's very strong evidence for me came from the March 25th Gmail chat and the first couple pages of his notebook. But in addition to that, both his notebook and his Gmail chat had significance in my ultimate opinion about whether he met the legal criteria for sanity.
How about the texts with the other girl later in the year from his graduate school?
That was equally important in determining my opinion around his capacity.
Did you end up formulating questions or approaches with the defendant during this examination to address the issues brought up in each of those conversations?
I did.
Your Honor, may I ask logistically, before we move into this next topic, does the court anticipate wanting to take a break now?
Yes, I do. This is a good breaking point. Thank you. Members of the jury, it's almost 10:30, so let's go ahead and take our morning break. Please make sure that you follow all the advisements I've been giving you with respect to your conduct when you're not in the courtroom. Enjoy the break. I'll see you back here in about 20. Thank you. Please be seated, everyone. The record should reflect that the jury has exited the courtroom. And doctor, you may go on break if you wish. Let me just supplement briefly a couple of the rulings I made earlier. The first one is with respect to the reference to bad shot. I think a reasonable inference can be drawn from somebody going to a shooting range, that the person is going to the shooting range to try to improve his aim, to try to get better at shooting in the context, especially in the context of this case. I think then it is natural to ask in a sanity examination, well, did you improve? Did you get better? There are different ways to answer that question. One way is, I don't know, I wasn't paying attention to that. Another way is, no, I didn't get better. I remained a bad shot. That implies that the person is paying attention to whether there was any improvement or not. And I think that's probative of thought process, it's probative of mental state, it's probative of what the person was doing in terms of going to these shooting ranges and what the purpose was, what the intent was, what the plan was, if you will. And when I say intent there in that form, I don't mean, I'm referring to what his intention was in terms of going to the shooting range, what was he trying to accomplish, and then how that relates to the larger, or the goal in the larger scheme of things. And then finally, with respect to homicidal thoughts, I thought more about Dr. Reed's testimony, and again, I think that this is relevant to diagnosis. It is probative of what diagnosis is made. It is probative of what mental illness the defendant may suffer from. My recollection from Dr. Reed's testimony is that there are certain mental illnesses that don't have a cure, and that you can try to provide medications to help in some regard, but they don't cure anything. And so whether someone is having homicidal thoughts now, or continues to have homicidal thoughts now, I think is probative of what diagnosis a doctor may make with respect to that person. So even though we're talking about now, the present, I think it has probative value, a lot of probative value in terms of mental state or possible mental illness back in July. And again, my recollection as I thought more about this is that both sides have asked questions along the lines of the present time and whether this is the human capital belief remains. And I've allowed those questions. Nobody has objected, and I think those questions are quite appropriate because I think they're probative of mental state at the time of the shooting, and I think they're probative of on the issue of sanity and the culpable mental state elements required by the crimes charged. So, all right, with that, let's take our break. I'll see you in 20. The court will be in recess. Thank you.
Well, good morning again. Welcome back to the west side of our 7 News newsroom. I'm Phil Tenser here with Brian Hernandez and Erica Tinsley. We are taking a break now that we've certified Dr. Jeffrey Metzner as an expert, given the jury a couple of instructions about how to treat his testimony, and soon we'll start to hear that. But we won't hear all of it. We learned earlier today, before the jury was even brought into the courtroom, that there are certain elements of this first assigned sanity examination that we won't be hearing about in the course of the trial. At least the jury won't be hearing about it. We heard hints of what it was in a defense objection that was largely sustained. Things like the gunman's discussion about regrets, the homicidal thoughts he apparently stated having had since he was a child, and apathy toward the death penalty, which of course he faces. He has pleaded not guilty by reason of insanity, and that is why this examination that Dr. Metzner completed, and then the second that Dr. Reed completed, we heard about last week, that's why those were both assigned. Of course, the first one was assigned because the first one was redone, and that's why Dr. Reed was assigned, because the first was found to be incomplete. Anyway, Dr. Metzner, however, did reach the same conclusion as Dr. Reed, even though he was called, his work was called incomplete. It was that the gunman is legally sane. Things like homicidal thoughts, regrets about what he'd done, and apathy toward the death penalty certainly seem to me to figure into why that conclusion may have occurred to Dr. Metzner. In the meantime, we have a clip that should take us most of the way through this morning recess that will recap some of these objections and, of course, the judge's decision on them and why we won't hear them, why the jury won't hear them. But it's also got a bit of animated Judge Carlos some more as he criticizes the defense for not bringing their objections up sooner. So we'll play that for you now.
Even if it had been raised on Friday, it would have given me a little time to do some of that, but it's being raised on the morning of the testimony. Minutes before Dr. Metzner takes the stand. Dr. Metzner is here actually in the courtroom just waiting to take the witness stand. And so It's untimely in that sense. It's not untimely in the sense that Dr. Metzner has not testified yet, but I haven't heard of the reason why this wasn't raised earlier in a timely fashion. So that's the first thing. The second thing, in terms of the merits of the request, I'm going to be consistent with my previous rulings with respect to Dr. Reed, and I'm going to try to do my best to be consistent. Again, given the short time that the defense has given me, and given the fact that I don't have time right now to review all these things that I mentioned a moment ago. There were a few things or maybe more than a few things, there were some things that I ordered redacted with respect to Dr. Reed's examination of the defendant at the defendant's request, in an abundance of caution under Rule 403. And with respect to some of them, I could have allowed them, and I specifically found that they were probative and that they were relevant and admissible under Rules 401 and 402. But in an abundance of caution, I kept them out under Rule 403. And some of these things could have been allowed also just to show the type of evaluation that Dr. Reed conducted, not for and not for any other purpose, but for that purpose itself. But in the end, I concluded that there was certain information that I thought I needed to redact in an abundance of caution, and so I ordered that. And I'm going to try to be consistent here. But I want to make sure that I think as my order shows, and I'm referring to my order D-264 small a-3, these were close calls for me, and this I was again in ordering redactions, proceeding in an abundance of caution and trying to be careful in terms of what information might have an undue prejudice for the defendant, or what information could have an inflammatory effect on the jury. And comparing that to the probative value of the information, keeping in mind that frankly all of the questions by Dr. Reed were questions that were asked as part of his examination, and I think theoretically I could have allowed the whole thing without any redactions, because it went to the evaluation that he conducted, whether some of the questions bore fruit or not, and whether some of the questions ended up providing or eliciting answers that he later found to be significant or not. They were still questions that he asked as part of his examination, and the jury, I think, was entitled to know what questions he asked and what type of examination he conducted in order to assess the reliability of his examination and in order to evaluate his opinions. With that being said, the first request is to the defendant's statement that he's a bad shot. I allow that with respect to Dr. Reed. With respect to Dr. Reed's examination, there was an exchange with Dr. Reed about the defendant not getting better. I think the question was, did you get to be a better shot from the beginning to the end? And the defendant responded, no, I stayed a terrible shot. And then he chuckled at that point, and then Dr. Reed asked, stayed a terrible shot? Okay. So that was the exchange that was in question in motion D-264 small a-3. And to the extent that Dr. Reed asked the defendant about this in terms of the defendant's activities at the shooting range in preparation for the shooting at the theater, then my ruling is the same as it was with respect to Dr. Reed, that it's part of that discussion about the defendant going to a shooting range on more than one occasion and practicing. And I think the common sense question is, did you see any improvement in your shooting? Did you, as time went on, based on your activities, was the practice effective for you? And I think it's part of the sanity examination that each of these doctors conducted, each of these court-appointed experts conducted. I mentioned in my order that the defense was not contesting Dr. Reed's inquiry into the defendant's activities at the shooting range in preparation for the shooting at the theater. Instead, the defense was arguing that the defendant's current perception as to whether his aim improved after practicing at the shooting range was irrelevant to his mental state at the time of the crimes charged and was not relied upon by Dr. Reed in his report. And the prosecution responded that the discussion in question was relevant to the defendant's thought process about the crime that he would later commit, the amount of time, the planning, and the preparation that he was putting into it, and that these things are by extension directly related to sanity, to the issue of sanity. And I agreed with the prosecution and therefore denied the request. Same ruling applies here. Now, Dr. Metzner shouldn't just go out of his way to say that. I'm allowing it to the extent that this was part of his examination and that he felt it was something important to inquire about, and then he can explain why he asked about that, or he can explain what significance this had and his opinions. That's how I treated the objection with respect to Dr. Reed, and I'm treating it the same way here. So this isn't an opportunity to gratuitously add, oh, the defendant said that his shot never improved. There has to be some reason for it. And so to the extent Dr. Metzner asked about this because he felt it was an important question to pose to the defendant as part of his examination, and or to the extent that the defendant's answer is of significance in some way to Dr. Metzner's opinions, then I'm allowing it. Number two is the defendant's statement about what occurred inside the theater, and this is objected to on constitutional grounds and also on evidentiary grounds. I plan to give the jury the same limiting instruction that I gave the jury with respect to Dr. Reed, and if Ms. Nelson wishes, I could expand it even further. She said that some of this testimony is more probative of guilt than it is of sanity. If you want, I can explain to the jury when I mention that this evidence, and when I say this evidence, I'm referring to Dr. Metzner's testimony and the defendant's statements to him, is only being admitted for the limited purpose of considering the issues raised by the plea of not guilty by reason of insanity. I can not only explain what I've explained before to the jury, which is that issues related to the plea of not guilty by reason of insanity refer to the capacity to distinguish right from wrong and the capacity to form the culpable mental state, or the culpable mental states that are elements of the crimes charged. But I can add to that I've mentioned to the jury before that each crime charge has elements, and one of those elements is sanity. And so this testimony only goes to that one element of sanity. It doesn't go to any of the other elements. The jury has heard me talk about elements. I talked to them about that in individual voir dire, in general voir dire, and then right before opening statements once we had a jury selected already. So they know about elements. I've explained that concept to them. I specifically told them what elements there are for each type of crime charge in this case. And so if Ms. Nelson, if you would like, I'll give you an opportunity to request that type of instruction. I'm happy to expand on that if you wish. But having said that, I will allow it. These are the defendant's statements in a sanity evaluation are, in my view, among the most important portions of that evaluation. I don't see how an expert can conduct a sanity evaluation without asking the defendant about the crimes charged and what he was thinking as the crimes charged took place or allegedly took place. Nor do I think that an expert can offer expert opinions about sanity without getting into what the defendant said about the crimes charged. To me, this is necessary for an expert to be able to opine on sanity. So the objection is overruled. Number three is the defendant's religious history. And Mr. Brockler said that after the defendant says that he's agnostic, that he then clarified that he was referring to moral relativism. I have previously excluded the defendant's declaration in an exhibit. I think it was one of the either Match.com or AdultFriendFinders.com exhibits where he declared that he was agnostic. And to me, there is some probative value to him saying that he's agnostic, but given what the jury has already heard from Dr. Reed about religion and the defendant's religious beliefs or lack thereof, I don't think allowing information that he's agnostic adds all that much probative value. So I will sustain the objection as to use of the word agnostic. And Dr. Metzner is here in the courtroom. Obviously, he can speak about moral relativism to the extent that the defendant said that that's something that he believed in. He can speak about other things related to religion. I allowed the videotaped interview Dr. Reed did to include some discussion of religion. There was a lot of discussion of religion, but never anything where the defendant just said, I am agnostic. I think the defendant talked to Dr. Reed about how when he was younger, he went to church with his parents. His parents used to have to bribe him, as he put it, to go to Taco Bell afterwards to get him to go to church. His mother was particularly religious, but his father wasn't really into it, and he himself was never really into it. That kind of thing. I think that kind of discussion is okay, but saying that he was agnostic, given the rest of the evidence that has already been introduced and the rest of the discussion on religion that may be introduced, I think is unnecessary and has little probative value. And I'm concerned that someone on the jury who is particularly religious may find that to be upsetting, or may find that to be something that has an inflammatory effect. And so I am keeping it out under Rule 403. Under number four in my list, the next thing I have is the request to exclude the statement by the defendant to Dr. Metzner, in which he says that he continues to have chronic homicidal thinking. And I looked up my order on Dr. Reed, again, order D-264, small a-3, and Ms. Nelson pointed me to page 40. And this was a section on thoughts of hurting people. And although I kept out the information the defense asked me to keep out from Dr. Reed's evaluation related to this topic, one of the reasons I granted the defendant's request is because before the challenged exchange, the defendant had already indicated to Dr. Reed that the shooting did not stop his suicidal or homicidal thinking. That's on page 42. So part of my reasoning was, well, the defense isn't objecting to him saying, the defendant telling Dr. Reed that the shooting didn't stop his suicidal or homicidal thinking. Therefore, the challenge exchange has little probative value because it doesn't add a whole lot. It adds something that's marginal. Same thing as the comment that I was making a moment ago about the agnostic term. And so, same type of ruling here. And by the way, my recollection is similar to Mr. Brockler's, and that is that during Dr. Reed's examination, both sides went into this, not only in terms of what the defendant was like at the time of the shooting and before the shooting, but also what's happened since then. The fact that he's on meds now, the fact that he's been in jail, and he was in jail at the time of the interview, the fact that even now he continues to have this delusional belief. I don't see a whole lot of difference between saying that the shooting didn't stop his suicidal or homicidal thinking and saying that he continues to have chronic homicidal thinking. The word chronic is the only difference, and I'm not sure what unfair prejudice that has. The defense didn't object or didn't ask me to request that specific part of Dr. Reed's examination where the defendant said that the shooting didn't stop his suicidal or homicidal thinking. I think Dr. Reed talked about how the defendant's belief or delusion about human capital continues to exist today. Well, that means that he continues to believe that he has to kill people to increase his self-worth and to avoid committing suicide. I don't see a whole lot of difference between what has already been allowed, what Dr. Metzner apparently said in his report. So that request is denied. The next one is the statement about remorse or regrets about the shooting. And I did say in order D-264 small a-3 that this had probative value and was relevant. But in an abundance of caution, I kept it out on the Rule 403. And so I'm going to do the same thing here. Same type of ruling, so I'm going to be consistent again. And again, this was a close call for me, and someone else would have let it in. I could see it going both ways. I erred on the side of keeping it away from the jury, at least during the guilt phase of the trial. If there happens to be a sentencing hearing, then this may be something that is admissible, but that question isn't before me right now. So to be consistent, that request is granted. The next one is a discussion about Miranda rights, and that request is granted as well. So Dr. Metzner, anything related to Miranda advisements is out. So no comments about how the defendant invoked his Miranda rights or how he asked for a lawyer. No comments about any of that stuff. I think best to try to stay away from any interrogations. And to the extent that counsel wish to ask him questions about any interrogations, they should ask leading questions that stay far from my rulings. And by the way, there is no objection to this particular request, so this request is granted without objection. The people of the state of Colorado versus James, Eagan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. Let's bring the jury in, please. By the way, we have to stop at 12 because one of the jurors, I think, is giving blood at noon, and so she has to leave right at 12. So we'll take our lunch break between 12 and 1:30. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Members of the jury, I want to remind you that the court has admitted the testimony of Dr. Metzner only for a limited purpose. You may consider this testimony only as to the issues raised by the defendant's plea of not guilty by reason of insanity. You shall not consider this evidence for any other purpose. Mr. Brockler, you may resume your direct examination. And Dr. Metzner, I remind you that you're still under oath, okay?
Yes, sir.
All right, thank you. Go ahead.
Thank you, Your Honor. Dr. Metzner, we had left off with sort of getting to the point where we were going to conduct this 25 and a half hours of face-to-face assessment down in Pueblo at the state hospital. Do you recall that?
Yes.
A couple things I want to ask you about. You mentioned that it was important for you to incorporate in the Google chats with the defendant's ex-girlfriend and the texts from the subsequent woman, the grad course. Did you spend time going through the notebook with the defendant?
Yes, I went line by line through the notebook with Mr. Holmes.
And in fact, did you create one of your appendices as part of that 129-page report? Was that a going through line by line with the defendant of the notebook?
Correct.
Now, let's talk in general terms about through the course of the 25 and a half hours, a couple things to get out there. One, was the defendant cooperative with you the whole time that you talked with him?
I would say so, yes.
Now, other than cooperation, did you, and we'll talk about this when we move forward, but did you find some difficulties in getting certain information out of him?
Yes, and it was similar to what you saw in the videotape with Dr. Reed. It was not uncommon to get answers to questions that I don't know, and I would follow up not only in that particular interview where I got a I don't know answer, but in subsequent interviews, similar questions trying to get more information. And sometimes I got more information and sometimes I don't know.
You referenced Dr. Reed's video. If we were going to try to describe for the jury the defendant's affect during the 25 and a half hours that you had with him, was it consistent with what we saw in there?
Yes.
Did you ever see, and I want to describe something for specificity with you, did you ever see the defendant have face red, grimacing like crying, hands tightening, anything like that?
No.
Also, based on your assessment of, I think, subsequent psychological testing, did you have psychological testing done subsequent to your interviews?
Yes, I had both neuropsychological testing and psychological testing done by Dr. Rose Mancuso and Dr. Thomas Gray, who were both psychologists at the Colorado Mental Health Institute at Pueblo.
And you've worked with them before?
Yes.
Okay. Based on that, and based on even your own face-to-face assessments, you don't have any concerns about any issues of malingering on behalf of the defendant?
I do not. I do not think that Mr. Holmes was faking an illness.
Okay. Let's talk now in terms of how we approach answering those questions that are part of this sanity evaluation. You said the first prong that you look at is one involving whether or not there's a certain mental disease or defect. I'm going to ask you, do you look to see if there is a serious mental illness based on how you defined it before?
That's, yes.
Tell us what a serious mental illness is.
Well, a serious mental illness is a mental disorder that's associated, at least intermittently, with psychotic features. And what I mean by psychotic features is psychosis is a type of mental disorder that's associated with someone having a significant impairment in reality testing, to being able to tell the difference between what's real and what's not real. You usually see that impairment via symptoms in one of the 5 following areas. You may see someone who has a delusional belief, and I understand the jury's heard what delusions mean. You can also see someone who has hallucinations, and the most common kinds of hallucinations is auditory hallucinations, meaning that someone hears something, hears somebody, hears a voice that's not really there. So there's a perception without an actual stimulus. You can also get visual hallucinations where you see things that aren't really there. You can also have what's called a thought disorder, and that's usually manifested by disorganized thinking. It can also be manifested by disorganized writing, but a thought disorder. You can also get symptoms, motor abnormalities. And when I talk about motor abnormalities, I'm talking about nonverbal behavior, movements. And you, so for example, in the video that Dr. Reed did, you can see Mr. Holmes doesn't move around a lot, doesn't use his hands a lot for expressions. But some people can be hyperactive and some people can be hypoactive, not very active. And the fifth area that you can see in psychosis is what's called negative symptoms. And again, there's a variety of negative symptoms. They include a paucity, lack of emotional response, which is often referred to as a flatness of affect. You can also see what's called alogia, which means paucity of speech. A person doesn't talk a lot. And there's some thought that that's actually related to what you see in certain neurological conditions that are called aphasia. It's a form of aphasia where there's difficulty with speaking. You can also see what's called, talking about negative symptoms, what's called avolition. And avolition means that someone doesn't have the kind of motivation to do things that they used to have. You can also see what's called anhedonia. And what that means is that they experience much less enjoyment in activities that used to be enjoyable to them. I think I've covered all the negative symptoms. So if you have a psychosis, people who have psychosis are often referred to as being psychotic.
Now, pardon me, if someone has a delusion, are they then diagnosable as being psychotic or have a psychosis?
Yes, by definition, if you have a delusion, you're psychotic.
Now that delusion, does psychiatry, as far as you know, have like a Richter scale for earthquakes? Like they say, oh, that's a class 10 delusion, or oh, that's just a class 1 delusion, or is it like being pregnant? You're it or you're not it?
You're either delusional or you're not. What psychiatry does do, you can classify various delusions. So, for example, it's not uncommon to see paranoid delusions. And a paranoid delusion would be characterized by the FBI's out to get me, or the CIA's following me, or Joe Smith is out to kill me. And if all that is inaccurate and fixed in the sense that if you try to confront the person with the reality that this isn't true, then that would meet a paranoid delusional belief. You can also see grandiose delusions. You see some people who say, I'm Jesus Christ. That would be an example of a grandiose delusion. You can also see erotic delusions. That means Jill is in love with me, and she's just doesn't want to tell me that, but she's in love with me, and there's no basis for that. So they're common delusions. And then you can have a delusion such as Mr. Holmes had that doesn't fit into any one of those categories, but that doesn't make it any less delusional.
Before we get back to defining the specific delusion that you found in this case, let's just give the jury a better sense too of, are there other diagnoses that fit the definition of serious mental illness that are not psychotic or delusional in nature?
Yes. So for example, you could have what's called a major depressive disorder. And that means, major depressive disorder means that you're profoundly depressed and you have a number of biological markers, biological symptoms such as sleep disturbance, weight loss, appetite disturbance, related to your depression. And you can have a depressive disorder with psychotic features or a depressive disorder without psychotic features. But that major depressive disorder is considered a serious mental disorder because it's associated with significant functional impairments, meaning people who have a major depressive disorder frequently have a very hard time getting out of bed. They perform poorly at work. They have memory and concentration problems. That would be an example. Or there's certain kinds of personality disorders in which a small percentage of those personality disorders are associated with significant functional impairments and interpersonal or occupational relationships that would meet criteria for serious mental disorder. So a good example actually is, I understand part of Dr. Reed thought that the most likely diagnosis for Mr. Holmes was a schizotypal personality disorder. That would certainly, particularly with the symptoms that Mr. Holmes had, would qualify for a serious mental disorder.
Let's talk a little bit about the delusion, and then we'll try to get into what relevance it has to what we're going to call a differential diagnosis, okay? First off, did you determine that the defendant back on the 19th and 20th of July 2012 had a delusion as you've defined it?
In my opinion, he did.
Tell us what that is.
His delusion was that he would increase his self-worth by killing people. And the delusion was, by killing people, the worth that each of those individuals had would be transferred in some fashion to him that would make him, that would increase his worth. A second part of his thinking was also that if he could increase his worth, he would be less depressed and would feel better.
Talk to us a little bit more about the increasing the self-worth part from the standpoint of, was he talking to you in terms of, was this delusion about self-worth or worth to other people, money in the bank? How did it work?
It would be his self-worth, that he would be worth more in some manner than he was prior to killing someone.
Did he tell you how he quantified that worth? For instance, let's say like a point per person or something else?
Well, he tried to, and I asked him specifically about that, and he talked about that, first of all, different people have different worth. So someone who is a surgeon is likely to be worth more than someone who does janitorial work. And then the worth was, let me be...
And doctor, just for the record, if you're refreshing your memory about what your opinion was based on or what it was, just tell us that, hey, I'm referring to my report, and tell us the page number that you
Okay, I am referring to my report, and I'll tell you the page number shortly. Okay, it's on page 10. And so I tried to get clarification from him regarding how he measured a person's worth. And he stated that included the following factors: the number of people killed, your own perception of what a life is worth, and your contribution to society, both in a meaningful and positive way.
Did he discuss with you the value of children?
Yes, he thought that children were probably worth more because they had a longer life ahead of them.
But not a 1 point, everybody's equal kind of a thing?
Objection leading.
Overruled.
Go ahead, sir.
He did not give me a 1 point, everyone's equal verbally. However, when you try to make sense of his notebook, there's lots of 1 pluses and zeros, but I did not obtain the history that Dr. Reed reported about 1 point per person.
Did he use the phrase human capital with you in discussing this?
Well, yes, because it was actually a leading question for me, because in the notebook it talks about human capital. So one of my questions when I'm going over the notebook, going line by line, what do you mean by human capital?
So this was the delusion that you found that he had.
Yes.
And I know that we've talked about him wanting to feel better as well and thinking that killing people would help him feel better.
Objection. That misstates the testimony of this witness. The testimony of this witness was that if he increased his value, it would alleviate his depression.
All right, sustained. Rephrase your question, please.
Sure. Is a component of the delusion, did it have something to do with this value impacting how he felt about himself?
He was hopeful that if he could increase his self-worth, that would result in him feeling less depressed.
And is it your opinion that but for the defendant believing he could alleviate those feelings and increase his self-worth, he would not have engaged in this behavior?
Yes, it's my opinion that but for the delusion, he would not have acted he would not have done what he did.
Now, if that's true, why isn't that insanity? Why isn't that lack of capacity on the grounds that we've discussed here this morning?
Because the sanity statute is a very narrow definition, which talks about capacity to distinguish the difference between right from wrong, and talks about capacity to form the culpable mental state. It does not talk about, in a general sense, causation. And when I say but for, that's really a causation opinion, but that's not, that doesn't have anything to do with the specific capacity that the statute talks about.
Does it mean that the defendant was not able to make decisions and act on his own will?
What I'm hesitating about is will is a nebulous term.
Okay.
So if you can ask me a different way.
I think when we get through the capacity discussion, that part will make sense.
Okay.
Okay, thank you. There is an aspect of this trying to, talk about whether there's a delusion, and that delusion means psychosis and the serious mental illness to get through the first prong. What it feels like is there's also an effort in satisfying that first prong to try to diagnose whatever it is that people think that the defendant has, both back on the 19th and 20th of July 2012 and now. Is that fair?
Judge, I'm going to object to the form of the question. There's a long narrative where counsel's testifying, essentially, and then a short question at the end. It's an inappropriate form of a question.
I don't know that it was counsel testifying, but I will sustain the objection as to the form of the question. Rephrase the question.
Thank you, Your Honor. Did you attempt to make something called a differential diagnosis about the defendant based on all the information and things that you did in this case?
I did.
First, tell us what a differential diagnosis is.
Okay, so a differential diagnosis is the list of the most likely conditions or diagnoses that would account for a person's presentation. So for example, if you go to your family physician and your chief complaint is that you are short of breath, your chief complaint is that you have a fever and you're short of breath. The doctor's going to take a history from you. He's going to do a physical exam, and then he's going to come up with a differential diagnosis. And he'll say, well, you know, you may have pneumonia, you may have the flu, you may have cancer. These are all possible diagnoses. And then he or she is going to do further testing and will eventually say, well, we know it's not cancer because your MRI was normal. And you narrow it down. That's what the differential diagnosis is. So after my examination, there was a whole bunch of symptoms that I think Mr. Holmes had, and I had to come up with a differential diagnosis. And so I came up with a differential diagnosis, and the differential diagnosis included the following: schizophrenia, what's called schizoaffective disorder, and I won't explain any of these right now. Schizophrenia, schizoaffective disorder, bipolar disorder, schizotypal personality disorder, trichotillomania, and social anxiety disorder. And included, before I came to that differential diagnosis, I ruled out malingering. And when I say I ruled out malingering, what that means is I considered it and I determined he wasn't malingering, so I ruled it out. I also ruled out antisocial personality disorder, and that was pertinent because if you have an antisocial personality disorder and that's related to capacity issues, is excluded by the statute. And I also ruled out what's called a dissociative identity disorder, and that used to be known as multiple personality disorder. So that was my initial differential diagnosis. Then from that differential diagnosis, I said that the most likely diagnoses were schizoaffective disorder, social anxiety disorder, trichotillomania, and that because I diagnosed him as most likely having a schizoaffective disorder, that meant that the schizotypal personality disorder was premorbid to the schizoaffective disorder.
Tell us what premorbid is before you move on.
So when you look at schizoaffective disorder or schizophrenia, there's certain criteria that you have to meet in order to get that diagnosis. One criteria is that you have to exhibit certain signs of psychosis for at least a month. A second criteria is prior to the onset of those psychotic symptoms, you had to exhibit a variety of other symptoms, such as negative symptoms that we talked about, flat affect, sparse speech. And you had to exhibit those symptoms and other impairments for at least 6 months. That's called prodromal. That precedes the actual psychosis. The way schizophrenia and schizoaffective disorder is set up is that prodromal, before you're psychotic, that prodromal period would look like you have schizotypal personality disorder because all those symptoms are consistent with schizotypal. But once you make the diagnosis that he's now psychotic and it's really was the prodromal, the schizotypal personality was just preceding the psychotic break, then you no longer call it schizotypal personality disorder. You say schizotypal personality disorder, parentheses, prodromal. That's all it means.
Which one of those that you've talked about, and there's been a bunch, which one of those that you've talked about automatically means that someone is legally insane in Colorado?
None of those disorders mean automatically that you're legally insane. What you can say, in general, if you're going to meet and I say in general, In general, if you're going to meet criteria for legal insanity in this state, the mental disease or defect you're going to have is going to be a serious mental illness that's associated with psychotic features. However, the vast majority, because the definition is so narrow around the capacity, the vast majority.
Judge, I'm going to be objecting to what other cases, the results in other cases might be.
Overruled.
Go ahead, sir. Keep going.
In general, let me just start over to get my thoughts correct. If you're going to meet legal criteria for insanity in this state, you're most likely to have a serious mental illness that is associated with psychotic features. The vast majority of people who have a serious mental illness associated with psychotic features don't meet criteria for legal insanity because the definition of legal insanity is so narrow.
All right. Is in part what we're talking about the difference between a diagnosis, a label, and how whatever that is affects somebody's function?
That's correct. And that's why, from my perspective, it doesn't make a difference whether the mental disease or defect is schizophrenia or schizoaffective disorder or schizotypal, because none of those disorders are either more likely or less likely to meet legal insanity. He clearly, Mr. Holmes meets the prong of having a mental disease or defect. The next step is looking at function. As a result of those symptoms, of whatever you want to call that illness, did it result in him lacking the capacity to distinguish the difference between right from wrong, or lacking the capacity to form the culpable mental state? That is that's the issue.
Before we get into that next issue of how we are measuring function/capacity, what you relied upon, I want to ask you, within that serious mental illness label that makes the mental disease and defect prong that you talked about, is each one of these potential diagnoses, is there also, a spectrum in terms of some people with schizotypal personality disorder are really much worse off than other people that have schizotypal personality disorder? Or does it affect everybody the exact same way?
No, it doesn't affect everyone the same way. And the easy analogy is look at people with diabetes. Some people with diabetes do very well with anti-diabetic 1,800 calorie diet, and they control their diabetes. Other people with diabetes, diet alone doesn't help. They got to take insulin. And then other people who are on a diet, taking insulin, periodically need to get hospitalized. So there's a severity. There's a severity within the diagnosis, but with a given individual, someone could have a chronic mental illness and they're not psychotic all the time. And so there's times when they're clinically worse than at other times.
Let's move now to talking about the function, the capacity part. And I want to talk with you first about what you considered and thought was psychiatrically significant in evaluating the defendant for his capacity to know right from wrong based on societal standards of morality back on the 19th and 20th of July 2012, okay? And was that yes? I'm sorry.
That's a yes.
As part of your evaluation of his capacity to know right from wrong on societal standards of morality, did you include as part of that an analysis of whether he knew he was violating the laws of that society?
I did.
Tell us what it is that helped you make that decision as you went through all of this stuff you've described.
Well, the easiest part in making that decision is what he told me. And Mr. Holmes was very clear in telling me that he knew that shooting people in a movie theater was not legal. It was against the law. So that's number one. And if you look at his actions, a lot of his actions, you don't need to be a forensic psychiatrist to come to the same conclusion. But I am a forensic psychiatrist, so I will give you examples. So, for example, his planning, the planning of the shooting was well thought out. Particularly, it's well documented in his notebook, and it was thought out in a manner to delay getting caught. And so, for example, the way he bought the ammunition, he bought the ammunition over time to not arouse suspicion from law enforcement or people who sell ammunition.
Now, is that your conclusion, or is that what he told you?
That's what he told me.
Okay, go on. What else did you consider?
He told me that he researched other mass murders.
Like what?
Specifically Columbine, to look at police response time. So already he's telling you that, why else are the police going to respond if you're not doing something that's illegal?
Since we're talking about his review of Columbine, did he have another reason for wanting to research Columbine that he told you regarding ammunition?
Well, he was looking at that both for police response time and the amount of ammunition that was used.
What other factors did you consider at this phase of your analysis?
Well, I think it was March 25 Gmail chat with his ex-girlfriend. He talks about the reason he hadn't done anything at that time is because you get caught and you would go to prison. He also talks about it being evil. And why is it evil? Because it's against the law. Let me just refresh my...
And if you are, just tell us what page of your report you're looking at, sir.
I'm going to go through a series of pages. I'm on page 14 now, and when you look at his profile on Match.com and Adult Friend Finder, in each one of them, there's a dating headline that asks, "Will you visit me in prison?"
And is it your understanding from the review of the discovery that that was posted before he mails this notebook to Dr. Fenton?
Yes.
Can I ask you about, you mentioned the diversion part of this thing to try to delay being apprehended. Was there something about his apartment specifically that dealt with that?
Yes, and thank you for reminding me that. Part of what he did, and I know the jury's heard testimony about it, so I will make it quick, is that he set up some incendiary devices in his apartment with the hope that if it worked, the police would be diverted to his apartment prior and would delay the response to the theater. And again, it goes knowing that the police were going to get involved. And why are the police going to get involved? Because it's illegal.
Further than that, why did he tell you that he wanted to delay the police becoming involved?
So that he could kill more people, which would increase his worth.
And when you talk to him, this is a slight step to the side on this. When you talk to him about this interest in killing people, this goal of killing people, did he ever tell you when he was carrying this out, that he thought he would wound some, but did not know he would kill.
No,
Sounds like to the contrary.
correct.
Was it, I mean, how important is it in considering his capacity to evaluate the apartment and to understand not only what he did, but why he did it?
That was just another piece of evidence in my capacity assessment.
How about the text conversations over a period of time with the other woman from the graduate school after he'd broken up with his ex-girlfriend?
Well, yes, this is, I believe, it was either July 6th, 7th, or 8th. There's some confusion about the exact date. But that was the text, and I won't refer to her as his other girlfriend, but it was another student, in which this is the bad news bears text. And he basically said, stay away from me, the floodgates have opened. And he also, when I questioned him further about why she should stay away from him, is he indicated that it would be bad for her to have media exposure, meaning after this happened, he was aware that there was going to be media exposure.
And not positive media exposure.
Correct.
How about the fact that he made the purchases he did in terms of body armor and other protection?
That's also is consistent with knowing what he's doing is wrong, because he's anticipating people aren't going to just let him do that without taking some action. So he was trying to protect himself, and the people who would be taking action would be law enforcement.
Now, I should have asked you this before, because it doesn't sound like the evidence fits in little compartments. Could some of the stuff you're talking about now, we revisit this when we talk about the capacity to form the intent to murder after deliberation and to act knowingly?
Yes.
Okay, just so I got that on the record. In terms of further exploring this capacity to know right from wrong based on societal standards of morality, did you also consider things beyond just his acknowledgement or the evidence that he knew it was illegal?
Yes.
Tell us about that.
Well, what you can see with people who have delusional beliefs is someone with a delusional belief, there are certain delusions where they clearly know what they're doing is against the law, but believe they lose the capacity to recognize morality from a societal perspective. And so I had to evaluate, was there evidence that he either lost capacity, or, as I said before, was there evidence that he in fact had capacity to know what societal morality was existing at that time.
Tell us the factors that you found to help you make the decision about his capacity to know this right from wrong.
Okay. So first of all, again, the capacity question is relevant at the time of the commission of the alleged acts. But to the extent that you can show he had that capacity or didn't have that capacity earlier on, that's important information. So you can start with the Gmail chat and the March 25 Gmail chat.
With his ex-girlfriend.
With his ex-girlfriend.
Go ahead.
And that's when he says that he's thinking about doing something evil. And and it gets clarified that what he's thinking about doing that's so evil is killing people, and that it's against the law. That's a good indication that using the term evil is an indication that at that time he had the capacity to distinguish right from wrong from a societal perspective.
What other things about that chat do you think went towards his capacity to know this right from wrong?
There's one other thing besides evil. The other thing is his friend at that time then says, well, why don't you kill Ben and I, who was another friend at that time? And he essentially says he can't do that, and because it would be too personal. And that again is getting into the capacity to recognize societal right from wrong. So Gmail chat is one. I'm going to refer to my report again. And
if it's refreshing your memory about this list of things, then just let us know and tell us the page you're on, sir. If
it is refreshing my memory.
While he's doing that, would counsel please approach for a moment?
Yes, sir.
All right, Mr. Brockler, you may proceed.
Thank you, Your Honor. Did you find it, Doctor?
I did. So the first page is page 6. And again, the context is, and I'm aware that the jury is aware of this phone call, is once he was at the theater and he went out to his car and he got suited up, before he went back, he called the university he called the university, and that was the 9 or 10 second call where there was silence on the other end. And so I asked him about, why did you make that phone call? And the reason he made that phone call is it was this is quotes, his last chance to turn back. I don't know, doubts, I guess. So that's an indication to me that he knew what he was doing was morally wrong. Also, when he was suiting up in the parking lot, he put on headphones. And when I asked him why he put on headphones, he was listening. He had programmed in loud techno music, and he said to me he did that so it wouldn't be personal. And then I questioned him further about what he meant by personal and why he didn't want it to be personal. And this is again page 6. I want to just quote what he told me. So there would not be a connection between me and the victim. I wanted generalized, being a crowd or group of people. Then it would not be like I was actually murdering somebody, if no personal interaction, just random people.
Doctor, did he use the words victim and murdering?
Murdering he used. I don't think, yes, and victim too, yes.
Okay, go on.
So my understanding of that's in many ways similar to what he was saying in the March 25 Gmail chat of why he wouldn't kill his friends, but would kill someone else. It was his psychological attempt to divorce himself from doing something, from considering the morality of that. But it indicates to me that he had the capacity to consider the morality.
Can I back up 1 second? And I want to make sure, I probably screwed this up with you, but when you're talking about the Gmail chats, is that to a woman named Gargi?
Yes.
And then the texts to the subsequent woman, is that to a woman named Hillary?
Yes.
Okay, and those are the two names that apply to those two different
Correct.
pieces of evidence? I got it. All right. You talked about his efforts with the headphones. Were there other efforts that he described to you that were efforts to try to distance himself, and maybe distance is the wrong word, but to prevent him from fully appreciating or seeing what he was doing or hearing what he was doing? I don't know how to put that. And the impersonal part.
Give me a second.
Sure.
Well, there was other things that he did to try to distance himself from considering the morality of that. And so, for example, when I initially questioned him about why he dyed his hair, and it turned out it had nothing to do with the Batman movie. And he initially said he didn't know why he dyed his hair. And he speculated for me that it had to do with separating himself out from the person who did this from the person who's not doing that.
Is that a split personality?
Well, it's not a split personality. It's trying to distance yourself psychologically from doing something such as he did.
Is that an indication of capacity to know right from wrong based on the description that we've had?
I think it is.
How about his statements about killing children?
That was another key issue for me, is once he was arrested and taken to the police station, one of the questions he asked people questioning him was whether he had killed any children. And so I asked him about that. Why did you even ask that question? And the answer was, apparently, in the police station, there was some sign regarding children. I forget the exact title of it, but it reminded him of children. And he was concerned whether he killed children because he thought it was wrong, would not be the right thing to do to kill children.
How about his interactions with Drs. Fenton and Feinstein?
That's another indication that he clearly did not tell them what was going on in his mind in the planning that he had been engaged in.
Why is that significant to an understanding of his capacity?
Well, certainly it goes to knowing that what he was doing was legally wrong. But I think when you think about going to a psychiatrist or a mental health professional, if there's any place that you have a fairly good chance of being able to talk and get a response in a relatively non-judgmental way, that would be the place. And he still chose not to do that.
And he tells you why, right?
Because they would have locked him up, meaning that they would have hospitalized him, which would have prevented him from being able to do this.
Now, over the course of these, and you spoke with Drs. Fenton and Feinstein?
I did.
Over the course of the several appointments that they had with him combined, and I know Dr. Fenton did some sort of, over that 3-month period, did he ever tell them or acknowledge that he'd had a specific target in mind for this mass murder?
No, he did not.
Did he ever tell them, including at the June 11th appointment, that he'd already spent the last month amassing the equipment necessary to pull off this mass murder?
He did not.
Does he instead tell them things in response to questions they ask that make them think that he's not as much a risk or prone to do this?
Objection, leading calls for speculation.
Sustained as to leading, overruled as to speculation.
Doctor, are there questions that they ask him on June the 11th that are efforts to determine certain levels of stability for him about what his plans for the future?
Yes.
Objection, leading.
Overruled.
Yes.
Tell us what it is that he told them.
They asked him about what he was planning to do after dropping out of school. And if I believe he told them that he was going to stay in his apartment for a while. And I think he told him he was going to stay in Denver for a while.
Did he indicate what he was going to do for work or school?
I don't recall.
Dr. Metzner, could you move the microphone closer to you, please?
Yes.
So everybody can hear you. Thank you.
The notebook itself, does it add some more information about what his, I guess, relationship was with these psychiatrists?
Well, not only a relationship with the psychiatrist, but it's another important component of why, in my opinion, he had the capacity to tell the difference between right from wrong. Specifically, I asked him, why did he send this notebook to Dr. Fenton? And his answer was that he wanted to help psychiatrists in the future to understand someone like him to prevent this from happening in the future. And the reason that shows, the reason that's relevant to capacity, if you had lost the capacity to know the difference between right from wrong, that would have meant that what you thought, you didn't think you were doing anything wrong. And if you didn't think that you were doing anything wrong, why would you want to alert psychiatrists in the future to prevent you from doing this?
What else was your opinion about why he mailed that notebook to Dr. Fenton?
I think Mr. Holmes was very angry at Dr. Fenton, and I think he had a general anger towards mental health professionals to begin with, and Dr. Fenton specifically, and for what she didn't do. And what she didn't do, and what Mr. Holmes, one of the reasons Mr. Holmes went to graduate school in neurosciences is for years he felt that something was wrong with him, something that was wrong with his brain. And one of his motivations for going, first of all, studying neurosciences in undergraduate school is to try to figure out what was wrong with his brain. That was one of his motivations, and it's clearly stated in his notebook, and it was clearly stated to me, of going to graduate school to not only find out what's wrong with his brain, but to try to fix it. So that didn't work. One of the reasons for seeing Dr. Fenton is trying to fix his brain, and that didn't work. And so I think he was very angry at her.
When he goes to see mental health, what is his stated reason for wanting to go there?
Well, the stated reason was that he was having significant anxiety during his presentations in graduate school. That was the stated reason. I don't think that was his only reason, because he made it very clear up front that he was having chronic homicidal thinking, and you don't tell someone that you have chronic homicidal thinking unless you want to get some help with that. So I think he wanted some help with that as well.
Doesn't the mere fact that he said he had some kind of homicidal thinking mean that he lacked the capacity to know right from wrong, or is it the opposite?
Objection, leading.
It's an either-or question, overruled.
It's certainly, having homicidal thinking does not mean that you can't tell the difference between right from wrong, and having homicidal thinking doesn't mean that you can tell the difference between right from wrong.
The individual concerns that the defendant details through his notebook, which we've seen, did he share any of those with Dr. Fenton?
Most of them he did not, and I talked with him about that, and that was in large part related to his negative symptoms and his difficulties in communicating, and I say in large part.
Well, you talked about this anger that you perceive that he has towards Dr. Fenton. What was significant, if anything, about the exchange where he wants her to tell him her philosophy of life?
Well, he was angry because she wouldn't tell him his philosophy. But the other place where anger came out, if you look in the notebook, and it's, again, not obvious until you question him about it, but he talks about the mind rapist. And, you know, when I first read his notebook, I had no idea of who the mind rapist was. But the mind rapist was Dr. Fenton, the psychiatrist. And there's nothing endearing about referring to another person as a mind rapist. It's pretty angry.
I should go back on this one other follow-up question on the homicidal thinking. The fact that he had a concern, or stated that he had a concern about these thoughts, does that have an impact on your evaluation of capacity to know right from wrong?
Yes, and it's another indication that he had the capacity to know the difference between right from wrong, because the homicidal thinking, I think, was disturbing to him.
Tell us, in terms of, was there anything else, by the way, that you thought was psychiatrically significant that you keyed on in terms of evaluating the defendant's capacity to know right from wrong based on societal standards of morality?
The last one would be his actions immediately after the shooting. You know, he just didn't drive away. He knew that he was going to be arrested. And so if he didn't have the capacity to know the difference between right from wrong, there would be no reason to be hanging around. Yeah, you did what you needed to do and you leave, and that's not what happened.
Let's talk about that. You explored with the defendant, one, did he take any steps to put himself in a position to escape?
As part of his planning, yes.
What was that?
I think it's called the Road Stars. And he brought Road Stars with him. And the reason you would bring Road Stars is if you were thinking about escaping.
And didn't he, in fact, tell you how he would use them?
I don't think that he told me about how he would use them. I think what he told me when I asked about that, his question was, I don't know.
Okay. And you don't remember writing in there anything about if he got into a chase?
Let me just refer to my report.
Please do, sir. If I'm wrong, forgive me.
I think that's my language and not his.
Thank you for clarifying that. Thank you. You did talk with him, though, about his thoughts when he came outside the theater after shooting. Is that right?
Correct.
Well, tell us, why did he stay there? Why didn't he try to escape and use those Road Stars?
Well, he did an assessment when he came out of the theater, and when he came out of the theater, he already saw police, and he assessed that trying to drive away in all his body armor wasn't going to work, and that trying to escape wasn't going to work, and that's why he removed his guns and just stayed there and was pretty passive during the arrest process.
When you say he already saw police, did he give you something to tell you how he assessed how many police were there? And I don't mean numbers. I mean, did he tell you he felt like he was outnumbered?
He assessed that that there were enough there that he wasn't going to get away.
And in terms of the options available to him, was this the best one as he assessed it?
Objection calls for speculation.
You cannot speculate. If you can answer the question based on what the defendant said to you, then you can answer it. Otherwise, it would call for speculation.
It was the best from his perspective if he wanted to stay alive.
Why did he tell you he put his weapon down?
So that he wouldn't be shot.
How about his taking Vicodin before he left for this mass murder?
That's another factor in my capacity assessment. I asked him why he took Vicodin, and he was preparing for the possibility that he would get shot or injured during the shooting, and by having Vicodin on board, it would decrease the amount of pain that he would experience under such circumstances.
Can you talk to us, if you would, about the role of, and we've seen this word a bunch and heard it a bunch, of purpose and having a purpose in life for the defendant and how it impacted his thought process going into July the 19th, 20th of 2012?
Yes, I guess that gets into the symptomatology of his psychosis. And part of my assessment, based on information I got from Mr. Holmes directly and from in his notebook, I think Mr. Holmes had a significant depressive component to his psychosis, that he was very depressed. And in his notebook, he lists a number of symptoms of his depression. But for example, information that I got from him independent of his notebook is that he had what's called vegetative symptoms of depression. He was having appetite disturbance, sleep disturbance, feeling depressed. And part of his depression also was feeling like he lost his purpose in life. And so, for example, it was clear that he wasn't going to make it in graduate school. It was clear that, and as related to that, is that his brain wasn't going to be fixed as he hoped his brain was going to be fixed. He had lost the first really serious relationship that he ever had in his life. And so I think he was floundering. And you see that in his notebook with, the pages of why. I think he was struggling with who he was and what was going to happen to him.
Is there a self-esteem aspect to some of this?
Yes.
There are a list of detailed questions I have for you about specific things that you found and that you didn't find. But before we break here, I want to ask you this. Did you form an opinion of the defendant's capacity to know right from wrong based on societal standards of morality for his conduct on July the 19th and 20th, 2012?
I did.
Tell us what that opinion is.
It was my opinion that despite having a mental disease or defect, that Mr. Holmes had the capacity to tell the difference between right from wrong from a societal standpoint at the time of the commission of the alleged crimes.
How confident are you in that opinion?
I'm extremely confident.
Did you formulate an opinion about the defendant's capacity to form the intent to murder after deliberation and to act knowingly back on the 19th and 20th of July, 2012?
I did.
Tell us what that opinion is.
And again, my opinion was, despite having a mental disease or defect, at the time of the commission of the alleged acts. It's my opinion that Mr. Holmes did have the capacity to form the required culpable mental state for the crimes charged.
How confident are you in that opinion?
Extremely confident.
Those two prongs, all that having been met, did you formulate an opinion as to whether or not James Eagan Holmes was sane when he murdered 12 people and attempted to murder 70 other people, whether he was legally sane on July the 19th and 20th, 2012?
Objection asked and answered. Object to the form of the question is argumentative.
Overruled.
Go ahead, sir. Tell us.
I did, and it's my opinion that Mr. Holmes, at the time of the commission of the alleged acts, met the criteria for legal sanity.
How confident are you in that opinion?
I'm extremely confident.
Your Honor, would now be a good time to break for...
Yes, it's 12 o'clock, members of the jury, and I understand that one of you is donating blood today and needs to leave at 12, and so we're going to go ahead and take our lunch break at this time. Please make sure that you follow all of my advisements with respect to your conduct when you're not in the courtroom during the break. I'll see you back here at 1:30. Enjoy your lunch. Please be seated, everyone. The record should reflect that the jury has exited the courtroom. Is there anything we need to talk about at this time, Mr. Brockler?
Your Honor, for planning purposes for the defense, I think I have maybe 15 minutes, 20 minutes at most when we return before I'll be done with direct examination.
Great, thank you. Mr. King, anything from you? Okay, I'll see you after lunch. The court will be in recess. Thank you.
Taking lunch right at noon on day 27 of the Aurora Theater shooting trial. I'm Marshall Zellinger, Phil Tenser filling in the morning, as well as Mitch Jelniker. We're here with Erica Tinsley and Brian Hernandez following you on Scribble. A bit surprising to me, we're hearing from the first court-appointed psychiatrist, Dr. Jeffrey Metzner, and we're just hearing from the district attorney that he only has about 15 more minutes of direct examination, which would put him at about maybe 2 hours. And we spent 6 days with Dr. William Reed, and the second court-appointed psychiatric examination. But what's important from this witness so far are the multiple times that he has told the jury that despite his analysis of the defendant of having some sort of psychiatric disorder, he feels that he was sane at the time of the shooting, knew the difference from right and wrong. He made different points from his conversations with the defendant of how he made comments and how he sent a notebook to his psychiatrist, Dr. Lynn Fenton, in hopes of educating others to prevent what he had done. And then most recently, the end of the testimony, how he had no escape plan, and how he knew how he had road stars in his car so that there was some form of a possible escape, knowing that what he did might have been right or wrong as well. So very succinct testimony from this first court-appointed psychiatrist, Dr. Metzner. And again, the whole purpose of having a second psychiatric exam was because the prosecution had issues with the first exam, which in the end, we're finding out, came to the conclusions that you would expect a prosecutor to want to hear from a psychiatrist, saying that the defendant was sane at the time of the shooting, even if he had some sort of disorder. And the most compelling testimony that I heard earlier this morning was around 11:11, almost an hour ago, when it was a great question from the DA, because it was something I was thinking of, is can you, if you have one of these disorders, how can you not be insane? And the doctor took us through that there's essentially a moral definition of insanity and a legal definition of insanity, and just because you have one of these disorders does not mean you meet the legal definition of insanity. And we're going to hear from 7 News legal analyst Dan Recht in this lunch hour to talk more about that aspect of insanity, what we're learning from this witness, the only witness we've heard from today. And you heard earlier this morning, before he took the stand, there was a bit of a 45-minute or longer delay from starting court, one because a juror had not arrived yet, but that was rendered moot when there were some arguments between both sides. Again, the defense trying to bring up to the judge some concerns they have for this doctor's testimony. What was interesting about what they were arguing is that it was either duplicative of what we have already heard from the Dr. William Reed, or cumulative, as they would call it, or that it was something that they didn't want him to bring up. But even though that Dr. William Reed had referenced something, at one point Kristen Nelson even admitted, oh, well, it was something that Dr. Reed said, but we missed that, but that shouldn't stop us from being able to object to it at this point. We have 7 News legal analyst Dan Recht with us at the lunch hour. And Dan, clearly the part that stuck out to me is this reference that that the district attorney directly asked, how can you have one of these psychiatric disorders and not be automatically insane? So let me ask you from that standpoint, because there is a legal definition of insanity. I was curious about this at that moment. Okay, we've defined some sort of disorder with someone. Why is that not insanity?
Well, in Colorado, insanity is defined by statute, very specific language, of being incapable of distinguishing right from wrong. So the argument of the prosecution here is, even though Holmes was mentally ill, and even if he was suffering from one of these things that Dr. Metzner said he was suffering from, he could still distinguish right from wrong. He was capable of distinguishing right from wrong when he was pulling the trigger in the theater, and hence, under the definition, he was sane.
And Dan Recht, just as we had with David Beller last week, we hear you perfectly. At times there are some hits in the video, just to warn our viewers, but we can hear everything that you're saying. Dan, a legal definition of insanity goes back for quite some time, I'm sure, but there's clearly the moral definition versus a legal definition. And what can you tell me, how can you educate me on what goes into legally finding someone insane versus me just, observing someone and saying, oh yeah, that person's got to be insane?
Well, I mean, you have to start with the definition that I just gave you. But beyond that, there isn't really a litmus test, and that's why we have the battle of experts that we're going to see in this case. You know, the prosecution has put on 2 experts that say Holmes was mentally ill, Holmes was suffering from delusions, but nevertheless, he was capable of distinguishing right from wrong and hence was sane. The defense, later in the trial, we know as an expert, a well-respected Ivy League expert from a medical school in the Ivy League that says that he was mentally ill, that he was having delusions, and he was insane because he could not distinguish right from wrong. And so the jury's going to have to scratch their head and decide what they believe, and if the prosecution has proved to them beyond a reasonable doubt that Holmes was sane when he was pulling that trigger, because, of course, otherwise they have to say that the prosecution hasn't proved their case and that he was insane.
Let's talk a little bit about timing then. You brought up this other doctor that we'll hear from the defense, and we know they had 2 legal experts interview the defendant, both based on the opening statements of Dan King. They found him to be insane. But I also remember from the opening statement of George Brockler that if you add up the time between these 2 doctors that he is presenting, I believe it's 48 hours, 22 hours of an interview that was recorded that we watched with Dr. William Reed, 25 and a half hours we just found out today. So rounding up 48 hours for this court-appointed psychiatrist interviews. And then if what we heard was accurate from the George Brockler about the defense's experts, I believe this Dr. Gurr spent 5 or 6 hours total, was what we heard in the opening statements. Is that significant in terms of making a determination of someone's level of capability and knowing right from wrong?
Well, once again, there's no litmus test here. But keep in mind, Dr. Reed saw James Holmes 2 years after the incident when he was medicated, and it was arguably a very different James Holmes once he was medicated for all of that time. Whereas Dr. Gurr, who is going to testify for the defense, interviewed James Holmes within, I think it was 2 or 3 months after the incident, and so had a much better sense of the person that was in the theater than Dr. Reed did. So there's many factors here, and they cut different ways, and as I said a moment ago, the jury is going to be left with a very difficult task of sort of sorting through these pros and cons and reaching a determination.
Now, I'm going to read between the lines here, because since I know there was a second court-appointed psychiatrist that was requested by the prosecution, clearly there's something that the prosecutors did not like about the first exam, although we just heard it came to the same conclusion that there is some sort of disorder with the defendant, but that he was legally sane at the time of the shooting. We spent 6 days with the second court-appointed psychiatrist, and we just heard the DA say he has about 15 minutes more before he's done with his direct examination, which would put that at about 2 hours. Why are we spending so little time with this first psychiatrist? Is it because the prosecution does not want to get into things that they didn't like about his exam?
Well, it's not clear, but my guess is we're going to see a pretty significant cross-examination of Dr. Metzner, and the defense is going to bring out in cross-examination of Dr. Metzner what it was that the prosecution didn't like about his initial evaluation and diagnosis. So I think we're about to hear that and why it is that they've used him so sparingly. Frankly, my guess is they weren't inclined to call him as a witness at all, but felt compelled to because they had the sense that if they didn't, the defense would. But again, I hear you, and it is a little confusing because in the end, Metzner says he was sane when he was in the theater, even though there's all of these caveats with what Metzner says. So the cross-examination should be very revealing.
Can you take me through any history that you've had with a situation where you need to call someone to the stand, but you're very wary of how much you get into something and how that's coached? Because with this being a court-appointed witness, essentially, we've seen the prosecution whisper to witnesses to let them know what they can and can't say based on objections. But when you're dealing with someone that's not necessarily on your side and you call them to the stand anyways, can you reflect back on one of your cases of how you go about it to walk that fine line?
Sure, but keep in mind this happens more often to the prosecution than to the defense. See, because the prosecution has the burden of proof, and so they want to be very careful not to have the jury believe that they are hiding the ball and that they are presenting all of the evidence that can be presented. So the prosecution often feels compelled to call a witness that they'd rather not call because they believe if they don't, the defense will call that witness, or the defense will criticize them in closing for not having called that witness. So this strategic problem occurs for the prosecution much more for the defense. However, it does on occasion happen with the defense, and there is something, if you call a witness and yet the witness becomes a hostile witness, you can still, interestingly, cross-examine that witness as if the other side had called the witness. So the rules of evidence get a little complicated when it comes to witnesses that are not cooperating.
And just a couple more points about this specific witness. He made a few
Sure.
references, Dan, to Dr. Reed's testimony. Why is that allowed? If he's, again, an independent witness of the court, why can he reference comparisons to something that didn't impact what he's on the stand for?
Well, if the expert took into consideration things that another expert said and used those things in reaching their opinion, then the rules of evidence say that to allow the witness to testify to that, to the expert witness to testify to it. So once again, I hear you, and it seems unusual, but if it's a piece of the analysis that went into Dr. Metzger's eventual opinion, then he can testify about it.
And the last thing, and it's not just independent of this witness, but often I hear the district attorney warn the witness, if you're going to refer to something, please, for the record, let us know what you're referring to and what page number. So two parts. One, why can a witness refer to something to give their answer? And why does it have to be out loud? I'm looking at such and such and it's on this page.
Well, once again, the rules of evidence require that so that the other side, in this case the defense, knows what he is looking at and can read along in their exhibit and potentially cross-examine the witness about it because they know what page he was referring to. So it's sort of a fairness idea. And the reason you're telling out loud the page, etc., is to allow the other side to look at that very document and to look at that very page.
We're all getting an education, our quick law school education throughout the first 7 weeks of the trial so far. Today is starting week 7. Dan Reck, thanks for the analysis at the lunch hour. We're about 15 minutes or a little more into the lunch hour, which is back to an hour and a half. We broke right at noon because one of the jurors doing a very noble thing by giving blood today, and he or she needed to get out by noon to go make a predetermined appointment. So we'll be back at 1:30 for live court action with about 15 more minutes of testimony, direct examination from George Brockler to Dr. Jeffrey Metzner, who is the first of 2 court-appointed psychiatrists, and his interview of the defendant took place over 4 days in August of 2013, 1 whole year before Dr. William Reed ended up doing his videotaped analysis. and then we'll clearly hear some extensive cross-examining of Dr. Metzner, especially because the prosecution had asked for a second psychiatric exam. The defense will likely try to express to the jury try to get out of Dr. Metzner what concerns the prosecution probably had and how he feels about having his work duplicated by a second psychiatrist. So at 12:18 Denver time, we're going to recap again the people impacted by this shooting, the survivors who have taken the stand over the first 6 weeks of the trial. Actually, the first 5 weeks, because all of last week was dominated by Dr. William Reed. So again, a reminder of who was directly impacted, those injured, retelling and recounting their experiences in the theater, and we will come back and get you back into court on the flip side of this, but some recapping some survivor testimony during the lunch hour on day 27 of the Aurora Theater shooting trial.
Were you at the Century 16 movie theater on July 19th, 2012 in Aurora, Colorado?
I was.
Did that go into the early morning of July 20th, 2012?
It did.
Could you please tell the jury about what you remember about the day of July 19th of 2012, prior to going to the movie theater?
Well, we started off our day a little late, but we were spending time together. I was up here on vacation. We went to the Coors Brewery.
I'm going to stop you for a second. Who's we?
We, Jessica and myself.
Who's Jessica?
Jessica Gowie is my good friend of almost 10 years.
How'd you know Jessica?
I met her in high school back in fall of 2002, and so it began. Gosh, we covered a lot of ground in that time, and great friendship. We dated for a while.
Interject an objection under 403 and 401.
The objection's overruled, but ask your next question, please.
What, were you visiting Jessica from another state?
I was. I'm from Texas.
Right. So when had you arrived to visit Jessica?
I arrived, I believe it was the 17th of July.
Of 2012?
Of 2012, yes.
What do you recall doing with Miss Gowie that day?
That day, as I said, we went to the Coors Brewery. We went on a tour, hung out, and we went back to her residence, and we just played catch-up. We hung out by the pool. We just talked like we hadn't got to talk in a while. She had moved up here the year prior, and
An objection 403.
Sustained.
Did you and Miss Gowie decide to go to the movie theater that day?
we did. After much persuasion, she twisted my arm, essentially. She's like, I never thought I'd have to twist a guy's arm to go see Batman. But any which way, we decided to go see the midnight release, and turns out they were sold out of tickets as soon as we tried to buy them. She checked again, and turns out there was a 12:05 showing. So we bought the tickets and eventually made our way to the theater later on that evening.
Do you recall approximately what time you got to the theater that night?
I'm going to go out on approximately, it was probably about 11:40, 11:45.
What'd you do when you got to the movie theater?
We went through the motions. We got our tickets. She had this obsession with this weird popcorn salt stuff, so she got her fix there. We made our way into the theater, and we just sat down and watched the previews. We were walking in as the auditorium was darkening for the previews.
Were you able to tell how full the movie theater was at that time?
It was packed. It was the midnight release, or the premiere night, so it was a very, very full theater.
Where did you find your seats that night?
It was the 12th row, offset to the right of the auditorium, probably 6 to 8 seats in.
So if you're facing the movie theater screen and this is the movie theater screen, were you closer to the right side of the theater or the left side?
Closer to the right side.
What do you recall of doing prior to the movie starting?
We were watching the previews. I remember there was that new Superman movie that was supposed to be coming out. I remember one of the gentlemen in the audience was wearing a Superman shirt, and he struck his little pose, and we all laughed. We were just, cutting up and having a good time, just getting ready for the movie, getting geared up. And, yeah.
What happened during the movie?
We're probably guesstimating 20, 30 minutes in. And I remember hearing a hissing noise coming from the front right of the theater by the emergency exit. And it drew my attention over there, but being that it was dark, I couldn't see anything. Shortly thereafter, I saw what was making the hissing noise being hurled across the theater, and it was going up theater, probably somewhere a row or so in front of us, but off to the opposite side, to the left side of the theater. And I remember there was this brief pause as soon as it hit the area of people, and then this surreal effect happened. It's like a drop of water hitting, and this wave of people just erupted away from where the object had been thrown. And I was kind of puzzled at first, and then the first shot rang out, and I was like, oh, this is actually happening.
What do you recall after that first shot rang out?
Of course, mass panic, chaos, people screaming. We stood up and we started to make our way to the right to exit our row. We got about 1 seat length down the way, and I realized that people aren't moving out of the way fast enough, and I pushed us to the ground.
When you say us?
Jessica and myself.
All right, what happened when you pushed her to the ground?
It was to get cover. The whole time she was saying, call 911, call 911. She was in a kind of a laying down position for cover. I was kind of in a low profile crawling position.
And could you describe for the jury how your bodies were at that point?
She was laying prone, which is stomach down, just flat on her stomach basically, taking cover, saying call 911. Myself, I was kind of in a curled up ball, but like in a crawling type position.
Were your heads closer to the right aisle or closer to the left aisle?
We're both facing the right exit. So, so at that point, I started to feel the spray of popcorn and soda just all around. I noticed her tone changed entirely, transitioned from call 911 to screaming, and I looked down to see that she'd been shot in her right leg. I believe it was right above the knee. As an EMT, I just finished my course, my training, and my first step from there was just to control the bleeding, so I applied pressure to her gunshot wound. Again, there was a continued spray of popcorn and soda or whatever was going on. I felt, I tried to reach for my phone in my pocket, and given my position, I wasn't able to do that, so I straightened out my leg. I kneeled up a little bit to gain access to my pocket to get my phone, and that was when I sustained a shot to my left buttocks.
Are you hearing anything in the background while all this is going on?
Shots continued to ring out. My perception of time was adrenaline slowed things down a lot, but I do recall shots being fired.
Now, describe for the jury the shots that you heard in the theater that night.
Well, as soon as the first shot rang out, it was just a loud bang, and then a pause, and then a bang, and it just continued. As soon as I saw that Jessie had been shot, my focus transitioned to taking care of her. So the shots continued, and I at that point had gotten out my phone, and I fumbled around to call 911 as soon as I could, as quick as I could, but I got some weird busy message on my phone. And so I stuck it back in my pocket. I had noticed at this point that the screaming had stopped, and Jessie had sustained a shot to the head, in which case brain matter was exposed. It was at that point I crawled a little closer to her, and I prayed over her.
I move to strike 403.
Overruled.
You can continue, Mr. Lowe.
I didn't really know what to do. It just felt right. I just gave her the best send-off I could. And at that point, my medical technician back, the training had kicked in, and we would count a patient like that in the EMS world as a black tag triage, which means they have injuries that are incompatible with life. At that point, I felt that my own survival was my next priority, and I made my way all the way across the aisle that I was in to the small section of seating that was right above the entrance tunnel to the right of the theater. My strategy was that if the shooter had come back, actually, I skipped a part. While I was laying there with Jesse, I looked up theater, the upper rows, and I saw someone stand up and run out, and I heard no shots fired out. So I figured at that point, if I'm going to move, now is my chance. So that's when I made my way to the end of the aisle. I sat there thinking if the shooter did come back, I could throw myself over the wall and land down in the tunnel and scurry off, and hopefully I'd have a chance. But the shooter never returned. Somebody cried out, "Somebody please help, please." And at this point, my leg had started to stiffen up a little bit. My adrenaline was wearing off. I remember hollering out and saying, "Just put pressure on it, help is coming." Not very long after, I saw personnel in uniform enter the auditorium, and one of them worked his way up my aisleway and found me there, and I said, "Are you all right?" And I was like, "I've been shot. I think I'll be okay." And he's like, "All right, stay put." And I was like, "Actually, this gas is really irritating me. Is there any way that I could get out of here?" And he said, "Absolutely, let's get you out." So that particular officer and one other helped carry me out of the theater, and they took me down and out that right front emergency exit, where I remember seeing bullet casings all over the floor. I remember seeing a few banana clips. I saw an assault rifle sitting on the ground as I walked out the emergency exit. They carried me out the door and around the corner and laid me on my stomach.
I'm going to stop you right there for a second, Mr. Locke. Did you know what had happened to Jesse at that point in time?
Your Honor asked and answered.
Sustained.
Did you see Ms. Gowie being carried out of the theater?
I did not.
Your Honor, with this court's permission, I would ask Mr. Locke to join me up at the 3D model.
Yes.
All right, Mr. Locke, if you can grab that cordless microphone that's up at your desk there. All right, and if you could turn that on, good. If you could please show the jury where you and Ms. Gowie were seated and tell them which seat's yours and which seat is hers.
Well, she was to my right. This was the row right here, and we were probably between 6 to 8 seats in, so I suspect it was approximation in this particular area. I was sitting to her left, right there. That's where she was. When shots stood up and started to work our way over, it was at that point I pushed us down, so we were down in this particular aisle, and we'd been shot at, and after she received the head shot, and I suspected that the theater was cleared up a little bit, I made my way directly across right here into this little nook, and I was sitting up against this wall, thinking that I could go over the edge if I needed to. And then I was carried out down the stairs and through the emergency exit out the front.
Could you show the jury where you saw that object being hurled across the theater?
It was a few feet in front of the emergency exit itself.
Were you ever able to see any gunshots?
No, I saw a muzzle flash and silhouette
Could you show the jury where you saw that muzzle flash and silhouette?
in the same area, close by the emergency exit.
Could you describe for the jury where it was that you saw the casings that you remember seeing in the clips?
Pretty much the whole floor, I want to say probably 3 rows or so, all the way to the actual emergency exit itself.
Now, when you exited through there, there's a parking lot that's right behind. Can you show for the jury where you were placed when you got outside the theater?
So there was a wall right here, and I was placed pretty much about right here, up against the wall, laying on my stomach.
All right, I'm going to stop you right there. You can go take your seat. Thank you very much, Mr. Luck. Mr. Locke, without stating what you said or that evening, did you make any phone calls?
Yes, I did.
Where were you when you made those phone calls?
Upon being escorted out of the theater, I called Sandy Phillips, Jessica's mother, and informed her that her daughter had been shot.
Your Honor, hearsay 403, 401.
Sustained.
Did you call anyone else after you called Miss Phillips?
I called my own mother.
So what happened after you were escorted out of the theater to the back?
I remember seeing there was a lady who had a finger shot off. I remember seeing someone laying on the ground close by my...
Interjection with an objection to 403.
I'll allow brief testimony. So you can answer this question. Actually, I think he answered it.
You saw more than just one victim, Your Honor.
All right. Go ahead, ask another question.
After you observed other injured people behind the theater, did you receive any medical attention eventually?
Eventually I did. They tried to take me to the hospital, and I did assist with triage because I felt somebody was in worse condition than myself. I was probably the 3rd or 4th to last person to leave. I remember hearing one of the officers say, "We're out of ambulances."
Your Honor, calls for hearsay.
You cannot talk about what other people said outside the courtroom. Okay? All right. You may proceed.
Were you placed in a vehicle to be transported?
I was.
Please describe for the jury what that vehicle was.
The vehicle that was available was a van. I believe it was a supply van. 4 officers carried me, stomach down, over to this van. They opened the back doors where there was permanent fixed shelving. They realized that wasn't an option. Took me to the side, opened up the 2 side doors, and one of the shelves extended halfway into that. I told them at that point, "I'm partially ambulatory. Set me down. I'll crawl in." And that's exactly what happened. There was a lady who held pressure on my wound the whole trip to the hospital. I was taken to Children's Hospital where I was admitted.
What happened when you got to Children's Hospital?
The same issues getting me in as getting me out. They were trying to figure out how to get me out, and I told them, "Yeah, this leg, don't touch this leg, just pull me out, with the other one, grab me and pull me out." They loaded me onto a stretcher and took me into a trauma room where they assessed my wound. They applied direct pressure and tried to stop the bleeding.
Were you taken into surgery?
I was. They realized that direct pressure was not going to stop the bleed, so they put me into emergency surgery where they performed abdominal surgery. They opened me up and repaired the damaged blood vessels, removed a few of the shrapnel fragments, and sewed me up, and went to recovery from there.
Could you please describe for the jury all the locations you were injured?
So I was shot in the left buttocks. I sustained a shrapnel burn to my right bicep. The shot to the buttocks internally hit the wing of my hip, sending shrapnel throughout my abdomen.
Objection, Your Honor.
Overruled.
You can continue, Mr. Locke.
So, as I said, they patched the blood vessels. There was some nerve damage caused by some of the shrapnel that ultimately caused one of my abdominal muscles to atrophy. I was also informed later on by an x-ray that I had a piece of
Calls for hearsay.
Sustained.
What else did you learn about your injuries?
X-ray showed that I had shrapnel in my shoulder as well.
Do you have any permanent injuries today?
403.
Overruled, it goes to the extent of the nature, character, and extent of the injury consistent with my order C-200.
You can continue, Mr. Locke.
To this day, excluding minor deformities, I have a clicking sensation in my hip every time I take a step. I was informed that 10 to 15 years from now.
Hearsay.
Sustained.
Will you need additional surgeries for your hip in the future?
I will.
And do you have permanent nerve damage?
I do.
Your Honor, if I may approach the witness with what's been marked as People's Exhibit 4556 and 4686.
You may.
First, looking at 4556, do you recognize that photograph?
I do.
Does that photograph fairly and accurately represent the injuries that you sustained from July 20th of 2012?
It is.
Your Honor, at this time I would move for the admission of People's Exhibit 4556 and ask that it be published.
Is there any objection?
Additional objection.
Are these subject to my order amended D-98B?
No, Your Honor.
They're not subject to that order?
No, Your Honor.
Right. Well, is there any objection then at this time?
No.
All right, without objection, P-TR-554, 556, and 4686 are all admitted and may be published.
All right, at this time, if I could please have 4556. All right, could you describe for the jury what we see in this picture?
That is a drain coming out of my left gluteal muscle and stitches closing up the wound.
All right, thank you very much. Now, Mr. Loak, do you recognize the person in photograph 4686? I think it's the next photograph on your...
I do recognize her.
Who is that person?
That's Jessica Gowie.
Have you seen Miss Gowie alive since July 20th of 2012?
I have not.
Were you at the Century 16 movie theater on July 19th of 2012 in Aurora, Colorado?
Yes.
Did that go into the early morning of July 20th of 2012?
Yes.
What can you tell the jury about what you remember about the day of July 19th prior to going to the movie theater that day?
My husband and I were at a friend's house visiting him, and that's pretty much, he lives in Green Valley Ranch, so it's close to the theater.
What's your husband's name?
Marcus.
What's his full name?
Marcus Kazar.
When did you and your husband decide to go to the movie theater?
I would say it was like a couple of hours before, about 8-ish.
What time did you arrive at the theater that evening?
The first time we arrived, we were there to buy tickets, and that was about, I'd say about 11 o'clock.
Did you stay at the movie theater once you got there at 11?
No.
What'd you do?
We went back home and dropped our dog off at the house, and then we went to the theater.
What time was it when you got back to the theater?
It was about 11:45.
What'd you do when you got to the theater?
We bought tickets, kind of scanned the concession stand, and then went into the theater.
Where'd you find seats in the theater?
I would say kind of the top half of the theater.
What'd you do while you were waiting for the movie to start?
One of my favorite things is to kind of scan the room and look at the excitement of the people and like watch the previews and stuff. So we just took our seats and just kind of talked and hung out.
What happened during the movie that night?
I would say about 20 minutes into the movie, a canister went across the screen.
Okay, now, if this is the movie theater screen, could you describe for the jury where the canister went in the theater?
I was from my right to the left of the screen.
What do you recall happening after that?
I heard about 3 shots in the air, like a pow, 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 really bright and about like a yellowish, whitish color.
So did you actually see the flashes from that
Yes,
gunfire?
they were kind of towards the bottom right-hand side of the theater. My
So again, if you're facing the movie theater screen, what do you remember after seeing those flashes?
After the flashes, I remember my husband telling me to get down.
Fiction, hearsay.
Your Honor, again, present sense impression, excited utterance, it's just the effect on the listener.
The objection's overruled. Go ahead.
Thank you, Your Honor. What did your husband say to you?
He told me to get down,
What'd you do?
and I got down.
What do you remember after that?
I remember being on the floor, and just kind of saying, like thinking to myself, what's going on?
Were you scared at that point?
Very scared. I wasn't sure what was going on. I was on the floor with my hands over my head.
Your Honor, if the record can reflect that the witness is putting her hands over her head in a motion like she was protecting her head.
Okay.
I was laying flat on the ground. As I was laying there, I could feel gunshots hitting the front of the seat.
The seat that's in front of you as you're
Yes.
laying down?
And I could just hear screams and moans and gunshots.
What do you recall after that?
Just a lot of screaming. I could smell gunpowder in the air. And then I was just laying there on the ground, listening to the gunshots.
Did the gunshots ever change while you were in the theater? Did they all sound the same to you?
It seemed like it was quicker at the beginning, and then they kind of slowed down. But I could still hear the whizzing of the bullets as they were hitting the seats and going past the seats.
Did you ever see a shooter in the theater that night?
No.
Did you ever see anything other than the canister and those flashes of light that you initially saw?
No.
What do you recall after you're down on the ground hearing gunshots?
I remember a phone call being made on the other side of me as I'm laying down. A phone call to someone's mom.
Objection, Judge. That's to hearsay.
We'll move on, Your Honor.
Let's give the microphone to Mr. King, please. So that
I have the microphone
do you
on,
have
Judge.
one? Okay, great, thank you. The objection is sustained. Please move on.
So after you heard that phone call, what do you recall happening next in the theater?
At one point, it seemed like it went on forever, but someone said,
Objection, hearsay.
Sustained.
All right,
Get
so without, you're all right. So without saying what the people said, what do you recall observing and doing yourself?
after a while, I got up and started to leave the theater.
Right. Your Honor, if I may approach the witness with what's been marked as People's Exhibit 1140.
Yes.
I have no objection to 1140.
All right. Are you moving to admit this exhibit, Ms.
Yes.
Tishmaguire?
Yes, thank you, Your Honor.
All right. Without objection, P-TR-1140 is admitted and may be published.
You could please have 1140. All right, so there's a little mouse in front of you. You could move that around a little bit. Great. Now, if you could use the mouse to describe where you and your husband were seated that evening.
Right here.
Okay, so that M right there, does that stand for Marcus
Yes.
Cooper? Oh,
And the D is for me, Debra.
great. Could you show on that diagram where it was that you saw the flashes of light?
Oops, sorry.
Oh, your fancy techniques up
Oh,
there.
okay.
More advanced than you knew. All right, we can have her bring back that exhibit for you. All right, there you go. We're gonna hire you. Okay, so then, okay, so that's where you saw the flashes in the
Yes.
theater. All right, could you also show the jury where you saw that canister go throughout the theater?
Went from the right side to the left.
All right, now if you could just start to describe your exit path on that diagram for the jury and just stop if there's something that you remember happening.
Okay. We exited towards the left of the theater.
They're having a hard time hearing you, so you can unbend the microphone. You can make it straight and just make sure it faces your mouth and get close to it, okay? Thank you.
We exited towards the left of the theater, or to my left at least, and there were people in the aisles. As I walked towards the aisle, there was a lady that was laying down in the aisle. I walked over her and then I proceeded up the aisle and to the exit right here.
Did your husband leave with you at that point in time?
I was before him, and he was kind of held back in the aisle.
So you guys got separated at that time?
Yes.
Right? What happened when you left the theater?
I ran down the hallway area. I kind of hung back at him, waiting to see if he was coming. And when he came in my visual, he just kind of waved to me, keep going. And I ran out of the theater, and I could see people just sitting outside of the theater, just kind of waiting around. The fire alarm was going off, but I don't remember a sound, just a flash.
When you left the theater, could you still hear gunfire?
No.
Gunfire had stopped by the time you left
Yes.
the theater. Were you ever able to notice anything about your body from that evening?
I remember feeling like warm liquid on me, but I didn't feel any pain. I don't think it was from me. And then I felt something falling on my legs when I was laying down in the aisle, but didn't know what it was.
Did you have any marks on your legs?
A couple of little specks.
Did you need to seek any medical treatment for that?
No.
I have no further questions of this witness. Thank you, Your Honor.
All right. Mr. King, do you have any cross-examination?
I do not, Judge.
All right.
Were you at the Century 16 movie theater on July 19th, 2012?
Yes.
Did that go into the early morning of July 20th, 2012?
Yes.
Now, was that in Aurora, Colorado?
Yes.
What could you tell a jury about what you remember from the day of July 19th prior to going to the movie theater that day?
We had a dog date with one of my buddies.
What's dog day?
No, a dog date.
Okay. A dog date. Okay,
yeah.
What's a dog date?
We just got a dog, and so we were introducing them and stuff. Had dinner with a buddy, and asked him if he wanted to go see a movie with us. He declined, and after there we proceeded home to drop the pup off.
Who's we?
Me and my wife.
Who's your wife?
Daber Thomas Kazar.
What'd you do after you dropped the dog at home?
Proceeded to the movie theater, and then we had bought our tickets before we dropped the dog off, and then came back and went to the theater and sat down.
What theater number did you go into?
Theater 9.
What'd you do when you got into the theater that night?
We did some people watching, and just kind of was looking around and just seeing who was coming in and stuff like that.
Anything unusual happened before the movie started?
No.
What happened during the movie that night?
Could you ask again?
Sure. What do you recall happening during the movie that night?
So we were sitting there, and we were watching the film, and I saw a figure come through the exit door or into the auditorium. A canister had went into the air from the right side over to the left.
That's if you're facing the movie theater screen?
Yes. And
how would you describe that figure for the jury?
it was black. It kind of, to me, it kind of looked like somebody in a costume, if, from just kind of a glance, I guess. And then,
what do you recall happening after that canister went across the theater?
I kind of chuckled a little bit because I thought that this was, this is the final Batman movie, kind of go out with a bang. And so I saw the canister and I kind of laughed, and I was kind of, pretty stoked about it. And then I saw a pistol come and a flash came out, and was kind of, still kind of riding it a little bit, kind of had some excited adrenaline coming, and then chaos kind of broke in front of me. So I hit the floor.
Did you smell anything in the theater at that time?
Not at the point that I hit the ground, no. I just heard a lot of gunshots going off. And then from there, I felt some kind of some stinging, some needle like in my calves. Don't really know what it was. And then from there, I smelled tear gas. And I noticed it was tear gas because of basic training in the Army. So it was a pretty quick reference after that of what it was. And it was pretty distinct of the smell that it was.
So what are you hearing at this point in time when you're on the ground in the theater?
I'm hearing a lot of screaming and stuff, and a lot of shots, and then my wife tells me that.
Objection, Judge. Hearsay.
And you can just talk about what you observed. I apologize, Your Honor.
That's okay. The objection is sustained. Go ahead, Ms. Tishman. Go ahead.
You can just talk about what you observed your wife doing without her saying.
She had her hands on my feet, and then like I said, the shots were just continuing, and so I was pretty much like, the weapon's gonna jam, because the experience of the shooter was not as qualified that I'm used to from the weapons from the military that I've trained in.
So let's tell the jury a little bit about that. So what weapons have you trained in?
Objection. Relevance.
Sustained.
Somebody in the section said, "Let's get out of here," and then we crawled. Everyone crawled to the end of the section, and then we ran up the stairs out the upper exit.
Your Honor, if I may approach the witness with what's been marked as People's Exhibit 1139.
Yes.
Do you recognize that document?
Yeah.
Does it fairly and accurately represent where you recall sitting in the theater on July 20th of 2012?
Yes.
Right, Your Honor, at this time I'd move for the admission of People's Exhibit 1139.
Is there any objection, Mr. King?
No.
Without objection, P-TR-1139 is admitted and may be published.
And Your Honor, actually, at this time I would ask for the court's permission for Mr. Kazar to approach the 3D diagram with me with the cordless microphone.
Okay.
Right, Mr. Kazar, there's a cordless microphone up there. If you could grab that and come meet me down here. Right, now if you could stay up here with me so the jury can see. Could you please show the jury on here where you and your wife were seated that evening?
Probably somewhere in this section, one of these 3 rows.
All right, one of these.
No, probably one of these 2 rows.
Okay, and approximately where in here do you think? We just pick a row approximately.
Probably about right here.
Okay, and where were you and where was your wife?
I was sitting here, and she was sitting here.
And just for the record, that would be Miss Thomas Kazar?
Yes.
Okay.
And this is myself.
You. Okay. And where was it in this diagram that you saw that canister?
Over in the corner over here, and it came up and landed, I'd say somewhere probably around in this section, maybe up in the handicap, just somewhere around here.
Where was it that you saw the figure of the shooter in the theater?
In this section right over here.
Okay, and if you could, if you need to go around a little bit to point exactly where you were?
Probably right in this area.
Okay, is that the only location you saw the shooter in the theater?
Yes.
Okay, and where was the shooter when you saw the shooter with a gun?
He had probably kind of approached a little bit into this section.
Okay. Now could you describe for the jury about your exit path as you left the theater?
So we had crawled out over here and then came up the stairs and then exited through the top area around here.
Did you have to stop at any point as you came up the stairs?
Yes, I got caught up probably maybe right in the next section as I was exiting. A woman had screamed, "Help me, I'm gonna die." So I picked her up and put her on her feet and kind of continued to move because I lost sight of my wife and I needed to maintain visual contact with her.
Okay. And then you guys you exited through this door?
Yes.
Now when you get to the top here, is there a balcony behind here?
Yeah, it's an upper level.
the upper level? And where was it that you were finally able to see your wife?
Right out the exit door. So, yeah, out. She was like probably on the other side of the wall.
All right, you can go up and take your seat again. Thank you very much, Mr. Sorry, and you could turn off that microphone. What happened when you got to the other side of that doorway and you saw your wife again? If you could tell the jury about how'd you got out of the theater that night?
Well, I was in a different mental state at that point. So a lot of that's kind of fuzzy, but I know I did some motionings, and I was just thinking I need to get out of the kill zone. So that was pretty much what I was running off of. I was kind of in a whole different area at that point. I was not in the theater.
You were trying to get yourself to safety.
Yes.
Do you recall having an opportunity afterwards to observe any injuries on your body?
Yeah. When I got to a safe location, I was able to. I saw that my wife's dress was kind of with blood, so panicked a little bit, and I had sustained a little bit of injuries on my calves, and I'm not sure if it was from pellets, maybe the plastic in the seating, or possibly shrapnel. But it got looked at. Everything was fine. So.
And where could you tell the jury where on your legs that was?
It was on the back of my calves.
Is that both your right and left calf?
Yes.
I have no further questions for this witness. Thank you, Your Honor.
Is there any cross-examination, Mr. King?
No, thank you.
Were you at the Century 16 movie theater on July 19th, 2012 in Aurora, Colorado?
Yes.
All right, and did that go into the early morning of July 20th of 2012?
Yes.
Could you please tell the jury about what you remember from the day of July 19th prior to going to the movie theater that night?
Before going to the movies, my best friend, Kaylin, asked me to come over to her house and help babysit Veronica.
Did you guys spend the day with Veronica?
Yeah, we spent the day.
All right. At what point in time did you guys decide to go to the movies?
It was when Veronica's mom, Ashley, and Kaylin's cousin, Jameson, returned to pick Veronica up. And Jameson was the one who suggested going to the movie.
What time did you go to the movie theater that night?
We went to the movies and bought our tickets before, and then we left again to do a few errands. And I don't really know what time that was.
All right. What did you do when you got back to the movie theater that night?
We first, found seats, and then me, Kaylin, and Veronica went to the arcade for a while.
What did you do in the arcade?
We just played some games.
What else did you do while you were waiting for the movie to begin that night?
Me and Kaylin went to the bathroom, and we saw someone we knew from our middle school, so we ran into her.
Do you know the name of that person?
Her name was Peyton Brown.
What else do you remember about that evening?
After that, we went back to the theater and saw someone else we knew, but we didn't know if he knew us, so we kind of tried to get him to recognize us, but he didn't.
Where did you find seats that night in the theater?
It was the third row of the stadium seating, 2 seats in from the right side.
Do you recall the order in which you were seated?
Yeah, it was me, Kaylin, Veronica, Ashley, Jameson.
Your Honor, if I may approach the witness with what's been marked as People's Exhibit 1133.
Yes.
Haley, do you recognize that document?
Yes.
All right. And does that fairly and accurately represent where you were seated in the movie theater on July 20th of 2012?
Yes.
Your Honor, at this time I would ask for the admittance of People's Exhibit 1133.
Is there any objection?
No objection.
Without objection, P-TR-1133 is admitted and may be published.
Thank you. Could I please have 1133? All right, now there's a mouse in front of you, in front of that computer. Let's see if it moves at all. Okay, perfect. All right, if you could point out on your diagram there where exactly you were seated and let the jury know the order of your seats. It's a little sensitive. Yeah. There you go.
Okay, this is where I was sat, and then Kaylin is here. Veronica, Ashley, Jameson.
All right. Thank you very much. How old were you on the night of July 19th, 2012?
13 years old.
All right. What happened during the movie that night, Miss Hensley?
Well, the movie began, and I don't exactly know how far into the movie, but the first thing I remember was seeing a canister of some sort go across the theater diagonally.
Now, if this is a movie theater screen, where did that canister start and where did it land?
It began like in the front corner area, and then it came that way to the back corner.
Right, so is that the right front corner?
Yeah, the right, and then it ended in the left.
What happened what did you do when that canister went across the theater?
It was just kind of confusing. At first, it didn't like register as a danger to me, and I don't think it did to too many other people.
What do you remember after that canister going across the theater?
After that, Kaylin pulled me down to the ground of the theater.
At this point, are you starting to wonder if there's some danger in the theater?
Yeah. At this point, I was a little skeptical.
What do you remember after Kaylin pulled you down?
I remember a distinct smell of smoke or some kind of gas. I wasn't very sure. And then I remember loud popping sounds that sounded like gunshots.
Could you describe for the jury how your bodies were on the ground?
I was partially laying on top of Kaylin, and I was kind of diagonally, so I could see kind of very obscuredly through the seats in front of me.
How much of a space did you have for the seats that were in front of you to see through?
Not very much. I would say that much.
I don't know if the record could reflect that the witness is holding up her hands for about 3 to 4 inches apart.
Okay.
What could you see through the seats at that time?
I could see a portion of the screen and the exit door that was in the front right of the theater.
Did you notice anything near that exit door at the front right of the theater?
I believe that I saw a figure come in through that door, or was standing near the door, I should say.
How would you describe that figure to the jury?
Dressed in all black, really, probably wearing a helmet of some sort.
Anything else that you remember about that figure?
Not too much, no.
Did you see that figure actually shooting anyone?
No.
Okay. Anything else you remember about that figure at all? No. So you're on the ground, and you're partially covering, you're on top of Kaylin.
Yes.
And you're seeing that through the theater. Are you hearing gunfire?
Yes, I am.
Could you describe for the jury what you heard?
It was just loud popping sounds. It was similar to gunshots that you would hear in a movie. I would compare it.
What are you thinking while you're on the ground?
The only thing I was thinking was to get out of the theater.
Why'd you want to do that?
Because I had realized that it was real and people were getting hurt.
Could you tell what was happening to the people that you were with that night?
No, I didn't notice anything until after the gunshots had stopped.
So what point had the gunshot stopped that you remember?
I don't really have much sense of how much time was passing. I don't know, it could have been a while or it could have not been a while. It's hard to say.
Were you on the ground the entire time you heard gunshots?
Yes, I was on the ground.
What did you do after you were on the ground for a while?
Well, the next thing I remember was the gunshots stopping, and I think I remember a figure leaving the theater through the same exit door.
And can you describe what you saw for the jury?
It was pretty much the same, all black, maybe in a helmet. I didn't really see too much.
Did you hear any shooting after that point?
No.
What do you remember after that?
After that, I remember me and Kaylin standing up, and Kaylin reached for my phone to get a hold of the police.
Did you see anything else when you stood up?
I saw, I didn't really see too many people because I imagined they were crouching over people who had been hurt. And I saw a man closer to the front row, gurgling like blood.
Did you see Ashley at that point in time?
No, I did not see Ashley or Veronica at that time.
Did you see Jameson?
I saw Jameson. He was sitting up, and I noticed that his face was bleeding. And I didn't know. I assumed he had been shot.
What happened after the 911 call that you remember?
After the 911 call, the police showed up and escorted me and Kaylin out of the theater.
How'd you get out of the theater that night?
We went out of the exit door in the front right of the theater.
And at this time, with the court's permission, I would ask Ms. Hensley to approach the 3D model and show the jury where she exited the theater.
Yes.
Okay, thank you. And there's a cordless microphone up there, Haley, if you could grab that and turn that on for me too. All right, I'm going to ask you to stay up here with me so we don't block the jury too much. All right, if you could first show the jury where you were seated that night, if you could approximately point to those seats for the jury.
I believe I was here.
Okay, and could you describe for the jury the order in which you were seated?
This would be me, Kaylin, Veronica, Ashley, Jameson.
Right, and where was it that you first saw the figure that you recall?
It was closer to over here by the door.
All right, and it's that the only place that you saw the shooter?
Yes.
All right, and could you describe for the jury where you saw that canister go?
It began right down here, and it came up this way and ended up here.
Could you also describe for the jury where it was that you saw that figure leave the theater?
Again, it was out this exit door here.
All right, and I know it's sometimes hard to estimate distances, but if you could use this kind of courtroom as an example, how far away do you think that figure was from you when you saw them leave the theater?
I would say somewhere behind that pillar, about.
So that's about how far away the shooter was from you?
Yeah.
Now, where were you able to leave the theater?
We came down these stairs and out that door.
All right, thank you. You can go back up to the witness stand and take your seat. What happened after you left the theater?
After we left the theater, me and Kaylin sat on the curb that was outside of the exit door.
How long did you sit on the curb outside?
I don't really have any estimates of time. It was kind of chaotic.
Were you able to leave the theater that evening, the theater parking lot that evening?
Yes, it began. A female officer approached me and Kaylin and escorted us to a parked car and told us to crouch behind it.
Did you do that?
Yes, we did.
Were you eventually able to leave the theater parking lot?
Yes, after we were crouched by the car, we were taken to another car that was running where there was just people, I don't really know. They just looked like civilians. And then a construction worker who was working on the road at the time came over to us and took us across the street to the bus stop where Kaylin's dad, Sean, met up with us.
Did Kaylin's dad take you to your parents?
Yes, Kaylin's dad drove me down the street to where my mom was parked.
What did you notice about your body when you got home?
When I got home, I realized, at first I thought it was just like a spatter of blood on my right shin, but it wouldn't like wash off. So it was shrapnel in my leg.
Did you notice anything else about your body?
I also noticed a gash on my left upper thigh on the back of it.
All right, what does this picture depict?
This is a picture of my left shin where the shrapnel was lodged.
Right, and did you actually physically see the pieces of metal that were in your leg?
Yes, my mom removed some of the shrapnel, and later I got it removed at the hospital as well.
What hospital did you go to?
Aurora South.
What day did you go to the hospital?
July 20th, 2012.
Right, if I could please have 2020. Right, and could you tell the jury about what this picture is?
This is the picture of the gash on the back of my upper left thigh.
Right. Did you also sustain that on July 20th of 2012?
Yes.
I have no further questions. Thank you, Your Honor.
All right, thank you. Do you have any cross-examination, Ms. Spengler?
No. Thank you.
What did you and Mr. Boxer do after you were crawling on the ground?
Someone had yelled to go to the exit at the top of the stairs. And so we had started that way to the left.
And where was the last place you saw the shooter in the theater?
He had disappeared behind the partition of the theater entrance.
And is that on the right side of the theater or the left side of the theater?
On the right side.
And is that the hallway that goes back to the lobby area of the theater?
Yes.
That was the last place that you recall seeing the shooter?
Yes.
So when you, after you heard someone say to go run to that exit, could you still hear shots at that time?
Yes, I could.
Right? Tell the jury about how you were able to get out of the theater.
We had reached the edge of the seats and begun up the stairs. Something had spilled into my shoes, and I lose Dylan's hand at one point. And somebody picked me up and threw me into the seats.
And what did you think was happening at that point in time when you got picked up?
Action relevance.
Overruled.
That means you can answer the question, Ms. Bone.
I wasn't sure that we were going to make it out at that point until Dylan grabbed my hand and we began up the stairs again.
So did Mr. Boxer find you in those other seats you had been thrown into?
Yes.
Could you describe for the jury what happened to your body as you were thrown into those other seats?
My upper back slammed down on the arms of the seat, and I reached out and Dylan was there, and he grabbed my hand and the strap of my purse and pulled me up.
Tell the jury about how you and Mr. Boxer got out of the theater.
We reached the top of the stairs and I tried to dial 911, and it was busy.
Do you recall seeing anything as you were walking up the stairs of the theater?
As I look back up from my phone and hanging up by the trash can and the exit door, somebody had not made it by the trash can.
Objection, Judge.
And did you observe anything else on the floors of the theater that evening?
I kept tripping on the stairs because there were shoes and flip-flops of people that had just left them behind.
Were you and Mr. Boxer able to get out of the theater that evening?
Yes, we were.
What happened when you got outside the theater?
We were looking for any signs of danger in the parking lot. And when we got to our car, we exited the parking lot and passed several police cars on the way out.
Were you able to make it home that evening?
Yes, I was.
Were you able to observe your body when you got home?
We inspected ourselves for injury and found that we were covered in blood that was not our own.
Did you specifically describe what you noticed about your arms?
I had bloody handprints that I suspect is from the person that threw me into the seats.
Did you have any bruises to your legs?
Yes, I did.
I'm going to have you come stand kind of right next to me right here. And if you could point on this diagram where you and Mr. Boxer were seated that evening.
We were sitting right about here.
All right. And where do you recall you sitting approximately? And where was Mr. Boxer?
I was sitting in this left seat, and he was sitting more towards the right.
All right. And could you describe for the jury where the shooter was when you first saw the shooter enter the theater?
He was right about here.
All right. And could you describe for the jury where that canister went that you saw the shooter throw?
The canister came up to about here and rolled down.
Could you describe for the jury where the shooter was when the shooter was holding the shotgun?
He came up about here, parallel with the first row of seats.
All right. And did the shooter move anywhere in the theater while he was using the shotgun? You
Yes.
could show the jury where that was.
He took a few steps up to about the third row.
All right. Where was the shooter when the shooter was using the rifle?
Approximately the same space.
Okay. And could you just show on the diagram for the jury where the shooter walked with the rifle?
Up to about here.
All right. And could you describe for the jury where was the last place that you saw the shooter?
Right about here.
Right. So is this the hallway you were talking about earlier about where you believe the shooter disappeared to?
Yes, it is.
Okay. And could you describe for the jury where it was that you exited the theater?
We exited through this exit here.
Right. And where was it that you got thrown into the chairs?
I'd say between these two rows. I can't remember exactly.
And do you recall where in the seats that you landed? Approximately.
Somewhere within the first seat or so.
Right. Thank you very much, Ms. Bowen. You can take your seat.
Ms. Bowen, the jury has submitted some questions that I have determined are appropriate under the rules of law and other applicable rules of evidence. The first question is, do you remember at what point in your story the shooting stopped completely?
I don't recall.
The next question is, did the shooting resume after the shooter entered the right theater entrance, if you know?
Coming down the stairs of the lobby, there were more sounds of gunshot.
All right, Ms. Tisch-McGuire, any follow-up questions based on those questions?
Yes, Your Honor, briefly. So, Ms. Bowen, when you went out this top exit door at the very top of the theater, is there a balcony area when you get to the top of that area?
Yes, there is.
And then did you have to go downstairs to get to the lobby area?
Yes.
Is that the location where you were when you heard more gunshots?
Yes, it is.
Thank you. No further questions.
Is there a follow-up question, or are there follow-up questions based on those questions, Mr. King?
No, Your Honor.
All right, may this witness be released from her subpoena, Ms. Tisch-McGuire?
Yes, please.
Without objection.
All right, Ms. Bowen, thank you.
What happened during the movie that night?
So from what I remember, about 15 minutes into the movie starting, right after previews, I believe the first shooting scene, people were just engaged in the movie, and then right after we saw I saw something thrown across the movie theater, and it lay out some smoke. The whole movie theater assumed it was just a prank and horseplay, so some people, like myself, I went to my phone and we just assumed it was just horseplay. And then what happened after those few moments, it was kind of a blur. I noticed something was wrong. I looked over to my right to Devin's suits and I pulled him down, and then I believed to get hit by gunfire simultaneously, and I just went to the ground after that.
So when you say you believe, so at that time you thought you were shot and you went to the ground immediately.
Yes.
What did that feel like?
So I felt a lot of punches to my entire abdominal side and my shoulder. And I didn't really realize it. I just kind of pulled Devin to the side to the ground while I got hit. So it was just like a lot of punches towards my side.
What do you remember after that?
I got dazed. I do not remember the immediate events after that, but after a few moments waking up from being dazed, I found myself holding my left abdominal and I was breathing very heavily. I heard a lot of running and screaming, and I recall telling myself, I think I got shot. It was very cold on my left side, so I just assumed I got shot.
Do you remember if you were hearing any gunshots at this time?
No, because all I heard was ringing, just a lot of ringing noises like from an explosion, so I couldn't really hear anything except running and screaming.
What happened after you were holding your left side?
I was just breathing to myself, just trying to hold on, and then a few moments after that I blacked out.
What's the next thing you remember?
The next thing I remember after that, waking up, I woke up in the hospital.
Now, while you were in the movie theater, did you ever see a shooter?
No.
Do you recall seeing anything other than the smoke and hearing any gunshots?
No, ma'am.
What did you learn happened to you when you were at the hospital?
They recalled to me how many days it passed since the night.
How many days was that?
I'm assuming 3 to 5 days.
Before you woke up?
Yes.
What did you learn about your injuries at that time?
The doctor said I sustained multiple gunshot wounds on my abdominal side. I had a bullet pierce my left lung. So to prevent it from collapsing any further, I had a tube inserted to my left lung, and I had a few bullets pierce my left arm.
What had happened to your abdominal region?
They said they did some surgery to remove some pellets, and they removed some of my lower smaller intestine because it was damaged.
So you actually had some of your lower intestine removed?
Yes.
Your Honor, if I may approach the witness with what's been marked as People's Exhibits 4561, 4562, and 2114.
Yes.
Do you recognize the person in those photographs?
Yes.
That person in the photographs you?
Yes.
Do those photographs fairly and accurately depict your injuries that you sustained on July 20th of 2012?
Yes.
Your Honor, at this time I would move for the admission of People's Exhibits 4561, 4562, and 2114.
No objection.
All right, if you could please describe for the jury where you were injured in this photograph.
I got injured within my left lung. One bullet pierced my left lung, so.
All right, if I could have 4562.
It shows my left lung up close and one bullet piercing my left shoulder.
All right, now I could please have 2114.
That shows my left abdominal injury and the surgery they performed at the hospital to remove parts of my damaged smaller intestine.
All right. Now, do you have any lasting injuries today because of those injuries, Mr. Lumba?
Objection. Relevance.
Overruled. It goes to the nature, character, and extent of the injuries.
You can tell the jury about the lasting impacts of your injuries.
Just digestive system. I can't really eat normally, so I have to precaution on what I eat sometimes and how fast I eat. I have some pellets in my body still remaining, so it limits my flexibility with physical activity at times.
Your Honor, with the court's permission, I would ask that Mr. Lumba come up to the front and approach the diagram with me.
Okay.
And Mr. Lumba, if you could grab that cordless microphone that's up there, please, and turn that on and come meet me. All right, if you could please show the jury where you were seated on July 20th of 2012.
We were seated, me and my group of friends were seated like around this area.
All right, and could you remember where you exactly were seated, approximately, and which friend was on either side of you?
On my left side was Louis Duran, my right was Devin Suits, then Nick Drogi, and then Phil Hardgrove.
All right, so let's just say if we pick a row, just approximately, if you could point to the jury about where you were.
Approximately like around right here or right here.
All right, and where was Mr. Duran seated?
Louis Duran was located on my left side.
All right, and can you tell the jury about where you remember falling down and how your body was positioned as you fell down that night?
So just right in front of our seats, the area right in front, I just pulled Devin Suits around this area.
Should reflect that the jury has joined us again. Welcome back, folks. I hope you had a good lunch. Great. At the end of the morning session, the prosecution was still direct examining Dr. Metzner. Doctor, I remind you that you're still under oath, and I want to remind the jury that the court has admitted Dr. Metzner's testimony only for a limited purpose. You may consider this testimony only as to the issues raised by the defendant's plea of not guilty by reason of insanity. You shall not consider this evidence for any other purpose. Mr. Brockler, you may proceed.
Thank you, Your Honor. Doctor, finishing up from where we were this morning, I want to ask you if you could tell us which factors you considered from all the discovery and your examination that go to the capacity to form the intent to murder after deliberation and to act knowingly as regards July 19th and 20th, 2012.
Well, the most obvious ones are the information in the notebook. There's a number of pages where he describes his plan for the movie theater and plans other options other than going to the movie theater. And then as I mentioned before, I questioned him line by line about that. So it was very clear that he had thought about this for some time. And then the knowingly part, the plans from the perspective of carrying out the shooting were realistic, meaning he didn't go out and buy water pistols. He bought an AR-15 and a Glock and a Remington. So that goes to the knowing part. And they're the major obvious factors.
You know, speaking of the 19th and 20th of July, we have heard Dr. Reed use the phrase acutely psychotic. Is there a synonym that you would use to describe if someone was, that they were not acutely psychotic?
Well, I heard the testimony by Dr. Reed with that particular use of acutely psychotic. And the word acute has changed between DSM-4 and DSM-5, but my understanding, I think, of what Dr. Reed was talking about is if you look at...
Judge, I'm going to object as to his understanding of what Dr. Reed was talking about. That calls for speculation.
The objection as to speculation is sustained under Rule 602.
Doctor, let me ask you a different question. Did you find that the defendant was floridly psychotic on the 19th and 20th of July 2012?
Objection, relevance.
Overruled?
Go ahead, sir.
I found that he was psychotic, not that he was floridly psychotic. The distinction that I would make between psychotic and floridly psychotic or acutely psychotic is if you look at his presentation around November 11, 12, 13, when he went to Denver Health Medical Center, he was floridly psychotic. And what I mean by floridly psychotic, again, if you were in the room, you didn't have to be a psychiatrist to say that something was wrong with Mr. Holmes. It would be obvious to a layperson. On July 20th, I think that Mr. Holmes was psychotic because he was delusional. But unless you talk to him, that wouldn't be apparent to you that he was psychotic. Being psychotic or floridly psychotic, they both are very significant impairments and reflection of significant mental illness.
The fact, though, that it's the delusion that we're talking about for the psychosis on the 19th and 20th, that's the one where we're talking about increasing his value?
That's correct.
And despite the determination that he had that delusion on the 19th and 20th, you still adhere to your opinions that you gave us right before lunch?
Yes, and that's in part, when you're psychotic, that doesn't mean that you lose all reasoning ability. And in fact, he was acting on an irrational psychotic notion, but he was very organized in acting on that.
Thank you. I want to ask you about some specific things from the discovery that may touch upon these capacity issues. One is, did the
Do you recall what the defendant told Drs. Fenton and Feinstein was his rationale for not studying for the prelims?
I'm not sure that I recall what he told them. I know what he told me, and I know what he told them, what he was doing instead of studying, but I'm not sure I recall what he told them about why he wasn't studying.
Do you recall from the reports and stuff that were generated that he told them he was prepared enough, he studied this way often, I know what I'm doing, this is no big deal, I've done it before?
That refreshes my memory, yes.
Is that what he told you?
No.
What did he tell you?
What he told me is that most of his life he was trying to please people. And one of the ways he would try to please people and please himself is by doing well in school. And one of the ways he did well in school is he studied a lot for exams because he was fearful of not doing well. And by the time prelims came up, he decided he was going to be his natural self and not study because of what other people expected of him or his fears of what would happen, but to just be himself and take the test without studying.
Did he tell you in terms of his planning how he was able to case out and draw out each of the theaters that we've seen in his notebook?
Yes.
How did he do that?
Well, he told me, I think it was between June and July, I believe he went to the Century 16 Theater 9 or 10 times and looking and going into different theaters and figuring out which would work best. And he eventually picked Theater 9 and 10 because of the layout. And he eventually picked Theater 9 because Theater 10 was being used as overflow for people who couldn't get into Theater 9. And the Theater 10 movie, I think, was beginning at 12:15, at least the previews. And the Theater 9 movie was starting at 12, and that's why he chose Theater 9.
In terms of the planning also, you spoke with him about how he decided to make purchases online versus at stores. Do you recall that?
Yes.
Tell us what he told you.
Well, the purchases at stores was based on convenience, meaning what was close to him. The purchases online were based on price.
Forgive me for not remembering this. I didn't put a check mark by it here. Did I ask you already about his use of an incorrect birth date on adultfriendfinder.com?
You have not.
Let me do that. Did you talk to him about the birth date he chose to put in when he was signing up for adultfriendfinder.com?
Yes.
And what was it?
He used the incorrect birth date because he really didn't, he wanted to be able to not be identifiable through that. And giving a wrong birthday is just one identifier that may make it hard to identify. And I think that was more related to the dating perspective than related to what he was planning to do July 20th.
Did he tell you why he chose to commit this mass murder at a movie theater?
He did, and again, it was in part related to some leading questions from me, which was based on reading his notebook, which clearly said why he chose that. And let me refresh my memory, and I'll give you the page number in a minute. This is pages 4 and 5 of my report. The theaters were chosen as primary targets related to the limited number of exits, and then the following is in quotes. Excellent spatial approach. Most moviegoers take right path and medium size, end quote. So that's was in his notebook.
Did he ever tell you that he chose the movie theater, quote, because he liked movies?
No.
Did he ever tell you that he was seeing shadows in graduate school?
No.
Did he ever tell you that he was experiencing audio hallucinations? Specifically, he'd hear music when he put his head on the pillow?
No.
Did he tell you in relation to an incident we've heard described a couple times now when he was 10, when he used cardboard to make a mark on his wrist? Did you talk with him about that?
I did.
Did he tell you that that was because he was told not to talk by his family and that was his response to that?
I don't think so.
Did he ever tell you that in part he did this because he thought the world was coming to an end?
No.
Did he tell you that he believed that shooting others can rid them of their problems and put them out of their misery?
No.
What's your understanding of why he stopped shooting in the theater in the early morning hours of July 20th, 2012?
My understanding was that the AR-15 became jammed, and he tried to fix it. He wasn't able to fix it, and he left.
Did he ever tell you that he just, independent of the AR-15 jamming, he just decided he'd shot enough people?
No.
Did you discuss with him the reasons that he purchased the weapons that he did and the timing that he did?
I don't think that I discussed with him why he purchased those specific weapons. I discussed with him the timing in the context that I think it was in May of 2012 that he decided that he was going to carry this out.
Did he tell you that he bought any of the weapons related to Hillary's screen at her apartment being slashed?
No.
Did he tell you that he believed that taking action will lead others to do the same?
No.
Did he tell you that those he murdered would be grateful to him for helping them die before the inevitable catastrophe?
No.
Have a moment, Your Honor.
You may.
Doctor, a final question for you. Did he ever tell you anything about, quote, a master power?
No.
I don't have any further questions, Your Honor. Thank you.
All right, thank you. Mr. King, cross-examination? Yes. Take your time.
Afternoon, Doctor.
Good afternoon.
Doctor, I want to talk with you first about some of your experience, and then I'd like to talk with you about your preparations and some of the work you did for your examination in this case, and finally about some of your conclusions and the things that you learned from your interaction with Mr. Holmes, if that's okay with you.
Yes.
Now, you said, sir, that following your graduation from medical school, at the University of Maryland, and what year was that?
1975.
That you then came to Colorado, and that's when you began your residency, is that right?
Correct.
And what did that residency involve?
I graduated medical school early, and so I graduated in January of 75 rather than June of 75. So I did a 6-month medical internship. At that time, medical internships weren't required to do psychiatric residencies, but I wanted to do a medical internship. And then, beginning in July of 1975, I started my psychiatric residency. And you're asking, what does the residency involve?
Yes, sir.
So back then, the residency involved, for the first year of your psychiatric residency, you do predominantly outpatient mental health treatment, which involves both psychotherapy and providing medications when clinically indicated. You also cover, on a rotating basis, there was 15 other residents in my class at that time. You cover the psychiatric emergency room during evening hours. And so that's your first year, and you get lots of supervision from faculty about doing therapy and learning diagnoses. The second year is all inpatient, and I did 6 months of inpatient psychiatric work at what used to be called Denver General Hospital, which is now Denver Medical Health Center. And then I did another 6 months of inpatient psychiatric work at the VA hospital. And during that year, you also continue to do some outpatient therapy, but much less, since you're on the wards for the whole time. After my second year, I talked to you before that I did an optional year at the state hospital. I left the residency for a year and went to the state hospital, and I was on the forensic division. And that's when I've already described providing treatment and evaluations. And for part of that year, I was the chief of psychiatry for the forensic division.
And that was in 1978?
It would have ended in June of 78. And then I came back to finish my last year of residency at the university. I was one of the chief residents in psychiatry at that time. And during that year, as a chief resident, I was responsible for providing, and there were a lot of other people doing what I'm talking about. I wasn't the only one, but I was responsible for teaching medical students through their psychiatric rotation in medical school. I did all the psychiatric consults for liver transplants and kidney transplants that year. And at that time, Colorado was the only place in the country that was doing liver transplants. And I also, as other senior residents would do, I had an emergency room rotation, but rather than being the person who evaluated the people, I would supervise the first year residents who were doing the psychiatric emergency room rotation. And then I continued doing outpatient therapy. And to the extent that I had patients in outpatient therapy who needed to be hospitalized, I would hospitalize them and be responsible for their care while they were hospitalized.
So suffice it to say, during the period of time of your residency and especially that year off when you were at the state hospital in Pueblo, you received a good deal of clinical experience dealing with all kinds of different mental illness, fair to say?
Yes.
And you talked specifically about your stay at the forensic unit at the Colorado State Hospital. And it sounds like to me that was particularly instructive in you in terms of your experience in having contact with psychotic individuals, individuals with serious mental illness. Is that fair to say?
Yes, and I also failed to mention that during your residency, back then, the head of forensic psychiatry at the university was Dr. John McDonald, who was a very well-known forensic psychiatrist. And I received some training that was one of my first introductions to forensic psychiatry was through Dr. McDonald.
And following that, your residency, did you work as a staff psychiatrist at Denver General Hospital, or was that the second part of your residency that you just described?
No. Once I got out of residency, my first year, ever since I've been out of residency, I've been in the private practice of psychiatry. But in addition to the private practice of psychiatry, I've done a number of things. So, for example, my first year out of residency, I took a part-time job as a staff psychiatrist at what was called West Side Mental Health Center. And that was a community mental health center in the west part of Denver that was part of what used to be the Denver General Hospital System, which is now the Denver Medical Health Center. So that was a job that I did for a year.
And following, like you said, following your residency, you've been in private practice, other than these side vocations, if you will, continuously since that point. Is that right?
That's correct.
And that the nature of your practice has changed somewhat over the years. Correct?
It's changed a lot over the years.
I think you said in the 1980s you preliminarily had an inpatient practice with a small outpatient practice as well. Is that right?
Not exactly. Rather than preliminary, you might have meant predominantly. During the 1980s, I had a significant inpatient practice, but I also had an outpatient practice. But when you're starting out in practice, you don't have a lot of patients come to you because they don't know you and you haven't started anything. So most people started out in inpatient psychiatry because the hospitals were always looking for a doctor who did inpatient psychiatry. So they would get people referred who didn't have a doctor, and they went down a list, and if you wanted referrals, they would send you referrals, and that was a way of building up your referral base.
Suffice to say, folks that are inpatient could very often be more seriously ill than the folks you might see just coming in off the street on an outpatient basis.
Not only could be, to be hospitalized psychiatrically, almost by definition, you're sicker, more symptomatic than if you could be treated on an outpatient basis.
Now you talked about the differences between conducting a clinical examination and a forensic examination, correct?
Yes.
And the different approaches that you take and the different considerations that you have to make. Is that right?
Yes.
And you're specifically trained your area of specialty is forensic psychiatry, right?
Yes.
Nevertheless, the fact that you specialize in forensic psychiatry doesn't prevent you from having a clinical practice, does it?
Well, in fact, no, it doesn't. And in fact, if you want, in my opinion, to be a good forensic psychiatrist, it has to be built on, you got to have the clinical background to begin with.
So there's nothing about being a forensic, having a specialty that then precludes you from doing the clinical work or other work as you see fit. You've moved into corrections, for example. Fair to say?
Fair to say.
And in the context of your private practice, it sounds like you have gradually moved away from a more towards a more corrections-oriented practice over time. Is that fair to say?
Yes.
And so now at this point, you said that you have a few patients that you continue to see on an outpatient basis, but the bulk of your work for some time now has been working in a corrections environment. In other words, evaluating prisons and jails, as you said, which might be under court order for proper treatment or of mentally ill individuals.
That's correct.
You are not now, nor have you ever been, a research scientist in the area of psychiatry, have you?
Well, I've done research in the area of psychiatry. I would not, and the research I've done is predominantly clinical research. I'm certainly not a basic scientist, and although I've done research stuff, no, I don't consider myself to be a researcher.
Now, you talked about well, first, you don't have extensive experience with the mass murder cases, do you?
I do not have extensive experience doing a sanity evaluation with people who've done mass murder. I certainly have a lot of experience having talked with people who've done mass murders, but that's, it's a lot different doing this kind of evaluation of 125 hours and talking with someone who's in prison who did mass murder and talking with them for an hour.
Understood. And suffice it to say, mass murder is a rare event as murders go. Fair to say?
That is very fair to say.
And especially when you're talking about events such as this one, where there are a large number of victims who are deceased, that is exceptionally rare, is it not?
Yes.
Almost so rare that there's really very little to compare it to in terms of other cases. Fair to say?
I think it's fair to say that from a scientific basis, comparisons you make are not scientific. They're anecdotal.
Now, in terms of your preparation for this examination, you indicated you received quite a volume of materials, and I think you've outlined those pretty clearly. In addition to the discovery or police reports that you received and the interviews of witnesses and the victims' medical reports, you also received information that related to what I'll call the history of Mr. Holmes. Is that fair to say?
Yes.
You received medical records and psychiatric records, particularly that pertain to members of Mr. Holmes' family.
I did.
You received a social history of Mr. Holmes' family that was created by my office, correct?
Yes.
You received videotape recordings of Mr. Holmes when he was hospitalized, at least one, when he was hospitalized at Denver Health Medical Center in November of 2012.
Yes.
You received interviews, numerous interview reports, in addition to the social history, which contained interview reports. You received interviews of family members, yes?
Yes.
Friends, teachers.
Correct.
Both in elementary school, high school, undergraduate school, and graduate school, correct?
Yes.
Coworkers.
Yes.
A tremendous amount of information leading back in time.
That is accurate.
You also received the treatment records of Mr. Holmes' psychiatric history, being the treatment he received from Drs. Fenton and Feinstein, as well as the treatment records of Mel Lipsey, a social worker that saw Mr. Holmes when he was a child.
Yes.
All of these things are things that you took into consideration, along with the police reports and other discovery that you were presented in forming the bases for your opinions. Is that correct, sir?
Yes.
Now, you saw Mr. Holmes on 4 different occasions for a total of 25 and a half hours, right?
Yes.
And also, he was observed by the hospital staff down at CMHIP and Dr. Pounds, and you're familiar with these folks, are you not?
Yes.
Throughout your private practice, you said that you've maintained a consulting relationship with the state hospital in Pueblo, is that right?
Yes.
And as part of that, you have done other sanity and competency evaluations on different individuals down there, is that right?
Yes.
And you consult with them, is that right?
Correct.
And really the folks that were assigned to this case were really top-notch people, fair to say?
Yes.
Now, in addition to your review of all the materials and your clinical interviews with Mr. Holmes, well, let me ask you first before we move on from the clinical interview aspect. I think you've indicated why it was important to you to get all of the history and the materials that you could before seeing Mr. Holmes. And that was to be prepared to evaluate the statements that he made and to corroborate those statements. Fair to say?
In part, yes.
And in part to give you direction on what might be areas that you should pursue?
Yes, I did not want to do my evaluation and then review the records and find something that could have been important and I don't have the opportunity to ask him about it.
And you saw Mr. Holmes in 2013, is that right?
In August of 2013.
So a little bit more than a year after the date of the offense of July 19, 2012.
Correct.
At that point in time, Mr. Holmes was medicated, was he not?
Yes.
With the antipsychotic medication that he's currently on.
With an antipsychotic and with an antidepressant medication, and yes.
And you have no doubt, do you, sir, that that medication affected the way he presented and affected his responses to your questioning?
I think that medication resulted in him being more organized in responses.
And certainly, it's your testimony that during the offense, and we'll talk a little bit more about the florid or acute psychosis later, but during the period of time preceding and during the shooting in 2012, it's your opinion that Mr. Holmes was psychotic at that point in time.
That is correct.
That his thinking was disorganized, correct?
His thinking was disorganized in the context of delusional thinking. He had other very organized thinking, but
sure.
Believing the delusion, and in that aspect it was disorganized.
And I think you explained that distinction for us pretty clearly, and that is if you're trying to accomplish a shooting, buying a firearm is a logical, goal-oriented move to make, right?
Correct.
But what you're saying is Mr. Holmes engaged in these logical, goal-oriented moves in order to accomplish a larger purpose, which was in fact delusional and illogical, correct?
Correct.
Why is it important to conduct a clinical interview of Mr. Holmes or of anyone that you're doing a sanity evaluation of? Why can't you just read the data and render your opinion based upon what you perceive was going on during the time of the offense?
Well, again, my understanding is the question of the capacities that we've talked about is at the time of the commission of the alleged acts. And so the primary source of finding out, at least beginning to find out, what his state of mind was at the time of the alleged acts is to talk with him. And I also mentioned to you that in the large amount of discovery, there's also things in there that's inaccurate. So if you base things on discovery that may not be accurate, you may not come up with an accurate assessment. And plus the fact, even if all the discovery was accurate, that the kinds of information that you need to do this kind of assessment usually isn't directly in that discovery. There's certain things that you can infer from the discovery, and there's certain things from the discovery that tell you, I ought to ask about this. But so that's the reasons.
Would you have rendered an opinion on sanity or diagnosis if you had not had the opportunity to personally meet and interview Mr. Holmes?
Well, and it depends. And the reason I say it depends, if I had access, for example, to Dr. Reed's videotape evaluation, you can render from an ethical perspective, and this comes back to my discussion about the American Academy of Psychiatry and Law. There's certain ethics that are promulgated by that organization. It is ethical to render an opinion.
And just so I'm clear, and I don't mean to interrupt you, but my question was not is it ethical to do it, but in this case, would you have done that without seeing Mr. Holmes?
And my answer to you is depends on the circumstances. So, for example, if I had access to the discovery, which includes Dr. Reed's video, and I was asked to render an opinion, I would probably have rendered an opinion, but I would have given a disclaimer that it's limited because I didn't personally evaluate Mr. Holmes, and that's a limitation on my opinion, because it's a big difference, even when you have a videotape. It's a big difference of being in the room and interacting with someone than seeing it on videotape.
And it's a big difference being able to ask the questions you want to ask to clarify the issues you want to clarify, as opposed to relying on the questions asked by somebody else. Fair to say?
Correct.
You talked about the different methodologies that can be employed, and you don't normally videotape, and you gave some reasons why you don't do that. Is that right?
Correct.
And you have found in your practice that the methods that you use are accurate and are effective, and that's why you use the methods that you do, correct?
Yes.
And that's why you continue to use them in this case, because they've worked for you in the past over time.
Correct.
So while Dr. Reed may choose to videotape his examination, that doesn't necessarily mean that that is the only valid way to conduct an examination. As we said, different psychiatrists have different practices.
Not only does that mean that, it is the standard of care for forensic psychiatric evaluations does not require videotape examination. Now, if you videotape it, it's certainly within the standard of care, but not videotaping it in no means that it's not within the standard of care.
In addition to the interviews that you did and the materials that you reviewed, you asked Drs. Gray and Mancuso to do some psychological and neuropsychological testing. Is that right?
Yes.
And you wanted to make sure that your clinical opinions that you were forming based upon your review of the materials and based upon your contact with Mr. Holmes were consistent with what the psychological testing revealed. Is that right?
Correct.
You also wanted to see if there was any evidence of malingering that would show up in the subjective testing.
Correct.
And in your experience, the MMPI, for example, which is a psychological test, is that right?
Correct.
Is helpful, can be very helpful in doing that.
Yes.
The questions that you presented to Drs. Gray and Mancuso were, are there any neuropsychological deficits, number one? Is there evidence of serious mental illness, psychosis? Is there evidence of a personality disorder, and is there evidence of malingering? Is that right?
Correct.
Now, to be clear, and I think you said this pretty clearly, but I just want to repeat it because I think it bears repeating. Based upon your analysis of this entire case, your contact with Mr. Holmes, your comparison of Mr. Holmes' statements to the statements to the other doctors, to the evidence that's contained in the record, you are convinced, you have ruled out as part of your diagnosis that Mr. Holmes malingering as an issue, essentially.
That is accurate.
You are confident that Mr. Holmes is not faking a mental illness, correct?
I am.
How confident are you in that opinion?
You know, you're never 100%, but as confident as I can be.
And you're never 100% about any of your conclusions, are you?
That's correct.
Now that conclusion that you made is supported by the psychological and neuropsychological testing that's been done, correct?
Correct.
There's no indication in that testing, either the testing done by the defense or by Drs. Gray and Manguso, that Mr. Holmes is feigning symptoms, correct?
That's correct.
There's no indication that during the course of that testing that he was not putting forth a valid effort in that testing, correct?
Correct.
Now, you talked about the standard with regard to sanity in the state of Colorado, and you talked first about the need to establish the existence of a mental disease or defect, or not, right?
Yes.
After reviewing all of the material and speaking to Mr. Holmes, you've reached a conclusion that Mr. Holmes suffers from a serious psychotic mental illness. Is that right?
A serious mental illness associated with psychotic features, correct.
And to be clear, that he was psychotic, in fact, due to this illness on the date of offense, July 20, 2012.
Correct.
You said the most likely diagnosis is schizoaffective disorder, along with trichotillomania and an anxiety disorder. Is that correct?
Social anxiety disorder.
Now, trichotillomania, what's that?
That's hair pulling. It's a form of an obsessive compulsive disorder, something that he's had for some time. In many ways, it's unrelated to his actions on July 20th, but that's what it is.
And he's, in fact, had this hair pulling disorder as far back as middle school and high school. Is that right?
Correct.
There's some indication in the notebook of him pulling out enough hair that he would cause bald spots in high school. Is that right?
Yes.
Now, just so that we're clear, and I want to talk a little bit about the criteria for schizophrenia and schizoaffective disorder. But it sounds to me like, in terms of the seriousness of the disorder, that schizoaffective disorder is as serious a mental illness as schizophrenia is.
That's correct. It's a little less common than schizophrenia, which is not common to begin with. But yes, and I don't think you can say either one is more serious than the other. They're both serious disorders.
And essentially, and we'll look at the criteria again, but essentially what schizoaffective disorder is schizophrenia plus a mood disorder.
Correct.
And a mood disorder doesn't mean you're in a bad mood. Well, it does, but a really bad mood, fair to say.
Well, a mood disorder, you could either have significant depression, or you could have what's called mania, which is just the opposite of depression, or you could have a mixed state, sometimes mania, sometimes depression.
And what's bipolar depression?
Well, bipolar disorder is a mood disorder in which you have at least one episode of mania. And what I mean by mania is when symptoms of mania include the following: a prolonged euphoric mood, grandiose ideas, meaning you get an idea that you think really makes a lot of sense and turns out to make no sense at all. And so people, for example, will go on spending sprees and can spend thousands of dollars because they had this great idea that if they did this, things would work out, and they ruin themselves financially in a manic state. You can get what's called flight of ideas, in which you get rapid ideas come into your mind so much that it's hard to concentrate. You can get decreased need for sleep. People in a manic mood can be very productive because they're very hyperactive, thinking fast, and really don't need sleep. And so they're the essential features of mania. Depression is feelings of helplessness, worthlessness, hopelessness, feeling very down in the dumps, depressed, having thoughts of wanting to hurt or kill yourself, having a sleep disturbance, trouble going to sleep or staying asleep, losing weight, having no appetite. So if you have a bipolar disorder, you've had to have at least one manic episode. And the reason they call it bipolar, it's not uncommon to have not only manic episodes, but also depressive episodes. And sometimes they can rapidly cycle from a manic episode to a depressive episode, and sometimes you have a manic episode, it goes away, you're doing well for a while, and then you get a depressive episode.
And so someone with that type of understanding that everyone is different and every disease is different, but someone with that type of disorder may commonly be very depressed for a period of time, where they experience those symptoms, a loss of sleep, inability to sleep, appetite, can't move, get out of bed, those kind of things, and then may cycle into a manic phase where it's almost the opposite, where they can't sleep. They experience time moving quickly sometimes. They may feel invincible in a lot of ways. Fair to say?
Fair to say, and let me tell you what I'm not talking about. All of us get depressed, and all of us at times feel very good. So short periods of depression is not a major depressive disorder. And, you know, your team wins a game and you feel great for a day or two. That's not a manic episode. When I talk about a manic episode or a depressive episode, it's also associated with significant functional impairments. And those functional impairments can be at work, at school, or in your relationships, and they're significant.
You saw evidence, talking to Mr. Holmes, of the existence of a major depressive disorder of some kind, correct?
Correct.
He reported in the notebook that he had very little energy at times during the spring of 2012, correct?
Yes.
He reported in the notebook that he couldn't get out of bed for extended period of times, correct?
Correct.
And I think I remember him having to tell himself, "Get up, Bambi, get up," in order to make himself get out of bed to go to class.
Correct.
Mr. King, I'm sorry to interrupt you. We need to take a break for one of the jurors. So let's go ahead and take 20 minutes, folks. Please remember my admonitions during the break. Thank you. Please be seated, everyone. The record should reflect that the jury has exited the courtroom. This is the same juror who was having some issues. I think it was a week ago Friday, and she's indicating in one note, which I'll mark as number 171, juror question number 171. It's a little hot in here. Can we cool it down, please? Thank you. And then in the other note, which I will mark as juror question form number 172, she writes, "I'm going to be sick." And in both, she wrote down her number. So that's why I interrupted you, Mr. King. We'll wait and see when she feels better. I'll keep you updated as much as I can. So we'll take a recess, and then I'll come back out when she's ready to go.
Judge, before
Yes.
you leave, can I approach the bench with counsel? It doesn't have to be on the record.
Oh, okay, yes. All right, is there anything else anybody wants to bring up at this time? No? Okay, well, Ms. Tish McGuire. Okay, all right, we'll be on break then. Doctor, you can be on break as well. Okay, thank you. The court will be in recess. Thank you.
The cross-examination of the first court-appointed psychiatrist to interview the defendant has begun. Surprisingly, only about 2.5 hours of direct examination by District Attorney George Brockler when he spent 6 whole days examining the second court-appointed psychiatrist to record and examine the defendant. So here we have a much shorter basically treatment of this witness without video than we did with the person who had 22 hours of recorded interview. But now you hear the district attorney or the defense attorney Dan King trying to make a point specifically that a diagnosis is just one man's opinion and is not necessarily 100% correct. We don't know how long this break is going to be. They're supposed to be 20 minutes when we take a break. It started around 2:20 Denver time, but you heard the judge say that they took the break because a juror had written a note that they were not feeling well and was going to be sick. So we don't know if we'll be back in 20 minutes or not. But for the time being, we are going to replay some of this morning's direct examination testimony. You'll hear District Attorney George Brockler questioning Dr. Jeffrey Metzner about his exam, which took place August 2013, almost 2 years ago. And this is about the different disorders and the different diagnosis that the doctor had with the defendant and the processes he took to eliminate other potential diagnoses. He also talks about the notebook being sent to Dr. Lynn Fenton, who we heard he had a chance to interview as part of his preparation for talking with the defendant. And he talks about the significance of what that notebook meant to the defendant. So here is a replay of this morning's direct examination between District Attorney George Brockler and court-appointed psychiatrist Dr. Jeffrey Metzner.
So, for example, if you go to your family physician and your chief complaint is that you are short of breath, your chief complaint is that you have a fever and you're short of breath. The doctor's going to take a history from you. He's going to do a physical exam, and then he's going to come up with a differential diagnosis. And he'll say, well, you know, you may have pneumonia, you may have the flu, you may have cancer. These are all possible diagnoses. And then he or she is going to do further testing and will eventually say, well, we know it's not cancer because your MRI was normal. And you narrow it down. That's what the differential diagnosis is. So after my examination, there was a whole bunch of symptoms that I think Mr. Holmes had, and I had to come up with a differential diagnosis. And so I came up with a differential diagnosis, and the differential diagnosis included the following: schizophrenia, what's called schizoaffective disorder, and I won't explain any of these right now. Schizophrenia, schizoaffective disorder, bipolar disorder, schizotypal personality disorder, trichotillomania, and social anxiety disorder. And included, before I came to that differential diagnosis, I ruled out malingering. And when I say I ruled out malingering, what that means is I considered it and I determined he wasn't malingering, so I ruled it out. I also ruled out antisocial personality disorder, and that was pertinent because if you have an antisocial personality disorder and that's related to capacity issues, is excluded by the statute. And I also ruled out what's called a dissociative identity disorder, and that used to be known as multiple personality disorder. So that was my initial differential diagnosis. Then from that differential diagnosis, I said that the most likely diagnoses were schizoaffective disorder, social anxiety disorder, trichotillomania, and that because I diagnosed him as most likely having a schizoaffective disorder, that meant that the schizotypal personality disorder was premorbid to the schizoaffective disorder.
Tell us what premorbid is before you move on.
So when you look at schizoaffective disorder or schizophrenia, there's certain criteria that you have to meet in order to get that diagnosis. One criteria is that you have to exhibit certain signs of psychosis for at least a month. A second criteria is prior to the onset of those psychotic symptoms, you had to exhibit a variety of other symptoms, such as negative symptoms that we talked about, flat affect, sparse speech. And you had to exhibit those symptoms and other impairments for at least 6 months. That's called prodromal. That precedes the actual psychosis. The way schizophrenia and schizoaffective disorder is set up is that prodromal, before you're psychotic, that prodromal period would look like you have schizotypal personality disorder because all those symptoms are consistent with schizotypal. But once you make the diagnosis that he's now psychotic, and it's really was the prodromal, the schizotypal personality was just preceding the psychotic break, then you no longer call it schizotypal personality disorder. You say schizotypal personality disorder, parentheses, prodromal. That's all it means.
Which one of those that you've talked about, and there's been a bunch, which one of those that you've talked about automatically means that someone is legally insane in Colorado?
None of those disorders mean automatically that you're legally insane. What you can say, in general, if you're going to meet and I say in general, if you're going to meet criteria for legal insanity in this state, the mental disease or defect you're going to have is going to be a serious mental illness that's associated with psychotic features. However, the vast majority, because the definition is so narrow around the capacity, the vast majority...
Judge, I'm going to be objecting to what other cases, the results in other cases might be.
Overruled?
Go ahead, sir. Keep going.
In general, let me just start over to get my thoughts correct. If you're going to meet legal criteria for insanity in this state, you're most likely to have a serious mental illness that is associated with psychotic features. The vast majority of people who have a serious mental illness associated with psychotic features don't meet criteria for legal insanity because the definition of legal insanity is so narrow.
What else was your opinion about why he mailed that notebook to Dr. Fenton?
I think Mr. Holmes was very angry at Dr. Fenton, and I think he had a general anger towards mental health professionals to begin with, and Dr. Fenton specifically, and for what she didn't do. And what she didn't do, and what Mr. Holmes, one of the reasons Mr. Holmes went to graduate school in neurosciences is for years he felt that something was wrong with him, something that was wrong with his brain. And one of his motivations for going, first of all, studying neurosciences in undergraduate school is to try to figure out what was wrong with his brain. That was one of his motivations, and it's clearly stated in his notebook, and it was clearly stated to me, of going to graduate school to not only find out what's wrong with his brain, but to try to fix it. So that didn't work. One of the reasons for seeing Dr. Fenton is trying to fix his brain, and that didn't work. And so I think he was very angry at her.
When he goes to see mental health, what is his stated reason for wanting to go there?
Well, the stated reason was that he was having significant anxiety during his presentations in graduate school. That was the stated reason. I don't think that was his only reason, because he made it very clear up front that he was having chronic homicidal thinking. And you don't tell someone that you have chronic homicidal thinking unless you want to get some help with that. So I think he wanted some help with that as well.
Doesn't the mere fact that he said he had some kind of homicidal thinking mean that he lacked the capacity to know right from wrong, or is it the opposite?
Objection leading.
It's an either-or question, overruled.
It's certainly, having homicidal thinking does not mean that you can't tell the difference between right from wrong, and having homicidal thinking doesn't mean that you can tell the difference between right from wrong.
The individual concerns that the defendant details through his notebook, which we've seen, did he share any of those with Dr. Fenton?
Most of them he did not, and I talked with him about that, and that was in large part related to his negative symptoms and his difficulties in communicating, and I say in large part.
Well, you talked about this anger that you perceive that he has towards Dr. Fenton. What was significant, if anything, about the exchange where he wants her to tell him her philosophy of life?
Well, he was angry because she wouldn't tell him his philosophy. But the other place where anger came out, if you look in the notebook, and it's, again, not obvious until you question him about it, but he talks about the mind rapist. And, you know, when I first read his notebook, I had no idea of who the mind rapist was. But the mind rapist was Dr. Fenton, the psychiatrist. And there's nothing endearing about referring to another person as a mind rapist. It's pretty angry.
I should go back on this one other follow-up question on the homicidal thinking. The fact that he had a concern, or stated that he had a concern about these thoughts, does that have an impact on your evaluation of capacity to know right from wrong?
Yes, and it's another indication that he had the capacity to know the difference between right from wrong, because the homicidal thinking, I think, was disturbing to him.
Tell us, in terms of, was there anything else, by the way, that you thought was psychiatrically significant that you keyed on in terms of evaluating the defendant's capacity to know right from wrong based on societal standards of morality?
The last one would be his actions immediately after the shooting. You know, he just didn't drive away. He knew that he was going to be arrested. And so if he didn't have the capacity to know the difference between right from wrong, there would be no reason to be hanging around. You did what you needed to do and you leave, and that's not what happened.
Let's talk about that. You explored with the defendant. One, did he take any steps to put himself in a position to escape?
As part of his planning, yes.
What was that?
I think it's called the Road Stars. And he brought Road Stars with him. And the reason you'd bring Road Stars is if you're thinking about escaping.
And didn't he, in fact, tell you how he would use them?
I don't think that he told me about how he would use them. I think what he told me when I asked about that, his question was, I don't know.
Okay. And you don't remember writing in there anything about if he got into a chase?
Let me just refer to my report.
Please do, sir. If I'm wrong, forgive me.
I think that's my language and not his.
Thank you for clarifying that. Thank you. You did talk with him, though, about his thoughts when he came outside the theater after shooting. Is that right?
Correct.
Tell us, why did he stay there? Why didn't he try to escape and use those road stars?
Well, he did an assessment when he came out of the theater, and when he came out of the theater, he already saw police, and he assessed that trying to drive away in all his body armor wasn't going to work, and that trying to escape wasn't going to work, and that's why he removed his guns and just stayed there and was pretty passive during the arrest process.
When you say he already saw police, did he give you something to tell you how he assessed how many police were there? And I don't mean numbers. I mean, did he tell you he felt like he was outnumbered?
He assessed that that there were enough there that he wasn't going to get away.
And in terms of the options available to him, was this the best one as he assessed it?
Objection calls for speculation.
You cannot speculate. If you can answer the question based on what the defendant said to you, then you can answer it. Otherwise, it would call for speculation.
It was the best from his perspective if he wanted to stay alive.
Did you form an opinion of the defendant's capacity to know right from wrong based on societal standards of morality for his conduct on July the 19th and 20th, 2012?
I did.
Tell us what that opinion is.
It was my opinion that despite having a mental disease or defect, that Mr. Holmes had the capacity to tell the difference between right from wrong from a societal standpoint at the time of the commission of the alleged crimes.
How confident are you in that opinion?
I'm extremely confident.
Did you formulate an opinion about the defendant's capacity to form the intent to murder after deliberation and to act knowingly back on the 19th and 20th of July 2012?
I did.
Tell us what that opinion is.
And again, my opinion was despite having a mental disease or defect at the time of the commission of the alleged acts, it's my opinion that Mr. Holmes did have the capacity to form the required culpable mental state for the crimes charged.
How confident are you in that opinion?
Extremely confident.
Those two prongs, all that having been met, did you formulate an opinion as to whether or not James Eagan Holmes was sane when he murdered 12 people and attempted to murder 70 other people, whether he was legally sane on July the 19th and 20th, 2012?
Objection asked and answered. Object to the form of the question is argumentative.
Overruled.
Go ahead, sir. Tell us.
I did, and it's my opinion that Mr. Holmes, at the time of the commission of the alleged acts, met the criteria for legal sanity.
How confident are you in that opinion?
I'm extremely confident.
Well, good afternoon. Phil Tenser joining you again, along with Erica and Brian, of course, as always throughout the day. We're going to take a few minutes here and cover some eclectic bunch of information that we have, starting with the reason why we're on this impromptu break and having to stretch for time a little bit. Namely, what we'd like to point out is juror number 706. Now, we know that juror number 706 has in the past had some illness issues while she's been serving on this jury. She is approximately 70s to 80s. She is a retired Army ICU nurse. And we know that, like most of the members of this jury, 19 of the 24, she is a female, a Caucasian woman. We remember 2 weeks ago or so, there were some complaints on the jury about gastrointestinal issues. I'm no doctor, but I think that's a safe way to describe things. Apparently today she sent one note to the judge saying it feels hot in here, and another one saying that she thought she was going to be sick. And the judge did mention this appears to be the same juror who had an issue in the past, and so that's why we're singling out juror number 706. This diagram, if you haven't seen it yet on the DenverChannel.com or your 7 News app, is accurate to where each juror is seated within Division 201, the courtroom down in Arapahoe County, south of Denver. So we know that juror number 18 is the one right here. So what she did, she handed a note to the bailiffs, if you will, the court staff, who sits just off of our diagram here to the right, and that is when the bailiff passed the note to the judge. And of course, we took this impromptu break. Now, We expect it to be 20 minutes, which gives us 3 or 4 minutes left to elaborate. Certainly we'll have a few more things to talk about than that. But what we don't know is if the juror's going to feel well enough. I know that some of you have asked Brian on the chat rooms if that means that the jury is going to be, well, could the juror excuse herself because of how she feels? And the answer, I think, is no. So firstly, she had to ask for court to take a recess. She can't get up and stand and walk out like you might remember doing in a college class or something like that, or a high school class. You can't just raise your hand and get the hall pass and walk down the hall, because you need to hear every piece of evidence, and that's something that the judge has been very clear about. There are no exceptions. So the juror who was late returning from a doctor's appointment last week, we waited for her as well. We don't know if that was the same juror as this one. I don't believe it was. But at this point in time, if the juror is not back, their only decisions are dismiss her and move forward, or wait for her to come back. At this point, the court does still have 12 alternates. Now, you'll know that in most jury trials, at least in the state of Colorado, we don't have 12 alternates. In this case, because of the length of the case, the severity of it, obviously the idea that the judge wants to avoid any and all possibility of having to do this work again, because it has taken us weeks and it's going to take us maybe 4 more weeks before we even hear a verdict. Maybe 3 weeks it'll be in the juror's hands. Judge Samore doesn't want to give it that much time. So that's why we have these 12 jurors. And what we don't know, as you click through these, you'll notice none of them say this one is a juror and this one is an alternate. So if you click through here, you'll learn the little bit that we know about them from attending jury selection, but we don't know who is who. The only folks who know which is a juror and which is an alternate is the court and the attorneys. Now, we can guess a little, and if you follow jury selection at all, you might say, well, they spent a lot more time arguing about one seat than another. Maybe that is a seat. But all of that is inference, all of that is guesswork, and we honestly don't have the answer for that yet. So we don't know if who is who. We don't know who's going to vote and who's not. Certainly it's going to be difficult. The folks who don't get to vote, can you imagine sitting on this trial for 3.5 months and then being told you don't get to choose or you don't get to cast a vote? And certainly that's going to be tough. But so far, we've had some near misses. We have not had to dismiss a juror. Now, let's go for a moment to the timeline and discuss what we have heard with Dr. Metzner. And let's also put it into context historically about when it occurred in the course of this trial. So firstly, what we'd like to look at is March 27th of 2013. And if you were in Colorado or following the case at that point, you'll remember a document came out on that day saying that they were ready to make a plea deal. Of course, the prosecution responded saying there are too many of the survivors and victims who oppose a plea deal, and there are too many of the, and there's too much evidence going on here to allow that. They decided to pursue the death penalty, and that's what we're working on now. But as I scoot forward here, again, they say they plan to enter the insanity plea. That's how they respond. Of course, after you enter the insanity plea, you enter the plea. Of course, he has to sign documents at that point. And then we move on oral arguments over the constitutionality of this degree. It took, of this plea, and it took weeks. As you can see the timeline going, we're now jumping into June of 2013. He's officially entering that plea, and here Mr. King with the shooter looking at the documents that they have to sign to make that official. Of course, when he was first in court, the court entered on his behalf a plea of not guilty. That happens routinely in Colorado, whether the defendant wants it or not. It's a result of the severity of the crime and the right to a due process in the course of a trial. The deadline for the first sanity evaluation, that is Dr. Metzner's, was extended, but of course we know that in the end it wasn't deemed sufficient anyway. We heard from Dr. Reed about the one that was deemed sufficient. Other things happening during this time, witnesses barred from the courtroom, deciding that his parents will be allowed to attend, and of course they are. They sit in the row behind where the defense team sits on your screens, just outside of the range of the courtroom camera. Another document comes in. You may have noticed that in the course of our reporting, we say the shooter, the gunman, because he's admitted. In most other cases, you'll notice that we don't do that. We say suspect or alleged, blah, blah, blah. In this case, we do have documentation where the defense team admits that. And of course, it is also intrinsic to the definition of not guilty by reason of insanity. It means he did it, but he wasn't legally in control of his faculties at the time and therefore can't be culpable. It's a culpable mental state. So we do have documentation at this point. And now we're all the way through the middle of July of 2013, and we still haven't received that document. We jump forward. Finally, a 128-page report is submitted on September of 2013. And of course, as we continue forward through that, we hear it was not deemed sufficient. And that's why Dr. Reed came. And that's why Dr. Metzner, even though he submitted a 128-page report that we've never seen, that's why he's only testifying for this short period of time. And Dr. Reed was on the stand for more than a week. It's all because of the fact that in the end, his report was deemed insufficient. However, as you've heard, they've reached the same conclusions. And Dr. Metzner has also talked about some speculation. That Road Stars piece was particularly interesting to me because that's something we've never heard an explanation for in the past. Dr. Metzner talking today and in the soundbite that we replayed earlier, speculating that that was all part of the intent to escape, and the intent to escape was very important to his decision that Mr. Holmes should be considered legally sane and therefore culpable at the time. And of course, that would mean guilty once a verdict is reached by the jury if they believe Dr. Reed and Dr. Metzner. But of course, both sides will have their own experts in addition to these court-ordered psychiatrists to hear from. While we're still waiting, obviously we are still waiting for the judge to resume court and for the jury to return to the courtroom, we're going to replay some of the sound from this afternoon, a little bit of a recap for you, and hopefully the juror will feel better and we can resume shortly.
Doctor, finishing up from where we were this morning, I want to ask you if you could tell us which factors you considered from all the discovery and your examination that go to the capacity to form the intent to murder after deliberation and to act knowingly as regards July 19th and 20th, 2012.
Well, the most obvious ones are the information in the notebook. There's a number of pages where he describes his plan for the movie theater and plans other options other than going to the movie theater. And then as I mentioned before, I questioned him line by line about that. So it was very clear that he had thought about this for some time. And then the knowingly part, the plans from the perspective of carrying out the shooting were realistic, meaning he didn't go out and buy water pistols. He bought an AR-15 and a Glock and a Remington. So that goes to the knowing part. And they're the major obvious factors.
You know, speaking of the 19th and 20th of July, we have heard Dr. Reed use the phrase acutely psychotic. Is there a synonym that you would use to describe if someone was, that they were not acutely psychotic?
Well, I heard the testimony by Dr. Reed with...
Court is resuming, so we are going to pause that replay. We'll rejoin it at a later time, and here is Judge Samore resuming court.
Eagan Holmes, case number 12CR-1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. We are outside the presence of the jury, and Juror 901 is telling us that she's ready to go, so we can proceed. Let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury has joined us again. Members of the jury, I want to remind you that the court has admitted the testimony of Dr. Metzner for a limited purpose. You may consider his testimony only as to the issues raised by the defendant's plea of not guilty by reason of insanity. You shall not consider this evidence for any other purpose. Dr. Metzner, I remind you that you're still under oath. And Mr. King, you may resume your cross-examination of Dr. Metzner.
Thank you, Judge. Doctor, after reviewing all the material and talking to all the relevant people and interviewing Mr. Holmes, you eventually reached a diagnosis, and I realize I may be taking one step back, but is that correct?
Well, as I previously testified, I reached a differential diagnosis, and of that differential diagnosis, I said what I thought was the most likely diagnosis.
And part of the differential diagnosis was schizophrenia, as well as schizoaffective disorder, as well as a major depressive disorder. Is that right?
Correct.
And the diagnosis of schizoaffective disorder, in essence, is you just testified before the break, essentially a combination of a major depressive disorder and schizophrenia, correct?
Well, it's a combination, correct, although you could have either a major depressive disorder or you could have a manic episode.
So, in that sense, why don't you tell the jury what an exclusionary diagnosis is first?
Well, an exclusionary diagnosis, if you look at DSM-5, to give a particular diagnosis of, say, of schizophrenia, there's what's called A criteria, in capital A criteria, and there's about five different symptoms in which you got to meet at least 2 of 5. And then there'll be B criteria. And B criteria, I think, in DSM-5 for schizophrenia has to do with impairments and or time duration. And then there'll be another, whether it's C criteria or D criteria, it will say, for example, if you have the following, then that will exclude the diagnosis of schizophrenia. So when you talk about exclusion criteria, it means if you meet certain criteria, then that diagnosis is impossible. It has to be some other diagnosis.
For example, if you diagnose schizoaffective disorder, it excludes schizophrenia as a matter of course. Is that right?
That's right. A better example probably is, say you meet all the A criteria of schizophrenia, which is essentially showing psychotic symptoms. But it turns out that the reason you had those symptoms is because you took amphetamines and you had an amphetamine psychosis, which can look just like schizophrenia. But if you know that that psychosis was caused by amphetamines, then that would exclude the diagnosis of schizophrenia.
No indication, suffice it to say, that Mr. Holmes' psychosis was caused by any drug or alcohol or anything along those lines.
No, this was not related to substance use or abuse.
And why is it important to reach a diagnosis?
Well, it depends on the context. In this context, it's, in my mind, it's more important to reach a differential diagnosis than a diagnosis, because what you have to reach in the sanity evaluation is the first question: did he have a mental disease or defect at the time of the alleged crimes? So you got to answer that question. As I said in direct, I don't think it makes much of a difference whether it's schizophrenia or schizoaffective disorder.
And I want to talk to you about that as well. But before we get there, you said that you were involved in writing the cautionary statement for forensic use of the DSM-4. Is that right?
Not exactly. What I said is I reminded the jury that what's called the cautionary statement or the forensic caveat in DSM-4. I wasn't involved in writing that, but related to that, part of the process of both DSM-4 and DSM-5 is once there were drafts of all the chapters, they did several things. They say, for example, the draft on schizophrenia. They would have sent, there's a council of the APA that is specific on schizophrenia. So they would have sent that draft to the council on schizophrenia to make sure there's nothing wrong in there. And they would have also sent that draft to experts around the country. In fact, you were invited if you wanted to comment on that. In addition to that, they sent all the chapters to the Council on Psychiatry and Law, of which I was a member at the time. And the question was, is there anything in here in the text or the criteria that's inconsistent with the cautionary statement? And I was specifically reviewed the chapter on schizophrenia.
Okay. And I don't know if you recall you said you saw Dr. Reed's testimony, is that right?
Correct.
During Dr. Reed's testimony, Dr. Reed was asked to read paragraphs 1 and 3 of the cautionary statement for forensic use of the DSM-5. What I would like to do is read you a quotation, and if you want to take a look, you're more than welcome to, just let me know. I'd like to read you a quotation or two from paragraph 2 of that document and see if you have any commentary on that.
Overruled.
When used appropriately, diagnosis and diagnostic information can assist legal decision makers in their determinations. For example, when the presence of a mental disorder is the predicate for a subsequent legal determination, the use of an established system of diagnosis enhances the value and the reliability of the determination. Can you explain that statement to the jury?
Yes, what that basically means is, for example, I had to determine whether Mr. Holmes suffered from a mental disease or defect at the time of the commission of the alleged acts. This cautionary statement, the second paragraph, basically says the DSM-5 can be very helpful in determining whether someone has a mental disease or defect that because it has a common language. So it's not my making up a mental disorder that I think this is a mental disorder. I can say he meets the criteria for either this diagnosis or that diagnosis, and my understanding of those diagnoses that they meet the definition of mental disease or defect within the statute.
And I think that's what you're saying is I'm going to read one more sentence from this paragraph if I might. The literature related to diagnosis also serves as a check on ungrounded speculation about mental disorders and about the functioning of a particular individual. Is that what you were saying in part?
Yes, that's what I was saying.
And the way that relates to the sanity determination is that the type of diagnosis that a person has is relevant to determining what their thought processes might be during the time of the offense. Fair to say?
In general, it's fair to say. And why I say that is you could have a diagnosis, say, of an anxiety disorder. And an anxiety disorder isn't associated with psychotic features. So if the only diagnosis he had was an anxiety disorder, it would not be very credible by an expert to say, as a result of this anxiety disorder, he experienced delusional thinking. Now, so it's correct in that sense. It's also where it's somewhat not correct is you could have a diagnosis of schizophrenia. That doesn't mean because you have a diagnosis of schizophrenia that you were psychotic at any particular time, but it does mean if an expert found someone to be psychotic at a particular time and found them to have schizophrenia, that would be each would be consistent with each other.
And certainly you're aware that the test, and you've said this a number of times, the test in Colorado for whether someone meets the standard for legal insanity or not has to turn on what the person's mental state is at the time of the offense, correct?
Correct.
So what we're doing in a lot of situations when we're trying to determine capacity, because we can never be inside the person's brain at the time of the offense, fair to say?
Correct.
So we're never going to know with 100% certainty what that person was actually thinking at the time, correct?
Correct.
The best that we can ever do is to logically infer what might have been the thought process that the person was engaging in at the time, based upon what they say later, what they said before, or any other relevant information around the event.
Well, I would emphasize the inference is based on that kind of information. The inference is not based on the diagnosis alone.
Correct, correct. And I'm not suggesting that it is. But the inference would be based on other information considered in light of the diagnosis. Fair to say?
Fair to say.
In other words, you consider the information. If you've said that Mr. Holmes was psychotic at the time of the incident, so part of the analysis is analyzing how that mental illness affected his thought process at the time and whether there was logical thinking going on there or not.
Correct.
Now, I want to talk about schizophrenia and what the diagnostic criteria for schizophrenia are. And can I have 2623 shown to the court and to the witness, please? Do you recognize what I put up on the screen, sir?
I do. This is the diagnostic criteria for schizophrenia from DSM-5.
Would that help to explain to the jury what these criteria are to actually be able to go through these?
Would not hurt.
Explain to me what criteria A is, and if we could highlight criteria A, please. Is this the psychotic symptoms part of the diagnosis of schizophrenia?
That's correct.
So, and what this requires is that you have two or more of the following, each present for a significant period of time during a 1 month period. Is that fair, sir?
Yes.
In Mr. Holmes' case, you found that he met this criteria in the sense that he had delusions, correct?
Correct.
And negative symptoms, correct?
Correct. And I guess I'm assuming you're asking me July 20 or before. You're not asking me through any other time.
Right. Well, sir, let's clear that up. Certainly, as of November 2012, he experienced hallucinations as well. Fair to say.
And a disorganized speech at that time as well.
And but I'm talking about as of the July 2012.
Okay.
You've identified delusions.
Correct.
And negative symptoms, correct?
Correct.
And those are symptoms of psychosis, is that correct?
Yes.
Especially the delusions.
Correct.
If you have a delusion, you are by definition psychotic, correct?
That is correct.
And your opinion that Mr. Holmes' idea regarding human capital is a delusion, how strongly do you hold that opinion?
Within a reasonable degree of medical certainty.
Now, if we can look at B, please. Can you explain criteria B for us, sir?
Yes, this goes to what I talked before about functional impairments. And it says, essentially, prior to the onset of the psychosis, or around the time of the psychosis, but prior to the onset of the psychosis, that there are significant functional impairments in either interpersonal relationships, self-care, or work. And so that's what it says.
And in Mr. Holmes' case, you indicated in your report that there were significant levels of disturbance in functioning in several areas, including work and interpersonal relationships. Is that right?
That's correct.
Now, the breakup with Gargi, for example, in your opinion, the breakup with Gargi didn't cause the shooting directly. In other words, the reason for the shooting was not the breakup with Gargi. The breakup with Gargi was a trigger to the psychosis, which then created the delusion, which would cause the shooting to take place.
I think was one of several triggers. It wasn't the trigger.
Understood. Another trigger would have been failure in academic failure.
At that point, I wouldn't say academic failure. It was not doing well in school. It eventually was academic failure, but not doing as well in school as he had done before, particularly in presentations.
Now, that didn't cause the shooting, correct?
That's correct.
That was a trigger for the psychosis that caused the shooting, correct?
In my opinion.
Now, in your opinion, Mr. Holmes had these negative symptoms, this prodromal period, or what you describe as schizotypal personality disorder, for some time before the onset of the psychosis, before the delusion actually developed. Is that right?
Yes, if I can, I'd like to go back and just say something about the triggers.
Sure.
The question about, he had chronic homicidal thinking for many years. And so one of the questions I had to answer is, okay, why is he acting on them now? And why did he develop delusional thinking? And there's several possibilities. One possibility, it had nothing to do with triggers. If you look at the onset of schizophrenia in males, the most frequent onset of schizophrenia is in your 20s. And so it could have had nothing to do with any triggers. It could have just been the natural course of his illness, and that's why he became psychotic then. On the other hand, it's very common to see someone who has the underlying genetic predisposition to schizophrenia to have their first psychosis triggered by stress. And as I got the history, I identified three major areas of stress that I've testified to that I thought triggered. And so that's why I think that precipitated his psychosis. But I could be wrong on that, and it could have nothing to do with triggers, and it could have just been the natural course of his illness.
And the natural course of schizophrenia and schizoaffective disorder is just as you say, that quite often the onset of the psychosis aspect of it happens when people, especially young men, are in their early 20s. Is that right?
Right. It's like hypertension. You could be predisposed to have hypertension, and some people get it when the genes kick in, and other people get it sooner before the genes kick in because they're under a tremendous amount of stress.
Or they're smoking 5 packs of cigarettes a day. Or
yes.
And there's no doubt, is there, in your mind, that Mr. Holmes was genetically loaded for mental illness, right?
Yes, that's based on his father's fraternal sister, his aunt, has schizoaffective disorder. His mother's father, his maternal grandfather, had a psychotic illness and had hospitalizations, and his father's father had severe obsessive compulsive disorder that was disabling and was also psychiatrically hospitalized. And there's also little question that there's a genetic component to schizophrenia. It doesn't mean if you have a family history of schizophrenia that you're going to get schizophrenia, but you're more likely to get schizophrenia if you have a family history, just like if you have a family history of heart disease. You're more likely to get it. Doesn't mean you're going to get it.
And that was going to be my next question, is that an apt analogy between hypertension and schizophrenia in the sense that it's a risk factor, but it doesn't mean you're automatically going to get it? Fair to say?
That's fair to say.
And some people get hypertension. They don't smoke cigarettes. They don't have bad life choices. They just get it genetically. It just happens despite all of their good intentions and healthy living.
Yes, you could have no family history of schizophrenia and still get schizophrenia.
Now, can we go to C, please? This is a continuous signs of the disturbance persist for at least 6 months. And it has to include at least 1 month of symptoms that meet criterion A, and may also include periods of prodromal or residual symptoms. During these prodromal or residual periods, the signs of the disturbance may be manifested by only negative symptoms, or by 1 or 2 or more of the symptoms listed in criterion A, in an attenuated form. Can you explain that, please?
Yes. So it essentially says you have to have the active symptoms untreated for at least a month. And the active symptoms he had was the delusion and the negative symptoms. And then in addition to that, you have to have at least 6 months of, it's really pre-psychotic symptoms, prodromal symptoms. And he clearly had, for a long time, the negative symptoms. You saw that back in, I think the jury's heard the evidence that the application, I think, is to the University of Iowa, in which the admissions people said Mr. Holmes had, from a paper review of his academic credentials, he was a shoo-in. But they interviewed him and thought that he interacted in a very aloof, bizarre way. That was an example of some of his negative symptoms.
And it's your opinion that those negative symptoms onset even previous to that. Is that right? How far back do they go?
Well, I think you can start seeing it back in his college days.
Okay. Those negative symptoms, we went through some of those with the jury, but those include alogia, which is a paucity of speech. Is that right?
Yes.
Asociality, not interested in being around other people.
Correct.
Avolition, lack of motivation, correct?
Yes.
Anhedonia, inability to get pleasure out of things that are normally pleasurable.
Correct.
Now, this jury has heard some talk about how Mr. Holmes, in his graduate program, appeared, number one, to have a paucity of speech. You recall reading reports about that, about how he didn't talk very much?
Yes.
That's consistent with the negative symptom of schizophrenia, correct?
Yes.
And it's consistent with what you observed in Mr. Holmes. Is that correct?
Yes.
You've also heard about a lack of motivation from some of these folks. Thought that he just didn't appear to be that into it and didn't seem to be trying that hard. That would be consistent with the negative symptoms of schizophrenia too. Is that right?
Correct.
Now, you said that when you were asked by Mr. Brockler about studying for these prelims, that Mr. Holmes indicated that he didn't study very much for his prelims in the spring of 2012. Is that right?
Yes.
And he indicated to you that that was out of the ordinary, in that previously he'd studied very hard and had to try very hard and study very hard in order to succeed academically like he had, correct?
Correct.
No indication that he just had it so easy through his entire academic career that he never had to study at all and was unmotivated the entire time, but it just was so easy for him to do that when he reached graduate school, it was just too hard for him. That's not what he told you, is it?
What he told me is what a large part of what motivated his studying in the past was fear of not doing well and of not pleasing people. And so that was, and so he decided this time he's going to be himself and not let it be due to fear.
Okay. When, in your opinion, did Mr. Holmes become psychotic? Was it that the first real sign for you, that Gmail chat with Gargi on the 25th of March, 2012?
That's the first time that I had concrete evidence.
Now, is psychosis or these delusions the type of thing where you go to sleep one night and you wake up in the morning and all of a sudden you've got a full-blown delusion and you're just psychotic? Or does normally it involve a more fluid process?
I think it's a more fluid process, unless, and where I would say it may be very abrupt. You can become delusional based on certain medical illnesses or certain insults to your brain. So, and for an example of that, you saw a different kind of delusion in Mr. Holmes is when in November, when he stopped eating, because at that point he thought his food was being poisoned, and he developed a delirium. And when you develop a delirium, that's usually very acute onset, and you can develop a delusion that you didn't have the day before. So in those kinds of causes of delusion, it can be overnight. The kind of delusion related to schizophrenia is usually not one day you're delusional and the next day one day you're not delusional and the next day that you are.
And you don't think that happened to Mr. Holmes? You think that this was more of a gradual process, a fluid process that happened over time. Is that right? And so over time, the delusion gains in strength, or how does that work? Or does it wax and wane, where it may be worse and then get better? Or explain that to us.
Well, like a lot of things, it depends. And I don't think it's a matter of being able to measure the strength of the delusion. I think, one, it depends on the content of the delusion, and it depends on the environmental circumstances. So if you have a delusion, for example, that people over 6 feet tall are going to harm you, it's probably going to be much more intense if you're in a room with a bunch of people over 6 feet tall. And if you're not in a room, that may not be such a important thing at that time. So it really depends.
Okay. Would you agree with me that the psychotic process can wax and wane over time, that folks can have bad days and bad months and do better at times? Is that fair to say?
Yes, and a good example of that is one example of a psychotic symptom is auditory hallucinations. There's some people who hear auditory hallucinations every day, but there's plenty of people once a week they hear them, or during the day they don't hear it constantly. So that's a waxing and waning.
Is that part of the reason that it's important to try as best we can to focus on what the mental state of the individual was on the date of offense to determine what the process was that was going on at that time? Does that make sense, my question, or no?
Yes, it does. And that's one reason for doing that.
So is it your opinion that what happened to Mr. Holmes in November of 2012 is somehow a different disease or a different psychosis than what was going on in July of 2012? Or is it part of the same disease displaying different symptoms at different times?
The opinion I gave is that Mr. Holmes, prior to July 20, and including July 20, that his predominant psychotic symptom was this delusion. And I think the delusion that he had on July 20 was the same delusion that he had, that was evidenced in the March 25 Gmail chat. And when you read his notebook and you read the first couple pages, that if you just try to read it, makes no sense. But when you talk with him and try to make sense of it, he had that in June and July as well, as evidenced by his notebook.
And how about in August? How about the writings that he wrote in the jail about the galactic colonization and the ultraception that he describes in there, and those writings?
Well, what I can say about the writings, about those writings, is I got those writings after my examination, and I got them after my examination because because they weren't available. No one was aware of those writings. If you just read them, I think they're pretty bizarre, but I didn't talk to him about that. So what they mean and whether it's the same process or a different process, I don't know.
Now, you did say before that you were able to read the notebook and go through the notebook with him, correct?
Yes.
And you would agree with me that, well, there are different parts of the notebook. There's the planning kind of part where he talks about the theater, correct?
Yes.
And to some extent, that seems to have some logic to it. In other words, because it seems to be logically evaluating different options and things like that. Would you agree with that?
I think it's very logical in the context of wanting to carry out an illogical, rational belief.
Now, on the other hand, the other part of the notebook that involves all those equations of ones and zeros and diagrams, and that is really nonsensical. Wouldn't you agree with me?
On its surface, I would agree that it's nonsensical, and then, and not just nonsensical, I think it's psychotic. And that's why when I tried to understand from him what this all meant, I got enough understanding that it was related to this delusional belief, but I can't explain his thinking about that. And I think that's also similar to what you saw what you see in the Gmail chat, in which he's talking with Gargi, and she's trying to argue with him about, why would you want to do this? It doesn't make sense. And she finally says, I don't understand what you're talking about. And I think she didn't understand what he was talking about because it was psychotic.
And that's in March again, is that right?
Correct.
Now, he wrote in the notebook after he stopped going to treatment on June 11th, 2012. Is that right?
Correct.
So some period, maybe more, he wrote what was in the notebook and then mailed that to Dr. Fenton.
Correct.
And he said that he did it so that psychiatrists could treat people like him effectively, correct?
Correct. And also prevent this from happening.
And you said that that indicated some indication of capacity to you at that time, correct?
Correct.
And that would be before the event.
Correct.
Now, psychosis is a severe form of mental disorder that is frequently associated with a loss of contact with reality. Correct?
Yes.
Is it that experienced differently by each patient who becomes psychotic, or each individual?
Yes.
And this gets to your distinction between acute psychosis or florid psychosis and otherwise psychotic. Is from a psychotic illness, babbling, homeless on the street, unable to dress themselves or carry on normal activities?
No.
Is there a whole spectrum of different types of psychosis and capabilities that individuals have?
Yes.
The fact that someone has the ability to plan in and of itself doesn't mean that they're not psychotic, does it?
It does not.
In fact, there are numerous examples of very psychotic people who are able to plan things in great detail over long periods of time. Is that right?
Correct.
It's a common misconception that people often have, that psychosis affects someone such that they cannot carry on normal daily activities or cannot plan normal parts of their life.
Well, it's a misconception that if you're psychotic, you can't. There's plenty of people who are psychotic who need structure and, won't take care of their hygiene and could never hold a job, could never go to school. So that's one end of the spectrum, but that's just one end of the spectrum. You can be psychotic and you can carry out many life functions and you can live independently.
So the fact that someone may be able to drive or go to the store or answer an email, none of that precludes someone being psychotic and being involved in a delusional process.
It does not.
Now, a thought disorder, what's a thought disorder?
A thought disorder is when your thinking is impaired, and impaired to the extent that it's psychotically impaired. And so you have different areas where your contact with reality is impaired.
So that's an aspect of psychosis then?
It's an aspect of psychosis, and you generally can see manifestations of it through speech or through writings.
Like the writings in the notebook?
Correct.
Which are disorganized?
Not all of them, but the part about his delusional thinking, I think, is quite disorganized. The part about his planning is very organized, and I would not call that's not evidence of psychotic thinking.
Understood.
But because when you have psychotic thinking, it doesn't mean in all areas of your life it's psychotic.
And let me ask you about that. And let me. I've heard an analogy to delusional psychosis that goes kind of like this. If you picture life as like a road map, the delusional psychosis is kind of like an overlay, like a transparency that lays on the map. And so the person, which may have delusional roads on it, let's just say, things that are not real. So the psychotic individual could be driving down the road, operating through life normally, and it might not be obvious to anyone because they're actually on the actual road driving normally, but then may turn off into where they perceive a road to be, where a delusion is, and may separate from reality. Does that make sense? Does that analogy make any sense? Not so much.
I'm sorry to say that it's not a great analogy description-wise, but I mean, I don't think it gives the full flavor of delusional thinking. If you talk to someone about delusional thinking, it's what they believe is that it's real, and that's the best I can tell you.
They believe it's real even though it's not.
That's correct.
And in my lame analogy, they believe that there's a road there when there really isn't a road there. And they really believe that.
Yes.
Now, in Mr. Holmes' thought disorder, now, that was not just limited to the human capital construct, but also included Mr. Holmes' feelings of worthlessness and his thoughts on the human worth equation as well, right?
The feelings, yes, I would say so.
So it's not just encapsulated into that one area, and you've told other folks that that's your opinion. That
Yes, he didn't have, his mental illness symptom was not encapsulated. And what I mean by encapsulated, you can see people who have what's called a delusional disorder, where they clearly have a delusion, but there's no negative symptoms, there's no other symptoms related to that delusion. And they could be working, they could be presidents of corporations. And unless you talk to them specifically about that delusional thought, you would never know that anything's wrong with them. That's not the case with Mr. Holmes. Mr. Holmes had other symptoms besides his delusion, and that's what I've talked about before, is the prodromal symptoms, or those symptoms.
And that's why you disagree. And we'll talk later about how similar the various clinicians' diagnoses actually are. But that's why you disagree with Dr. Reed's diagnosis of a partial delusional disorder, correct?
Correct. And that goes sort of back to your, I think you had asked me about exclusionary diagnosis.
Yes, sir.
That for a delusional disorder, there's essentially an exclusionary diagnosis, is that you don't have other symptoms other than something that's directly related to the delusion. So if you had a delusion and you had negative symptoms, that would be exclusionary for making that diagnosis, as I understand it.
In November of 2012, is there any doubt in your mind that Mr. Holmes, when he was admitted to the hospital, Denver Health Medical Center, was both psychiatrically psychotic and suffering from some delirium as a result of not eating and drinking?
No, I don't have any question for a number of reasons. One, his delirium was indirectly precipitated by his psychosis. He developed a paranoid thought that, I believe at that time he was still on suicide precautions, and he was getting bagged lunches, and it said SS, and SS stood for suicide sack lunch. And he was paranoid and interpreted that as something to do with the Gestapo or the Nazis, and interpreted that he was being poisoned. And so he stopped eating and he stopped drinking. And he stopped eating and drinking enough that he then developed metabolic disturbances, which is the delirium. And so he got treated for the delirium and got better, but he still remained psychotic for a period of time. And it wasn't a small period of time. When you go back and look at, symptoms started November 11th, and if my memory's correct, he got discharged on November 17th, and that was after he got not only his delirium adequately treated, but he got put on antipsychotic medication. So you're not talking about 2 hours or 6 hours, you're talking about at least 6 days where he had psychotic symptoms.
And the antipsychotic medication that he was prescribed, what's the purpose of that?
The purpose of antipsychotic medications is to treat the underlying psychosis. And so, meaning if you treat the underlying psychosis, you'll decrease, sometimes you'll get rid of it, but usually it's decrease or, excuse me, or you help stabilize his condition so he can improve.
Now, in terms of florid psychoses, when on November 15th, a psychiatrist at Denver Health Medical Center, Dr. Rachel Davis, noted that that recent history had been that he had been very disorganized and definitely psychotic, sticking his finger up his anus, smearing feces, refusing to wear clothing, licking the walls, defecating on the floor, eating paper, standing on his head, talking to himself, talking without making any sense. Is this the kind of stuff that you're talking about when you talk about florid or acute psychosis?
That's what I'm talking about, florid psychosis.
He was given Haldol first at Denver Health Medical Center. What is Haldol?
Haldol is an antipsychotic medication.
As is Risperdal?
As is Risperdal.
Now, you talked about the Gmail chat with Gargi, and it was evident from the contents of the chat itself that that Gargi didn't think that Mr. Holmes was making a lot of sense in that conversation. Fair to say?
Yes.
And you have some information, do you not? And I don't know where I'm remembering this, but that she may have suggested to Mr. Holmes that he see a psychiatrist. Is that right?
She had suggested to him. I'm not sure that was as a result of the Gmail chat. But she had suggested that to him.
Now, you said that it was evident at the first session with Margaret Roth, frankly, before he even saw the psychiatrist, that the stress of the homicidal ideation was expressed. Is that right?
Correct.
How long had this homicidal ideation been going on, and can you explain that to us?
Well, he reported having thoughts of killing other people for many years.
And is that one of those negative symptoms, or how does that relate?
No, I wouldn't call that a negative symptom. It's a very interesting concept. I had part of my evaluations I mentioned before is I looked at previous records, and I also talked with previous evaluators or treaters. And one of those persons was Dr. Woodcock. And so I talked with Dr. Woodcock, and I also looked at notes that Dr. Woodcock had written. And one of the things that Dr. Woodcock said is that Mr. Holmes had been struggling for many years with homicidal and suicidal thinking, and that the way he had dealt with the suicidal thinking is somehow had transferred suicidal thinking into homicidal thinking, which made him less suicidal. So I had that information going in. So then I attempted to clarify with Mr. Holmes what that process was and how it occurred, and essentially saying, how did you transfer suicidal thinking into homicidal thinking, and how was that helpful? And he couldn't explain that. And I thought that he couldn't explain it because I think he didn't understand that. And I also don't understand that. But that's the best I can tell you. He's had those thoughts for many years, and his own conceptualization was that he had homicidal thinking because he had suicidal thinking, and it was his response to deal with the suicidal thinking.
Now we've said already that we're constrained by the fact that we can't be inside someone's head at the time of the offense, and we have to infer from other things what the thought process was. Now, is that an example of how somehow that can be difficult to do, difficult to apply logic retroactively to someone who's engaged in a psychotic process at the time?
Yes.
And the danger is that we're trying to apply logic to what may be an inherently illogical thought process, potentially.
Correct.
So there may not be an answer that makes any sense.
Correct.
What's psychotic ambivalence?
Psychotic ambivalence is all of us with a lot of different issues have ambivalence. You know, should I do this or shouldn't I do this? And there's nothing psychotic about that, and there's nothing abnormal about that. What you'll see with people who demonstrate psychotic ambivalence is you'll see intense ambivalence that rapidly changes over things that they really shouldn't be ambivalent about. I mean, it could be something very simple that most people can make up their mind, you know, should I go to the store now? And they keep changing and they get distressed by it. That's what psychotic ambivalence is. And you frequently see psychotic ambivalence in people who are psychotic. You can also see ambivalence in people who are psychotic. That's not psychotic ambivalence, but just normal ambivalence. You can also see ambivalence in people who are psychotic, in which it's not psychotic ambivalence, it's just normal ambivalence.
Now, you've spoken with Drs. Fenton and Feinstein, is that right?
Yes.
And you have no reason to doubt their observations or their conclusions that were in their notes and their record?
No, my conversations with them were consistent with their documentation.
And many of the things that they told, that Mr. Holmes told them, was consistent with what he told you and other clinicians after the fact, right?
Yes.
Long-standing thoughts of killing people. He went right in and told them that, right?
Correct.
And we've talked about, counsel's talked about some of the things that he didn't tell them. But there were certainly a lot of things that he did tell them. Fair to say?
Yes.
He went in right off the bat and said he had thoughts of killing a lot of people. Is that right?
Correct.
And Dr. Fenton recognized pretty early on what she identified as probable psychotic thinking. Is that right?
Yes.
I'm thinking specifically at first about him having to get glasses and portraying that to her as a betrayal of his biology. And she saw that as probable psychotic thinking in that it had a very bizarre quality. Is that right?
Yes, let me just clarify. I previously talked about differential diagnosis. Early on, Dr. Fenton, in her differential diagnosis, included high on her list that this was a psychotic presentation. So yes, she considered that.
And later on, she continued to talk about how this may be a frank psychotic disorder, such as schizophrenia. Is that right?
Correct. I don't think she ever ruled out that he was psychotic. I think it continued as a potential description as of her June 11th discharge note.
And you see some potentially psychotic thinking in some of those statements that were made to her as well. Is that right?
Yes.
How about the glasses thing? Is that a somatic delusion of some kind, or?
You know, the glasses thing I would consider, if I was in her shoes, not necessarily psychotic, but bizarre. And when you start seeing things that are bizarre, you begin to think that maybe this is a psychotic process. But by itself, you don't say it's psychotic. But it certainly raised the index of suspicion for Dr. Fenton.
How about the whole session where she thought Dr. Fenton had locked the door and had some kind of secret box behind her desk that she was hiding from him? Do you recall that?
Yes, and again, that would make you certainly think of paranoid thinking, and when you start thinking of paranoid thinking, you think of psychosis, and then if you have other kinds of bizarre behavior, that makes you think more strongly of psychosis.
It's common for people suffering from schizophrenia to describe their past delusions or motivations somewhat differently over time, especially after they're medicated. Is that a fair statement?
I think that's a fair statement.
If I may have a moment, Your Honor.
Yes.
Now, 5 days before the Gmail chat with Gargi on the 25th of March, 2012, Mr. Holmes goes to see Dr. Fenton, and she puts him on sertraline, correct?
Yes.
What's sertraline?
Sertraline is an antidepressant medication, but it's not just used for depression. It's also used for anxiety disorders. It's also used for obsessive compulsive disorders.
Is that like a generic term for Zoloft? Or?
It is.
So he gets put on Zoloft or sertraline. Let me ask you, if you give, and it's your opinion at that point in time that Mr. Holmes was suffering from a depression, right?
Correct.
A clinical depression.
Correct.
Such that he meets the criteria for a major depressive disorder.
If you, and that, yes, and that's based on what he told me and based on his notebook. And I'll just add that that wasn't told to Dr. Fenton.
Indeed, indeed. Now,
Wasn't me.
was it,
I deny it as well.
I do. I'm going to blame it on somebody in the gallery. The
Mr. Ingalls raising his hand.
And we talked before about mania versus depression and how that can work. Now, it's known in the literature, the psychiatric literature, sir, that if you have someone who's suffering from a depression, a clinical depression such as you described, major depressive disorder, and you give them an SSRI, like sertraline or Zoloft, it can flip them into mania, can it not?
Well, not exactly. If all you have is a depressive disorder and you get treated with antidepressants, that will not flip you into mania. If you have a bipolar disorder or a form of bipolar disorder in which you can have depression and mania, that a certain percentage of people with that kind of disorder, if you give them antidepressants, it can flip you into having manic symptoms.
And that's the kind of disorder that you've diagnosed Mr. Holmes as having as part of the schizoaffective disorder, is that right?
That's correct.
Bipolar disorder that had both manic and depressive features.
Correct.
So it's certainly possible that by getting that medication, it threw him into a mania. Is that right?
It's possible when you look at the symptoms that he described in his notebook, which included some manic symptoms and what he labeled as his dysphoric mania.
Right.
It's possible that the Zoloft could have caused that. But let me also tell you what I'm not saying. I don't think his delusional belief was related to that medication, and I don't think his subsequent actions were related to that medication. I think his actions were related to the delusion, not to the medication.
And the delusion was related to the psychosis of the underlying disorder.
That's
and
correct.
not the medication.
That's correct.
The symptoms of mania, however, may have been exacerbated by the medication. Fair to say?
if he had, the history he gave me is that he did not have manic symptoms until he got on that medication. And then, once he got on that medication, by the notebook, there's what looks like manic symptoms. And then he got off the Zoloft, and those symptoms went away.
So it seems like that may have played a part in some way.
It may have played a part. I don't think it's a significant part, but it may have played a part.
And he wrote in the notebook, did he not, that after receiving the medication that he lost the fear of other people and lost the, do you remember those writings?
Correct.
And it was then, or later on, actually, that he wrote that text message to the young woman in his class, Hillary. Is that right?
Yes, that was much later on.
In July.
We're talking about July. And
Early July.
He had been off Zoloft for certainly for some period of time.
Do you know when he stopped taking the Zoloft for sure or no?
Well, I do when I look at, I think it's in Dr. Fenton's notes. I don't recall the exact date. I'd have to look at that.
Do you know how many pills were found in his apartment?
I know pills were found. I don't recall how many.
And in that text message, he says, I could have one moment, Your Honor. I'd like to mark this as defense exhibit. D-PT-56, I think, Your Honor.
I think you mean D-TR-56.
TR. I'll show it to counsel.
Okay. Mr. King, you may want to turn your microphone up. Okay.
I don't have an objection to the exhibit.
All right, Mr. King, are you moving its admission? Yes, Your Honor. All right, without objection, D-TR-56 is admitted and may be published. You may, and you can turn your mic back on too.
Is that the text message you're referring to, sir?
It is.
On the first page there, and there's some overlap between the three. It looks like this is taken right directly from someone's phone. Is that what it looks like to you?
Yes.
And can you see about halfway down there where it says, have you ever met someone with dysphoric mania?
Yes.
And to your understanding, is that Mr. Holmes texting on the left-hand side and Hillary texting on the right-hand side?
Yes.
And Hillary says, no, what is that? And he says, it's what I've got. And can we have the next page? Anyways, it's in your best interest to avoid me and bad news bears. See that?
Yes.
And then she says, I just looked it up. Is it manageable? I've struggled with depression too. Comes from other stuff it's hard to deal with. And in response to the is it manageable question, he says, it was, floodgates open now. Correct?
Correct.
If we have the third page. It says, are you okay? I'm not scared of that stuff, but I can understand. And he says, yup. What significance did that text message have for your determination, sir?
Well, there's all different significance, but let me start with the first. Is, as I've already testified, I thought that he had a significant depression. And I think this describes a significant depression in the context of all the other stuff that I've gathered. The other thing that this helped me formulate, one of the questions I had to try to answer is, if he's had this homicidal thinking for this long, one question is, why is he acting on it now? And you can also ask the question, well, if he's had this delusional thinking this long, why didn't he act on it in April? Why did he wait till July? And this, along with other questioning, helped me answer that question. And so he didn't act on it, and he says in the Gargi March 25th chat why he didn't act on it is because he would get arrested. And that's why he didn't act on it, because he didn't want to get arrested and go to prison. So why is that not a deterrence now? I think the reason it wasn't a deterrence by July is his depression. Having a major depressive disorder is an extremely unpleasant experience for most people. It's a painful experience. And I think he was significantly depressed, and so depressed that, and what he essentially told me, that acting on this belief that if I kill people, I will feel better, that going to jail didn't look so painful as how he felt not acting on that belief. So he felt so depressed that he was willing to do anything that would make him feel less depressed, even if it was going to end up in jail. And I think that's what he's saying here is, in many ways, he had some coping mechanisms before to deal with the depression. And part of those coping mechanisms is, people feel feel better about themselves generally through their love and their work. And for him, work was school. And so he failed at school. He failed at his relationship. And those coping mechanisms weren't helping him with feeling better. And I think that's what he means when he says the floodgates are open. There's no way of shutting the floodgates again to at least make him feel less painful. So that's my understanding from talking with him about this.
You can take that down, man. Thank you. You were asked some questions about whether or not Mr. Holmes ever told you that he felt like he was possessed by some higher power or something along those lines, by a do you remember that line of questioning from Mr. Brockwood?
I do.
Said he remembered the questions.
Overruled.
Do you remember Mr. Holmes talking to you about the selfie photos that he took with the black contact lenses?
I do.
do you remember him saying to you that these lenses had a feeling, quote, like I'm possessed, just felt right, possessed in some manner, like I had to go through with it?
Correct.
Now, you said that you ruled out dissociative identity disorder as part of your differential diagnosis. Is that right?
Correct.
And that used to be what was called multiple personality disorder?
Correct.
The civil thing?
Correct.
Now, in terms of malingering, would that have been a perfect opportunity to malinger if Mr. Holmes had wanted to do so?
Yes.
Why?
Because what he could have said is, I don't remember doing any of this. It was a part of me that I don't know about. And then that would have led to a whole different series of kinds of questions. And the reason I say that, back in the 1980s, when it was still called multiple personality disorder, it was sort of in vogue, not both there was a group of clinicians who suddenly were diagnosing multiple personality disorder in a huge percentage of people
that was you? Or
pardon me?
That was you that was diagnosing the more? No, I'm joking.
Yeah, that was not me. Yeah, but as a result of that, there were a lot of people in criminal court pleading NGRI based on MPD, multiple personality disorder. And so I've been through that before about trying to rule out malingering, because it's very easy to say, I don't remember, and it was someone else. That's, and it was not infrequently done. Mr. Holmes didn't do that.
Yeah, Mr. Holmes.
And I gave him plenty of opportunity to do that, and he did not do that.
He refused to just blame it on another part of himself or something like that. Fair to say?
Correct, and he didn't claim memory loss. That's correct.
But he did talk about his normal self being distinct from his crazy self, though. Do you recall that?
Yes.
That? And when you asked him, how does that work? He was unable to say why that was important to him, right?
Correct.
There were no gaps, though, in his recall of the day of events that would suggest that he was becoming another person at different times, and then didn't remember large portions of.
There was. That's correct. He does not meet the criteria for dissociative identity disorder.
Now, you did note in your report, however, that there were symptoms of depersonalization. For example, experiences of detachment, distorted sense of self, emotional and or physical numbing that appeared to be present during the time surrounding the alleged crime. Is that right?
Correct.
I want to just follow up a little bit on malingering. In order to have been malingering his mental illness, Mr. Holmes would have to have been malingering with Drs. Fenton and Feinstein, right?
Among others.
With Gargi in the chat in March, right?
Correct.
When he applied to the University of Iowa.
Correct.
So we see evidence that shows that he's not feigning. It goes way back in time, prior to even the development of the delusion that caused the shooting, right?
Correct.
Now, would you agree with me that if someone is going to malingo their symptoms, they're going to exaggerate their symptoms, and there's certainly some indication at times that Mr. Holmes seems to minimize his symptoms?
Correct.
Is that something that people with mental illness do, is minimize their symptoms?
It's very common that people with serious mental illness minimize their symptoms, and the reason they do that is no one likes to not have their brain working correctly. Most people don't like having medical illnesses. So, I mean, it's not unusual. You see someone who has a heart attack who had symptoms the day before, and they denied that they had symptoms consistent with a heart attack, because who wants to have a heart attack? Well, it's very similar to having a mental illness. There's a tremendous stigma in this country associated with having serious mental illness, in addition to it being very unpleasant to have a serious mental illness. So people's psychological coping is generally to deny that you have such symptoms.
Any indication to you that Mr. Holmes' mental illness is a pleasant experience for him, either in the past or currently?
No. There's no indication that it's been a pleasant experience for him. There's plenty of indications that it's been a disturbing, distressing experience for him.
Both before the shooting and subsequently?
Correct.
Now, on the psychological testing that was done of Mr. Holmes, that testing revealed, it revealed that he wasn't malingering, number one, right?
It was consistent with him not malingering.
It revealed as well that there was some significant psychological disturbance in the testing itself.
Correct. It was consistent with having a psychotic illness. It was also consistent with having a depressive illness as well.
So as a bottom line, it's very clear to you that Mr. Holmes suffers from a chronic and serious mental illness associated with psychotic features, yes?
That's an answer, Your Honor.
Overruled.
Yes.
And the symptoms of that illness have included the following: delusions, hallucinations, catatonic behavior, negative symptoms. True?
True. And now I just want to be clear, when you're talking about hallucinations, I'm not just talking about pre-July 20. I'm talking about November 17 and before.
Understood. Negative symptoms including diminished emotional expression, lack of motivation, diminished speech output, lack of interest in social interactions, and decreased ability to experience pleasure. True?
Correct.
A marked decrease in his level of functioning.
Correct.
Across numerous areas of his life.
Yes.
Manic-like symptoms.
Correct. And I think in my report I said manic-like symptoms by history.
You did, as a matter of fact. Thank you for correcting me. And by history you mean reported in the notebook as having happened in early 2012.
Reported in the notebook and reported by him. That's what I mean by history.
Obsessive compulsive behaviors.
Correct.
Chronic suicidal and homicidal thinking.
Correct.
based upon everything that you've seen, it's very clear to you that the tragic and horrible shooting spree on July 20th was a direct result of Mr. Holmes' illness. Is that right?
Correct.
And without that mental illness, the shooting would never have taken place.
That is my opinion.
What's concrete thinking?
Concrete thinking is to be contrasted with abstract thinking. So, for example, if I ask you to tell me people in glass houses should not throw stones, if you have an example of abstract thinking, and I say, what does that mean? Abstract thinking would say, well, you shouldn't be critical of other people if you have the same faults. Concrete thinking would be, you shouldn't throw stones in a glass house because you'll break the glass. So that's what concrete thinking is.
Mr. Holmes displayed evidence of concrete thinking?
Correct.
And that's a sign of schizophrenia, is it not?
It's consistent with schizophrenia.
Or schizoaffective disorder.
With a lot of other illnesses, but also with schizophrenia or schizoaffective disorder. And you can also have concrete thinking and not be mentally ill. So I don't want people to think that if they have concrete thinking, that's a sign of mental illness.
Not necessarily, but
Correct.
it can be.
It can be, but because you have it doesn't mean you have a mental illness.
Now I want to talk a little bit about nihilistic philosophy and philosophy in general. Can we do that?
I guess we're going to.
There's been some talk about how, and you heard Dr. Reed's testimony about how Mr. Holmes had a belief in moral relativism, or what could be called nihilism. Let me ask you this. Can somebody believe in moral relativism and still be mentally ill and psychotic?
Yes.
Isn't it true that many times people's psychosis or delusions incorporate aspects of religion or philosophy into the delusional construct?
Correct.
For example,
it's not restricted to either religion or philosophy, but correct.
Could be anything, right?
That's correct.
Like I think I'm Jesus Christ, for example, would be a delusion you mentioned before, right?
Correct.
That would be related to religion in some fashion,
Correct.
right? And so the fact that Mr. Holmes may have a belief in moral relativism does not mean that his thought process was not psychotic, does it?
Correct.
Whether or not he believes in moral relativism or not is irrelevant to whether the thought process is psychotic. I mean, it could be either way.
Correct.
You were asked about whether you saw Mr. Holmes react emotionally when you talked to him, and you did not, did you?
Correct.
Now, you were the third psychiatrist to see him, is that right?
Probably more than that. Before my seeing him, there was Dr. Woodcock, there's Dr. Gurr, there's Dr. Mosier,
The folks at the hospital, in some sense.
Dr. Pounds admitted him, so I was probably the fifth psychiatrist. I was the third psychiatrist who, well, I was actually the second psychiatrist who really talked to him about the alleged crimes.
The more that you see people, the more their reactions can change, especially when someone is medicated, right?
Yeah, I would say more, not so much the more you see people. I think that when you're talking about emotionally charged issues, probably you're going to see the most emotion related to those issues the first time you talk about it. I think when you talk about it the second time, you're not going to have the same, necessarily going to have the same emotional reaction.
Now, there's been some talk about whether Mr. Holmes was seeking to be remembered or some kind of notoriety or something along those lines. It's your opinion that the pursuit of notoriety was not, in this case, the basis for the shooting.
That's correct.
Now, with regard to psychotic ambivalence, it is psychotic ambivalence that caused Mr. Holmes to go to the psychiatrist, tell the psychiatrist he was going to kill a bunch of people, and then withhold further information because he was psychotic, right?
I don't know if that was psychotic ambivalence. I think it certainly was ambivalence. I'm not sure that the reason I'm saying I don't think it was psychotic ambivalence is I think if it was psychotic ambivalence, he would have been more likely to tell him and then next day not tell him. And I think it was just ambivalence.
Do you remember testifying in this case before, sir?
I do.
You recall testifying in the afternoon of January 30, 2014.
I do.
Counsel, I direct your attention to page 68 into 69. What's that? Sure. Do you recall this question and answer? And I'll give you a chance to clarify if you want. Okay, so if you go to a psychiatrist and you tell the psychiatrist, I'm thinking about killing a bunch of people, why would you then withhold further information from her? Answer, well, I can actually answer that because we talked about it, okay? And because he was psychotic. And part of psychosis is you frequently see ambivalence. It's not all one way or the other. And one of the things he told me on one hand, he wanted to be hospitalized. And on at least one occasion, and I think more than one occasion, he was giving answers such as, if I told you that, you would hospitalize me. And then on the other hand, he had the delusional belief that he wanted to act on, and if he was stopped, if he was hospitalized, he was not going to be able to do that. So that's an example of ambivalence and psychosis. Do you remember those questions and answers, sir?
I don't think that's inconsistent with what I just said. What I said in that testimony is it was an example of ambivalence and psychosis. What I didn't say is that's an example of psychotic ambivalence. And I think on balance that, so that I stand by what I'm saying now.
Okay. Now, it's not uncommon for schizophrenic people to describe delusions somewhat differently over time as they become medicated. You said that. And the reason is that they may describe delusions differently because medication can change the underlying process that led to the delusion in the first place. Correct?
Correct.
They may also describe delusions differently because of protective reasons. Can you explain that?
That, again, goes back to not wanting to think that your brain's not working well. And if you begin to think about a particular thought process, you could change that because that particular thought process is too disturbing for you to come to terms with. And so you could change it as a protective psychological mechanism.
At some point, Mr. Holmes told you that the thoughts that he had about the homicidal thoughts that he had, after he expressed them to Gargi in that Gmail chat in March, that they became more real because they existed outside his thoughts. Having spoken these thoughts led to an action regarding these thoughts. You recall that?
Yes.
Can you explain that?
I can't rationally explain that. I think that's part of his psychosis. Yeah, I mean, that the fact that he spoke out loud and shared this delusional thinking, he somehow made it more real to him, I think is psychotically based. I can't give you a rational explanation of why that would happen.
Now, he described later on that this was an inevitability, something that he had no choice about doing, he felt, something he was obligated to do. Fair to say?
You'll have to refer me to my report where I say that, because I'm not sure that I have that information from my examination, that it was inevitable.
Okay. Well, let me ask you this. You were asked about whether he used the phrase call to action, I think. Do you recall that question?
Correct.
He did say to you that once the thoughts were more real, having spoken them led to an action regarding those thoughts. Correct?
He did say that. That's correct.
All right. I'm almost done. I want to ask you a little bit about your treatment of prong 2, or capacity, if I might. Now, in your analysis of capacity, you noted in your report that you used the societal standard of morality in determining, when it came to the issue of ability to distinguish between right and wrong. Is that correct?
Yes.
That's your understanding of the test in the state of Colorado.
Correct.
Your understanding of the test in the state of Colorado is that someone may be insane under the law, despite the fact that they know that their actions are legally wrong or against the law, correct?
Correct.
You listed a number of factors in your analysis of what was significant to you. Now you believe, it's your strong contention that he legally knew quite clearly that what he was doing was against the law, correct?
Yes.
The issue of morals was a little bit more gray for you, fair to say?
Well, as I said in direct, it was more difficult for me because I had problems obtaining information from Mr. Holmes because of the nature of his illness.
Okay.
Once I obtained that information, then it wasn't a difficult assessment for me.
And the assessment was that he was able to have the capacity to distinguish the wrongfulness of his actions.
Yes.
It's also very clear that his appreciation for the wrongfulness of his actions was impaired from a clinical perspective as a result of his psychotic thinking, correct?
Right, and the reason I said from a clinical perspective is I was using the term impaired or impairment, not using a legal definition, which is a different definition. I was using it from a clinical perspective, that his judgment was impaired.
Now, there are circumstances, are there not, where society considers it morally right to kill.
Correct.
During wartime?
Yes.
To prevent larger disasters or when someone's life is threatened?
Correct.
So being part of being able to distinguish whether something is right or wrong is understanding the context in which that is made. Is that fair to say?
Certainly in terms of war or self-defense, that's fair to say.
The terrorist who conducts a mass shooting for political reasons and is not mentally ill, we would all agree that that person is morally wrong from a societal perspective.
Correct.
But the person themselves, the terrorist, might consider that it's the morally right thing to do if they really believe in their cause. Fair to say? And that's why it can get a little tough, because we're combining law and medicine and morality together in one place. Fair to say?
Okay. The objection is overruled, but Mr. King, you must proceed as we discussed at the bench.
For someone who has their microphone on. For someone who is psychotic, the context in which we have to evaluate their ability to distinguish right from wrong includes their psychosis, right?
Yes.
The thought disorder and the delusional thinking, right?
Correct.
The paranoia and the impaired judgment.
Yes.
Reality for that person is colored by the thought disorder they're suffering from.
That's
right?
also correct.
We know, as we sit here today, that it's morally wrong to kill, right?
Correct.
But the question for the psychotic person is, at the time, perceiving and understanding the world through their thought disorder, did they have the capacity to understand what was right and wrong?
That is the question.
When a person is psychotic, their decision making and their thinking is affected by their psychosis.
Correct.
And you give an analogy to drunk driving when we've talked, when it comes to capability. Is that right?
Correct.
Can you describe that analogy for the jury?
Yes. You could be intoxicated and know that it's illegal to drive while you're drunk. And you can also know that it's morally wrong by societal standards to drive while you're drunk because you could injure people. But because your judgment is impaired by your intoxication, you could say I don't care, or you could say it's not going to happen, and so your judgment would be impaired, and you would still drive. And the context that I gave that analogy is when I said that in my report that I thought Mr. Holmes' judgment was clinically impaired, and that's why he did what he did, despite knowing the difference, in my opinion, despite having the capacity to know the difference between right from wrong. He still did it because he had impaired judgment. And as I said before, an example of his impaired judgment in my mind was that it was much better for him to go out and do this in order to increase his self-worth and feel better than it was to not do this and feel as bad as he did. And that it was worth the risk of him going to jail because of how he felt. And all that is example of psychotically impaired thinking.
Now, insanity is a recognized offense here in Colorado. Is that right?
Correct.
For any specific intent crime, right?
Correct.
Is voluntary intoxication a defense to drunk driving anywhere?
Not that I'm aware of.
Is someone who's drunk ever insane? Or would that be specifically precluded by the statute?
Well, it's precluded if the cause of your assuming that you lack the capacity, if the cause of your lacking the capacity is because you're drunk. I imagine you could have lost so that's my answer, to make it clean.
Someone who is drunk doesn't have persistent delusional beliefs, do they?
Correct.
If I'm drunk and I'm going to drive, is the first part of your analogy, does that imply that the person is making a rational choice despite their impaired judgment? In other words, they know that what they're doing is wrong. They're thinking in a rational way about that, but their judgment is impaired such that they don't care, or they're rationalizing and justifying their behavior.
And would you please repeat your question?
The question is, if I'm drunk and going to drive, does that imply that that person is making a rational choice?
No, it doesn't.
Turn on your mic.
I'm going to object to the relevance of the drunk driver for the discussion.
Sustained.
Okay. The factors that you pointed to, sir, that you relied on in making your determination of capacity were, first of all, the content of the Gmail chat with Gargi. Is that right?
Correct.
And that took place in March. Is that right?
Yes.
So you're inferring by what he said in March that he could distinguish between right or wrong in July. That's the inference.
No, that's not the inference. If it turned out that my opinion was he lacked capacity in March, that would be important information. The fact that he didn't lack that, in my opinion, that he had capacity in March is a point in time. And I couldn't generalize what he had in July based on what he had in March, but it's a point in time that's useful information.
So it's something that you can infer from.
The reason that that's important is part of my diagnostic thinking is that, in my opinion, he was psychotic in March. And in my opinion, in March, he had capacity to tell the difference between right from wrong. And I wanted subsequent questioning to see if anything changed. Did his illness change that changed his capacity? So that's really the significance.
That he had the ability in March to distinguish between right or wrong, and from that, absent some change, you're inferring that that was the same state of mind he had in July.
That's fair.
Same is true of his statements to Drs. Fenton and Feinstein. That's closer in time to July than March, for the most part, correct?
Yes.
But again, it's a point in time whereby you can then infer that he knew the difference between right or wrong, had the capacity to at that point, and absent something contradictory, you're saying that he did in July as well.
Yeah, what I'm saying is the closer you can get to time, the more, probably the more important the assessment is. So, for example, opining that at the age of 16 he had the capacity doesn't mean much. It means a fair amount when you can opine that at the onset of his psychosis he had the capacity, and it means something when in the same month of the alleged crimes he had the capacity. And then it means a lot when you can say immediately prior to the shooting he had the capacity. It means a lot.
And those things all can mean something, but they are not dispositive of what was going on in his mind as the shooting took place, correct?
It's not 100% dispositive. It gets pretty close.
You said that one of the things that you considered was the fact that he didn't reveal his planned actions to Drs. Fenton and Feinstein, right?
Correct.
And by that you infer that he knew that what he was doing was going to be wrong, or what he was planning to do was wrong.
Correct.
And that could certainly be true in a legal sense, that he may have thought that it was legally wrong and he didn't want to tell them because he would have been stopped from doing what he was doing.
That's a possibility.
That doesn't preclude the fact that he thought it was morally right.
That fact by itself, I would not have rendered that opinion based only on that.
And if he had told Dr. Fenton and Feinstein exactly what he had planned to do, that would have also suggested to you that he had the capability to distinguish between right or wrong. Right? Why would he not tell them if it wasn't wrong?
Let me just think about your question again. If he had told him, that would have meant that he could distinguish the difference between right from wrong, is your question.
As well, yes.
That's, again, a possibility.
You brought up the fact that after the shooting, Mr. Holmes didn't attempt to escape or didn't attempt to leave or drive off, but just waited there because he knew he was going to be arrested.
Correct.
Again, a sign that he knew what he was doing was legally wrong, for sure.
Yes.
And by that you infer perhaps morally, right?
Yeah, I infer more than just perhaps. Yeah, I think that that was an indication for me that he knew it was morally wrong as well.
If he had jumped in his car and sped away and led the police on a high-speed chase, that would have also created an inference for you that he knew what he was doing was wrong as well, right?
Correct. However, if he had jumped in his car and drove normally, as if nothing he did was wrong, would create a different inference for me.
If he jumped in his car and tried to drive casually away as if nothing had happened, that wouldn't create an inference that he was trying to get away because he knew what he was doing was wrong?
Well, that would then require further questioning of him, of why did you drive casually?
If he'd shot the police officers, that would have been an indication to you that he thought what he was doing was wrong.
Again, it would be, if he shot the police officers, I would need to talk to him about why he shot the police officers before I made that judgment.
And if he attempted to run away on foot, that would have been an indication to you that he knew what he was doing was wrong as well.
Correct.
I have 1 minute, Your Honor.
Yes.
With regard to your opinion, sir, that the cause of the shooting was the mental illness, you hold that opinion to a reasonable degree of scientific certainty?
Reasonable degree of medical certainty.
Thank you. I don't have any other questions.
All right, Mr. Brockler, do you have any redirect?
Yes, Your Honor, thank you. Dr. Metzner, in light of all of the stuff that Mr. King just went through with you and all the different possibilities from suggesting that something else was to blame for it or something else could have caused it or all these different scenarios, including the drunk driving one, has your opinion changed one whit that this guy right here had the capacity to know right from wrong based on societal standards of morality when he walked into that theater on the 19th and 20th and tried to murder the theater full of people?
It has not changed.
You still extremely confident in it?
Yes.
How about the other prong? Anything about what Mr. King brought up to you or threw out as possibilities that changes your extreme confidence in your previously stated opinion that this guy had the capacity to form the intent to murder after deliberation and to act knowingly with regard to all the other alleged criminal conduct?
My opinion hasn't changed, and my degree of confidence hasn't changed.
In fact, had you considered all of the things that Mr. King had just brought up in cross-examination in formulating your expert opinion on the matter of sanity?
I believe so.
There was something that you said right towards the end, and then we'll back up to where Mr. King started. You had said with regards to trying to figure out what his capacity was on July the 19th and 20th, you said it's not 100%, but it's close. What did you mean by that?
I'm trying to think of the context of the exact question that I was responding to. I think the question was, one of the factors that the context was what was going on in his mind immediately prior to the shooting. And one of the factors I talked about, there was actually two of the factors that I previously talked about. One was the telephone call to the University of Colorado. The second one was putting on the headphones and wanting this to be impersonal, not wanting it to be personal. That's about the closest you can get to what his state of mind was without being in the theater and interviewing him as he's shooting. And so that's why I say it's not 100%, but it doesn't get much closer to getting that kind of information.
Some of the other things that you had brought up before, though, took place either during or shortly after. Do you recall one of the prongs you talked about was his reference afterwards to whether he had killed any children?
Correct. And so that was pretty soon after the shooting as well.
We had evidence presented that he sent the notebook maybe that night before. Also, you had indicated that the mailing of that notebook fed into your thoughts about his capacity to know right from wrong based on the societal standards of morality.
Objection leading, asked and answered.
I'll sustain us to leading. So sustain us to this being a leading question overruled as to asked and answer. You can rephrase the question.
Thank you, Your Honor. Sir, let me do that since that got sustained. How did the mailing of the notebook impact you in terms of your analysis of capacity and the timing related to when this shooting took place?
Well, it was the day before the shooting, and the stated reason, which was consistent in my mind with a lot of the contents of the notebook, the stated reason was to educate psychiatrists in the future so they can prevent this from happening. Well, if he had the capacity, if he lacked the capacity to tell the difference between right from wrong, there would be no reason to educate psychiatrists about doing something that he thought was right.
There was another portion of the exchange here towards the end where you were confronted with other hypothetical facts from this. For instance, had the defendant actually made an assessment that he could get away and had driven away, how would that impact? Do you recall that exchange?
Yes.
I want to give you a different hypothetical that touches upon that. If you had a hypothetical where the defendant, on the same day, goes to a gun store, purchases an AR-15, buys ammunition, carries it out in broad daylight, walks across the parking lot to, let's say, a theater, walks in broad daylight, does nothing to be surreptitious or cover up what his plans are, goes and even gets a Coke to drink, walks into the theater and starts shooting folks from that regard. Are those facts distinguishable enough from these that they begin to suggest that maybe this guy doesn't know right from wrong on a societal standard of morality?
They would be.
When you are considering this crime, are you focused on one, two, or three things, or do you look at a global perspective of all the decisions that were made by that guy right there?
We look at the totality of the circumstances, so it's not based on just one factor.
And I want to make sure that I'm clear on this too. We keep saying psychotic and psychosis, and those are the right terms, I get that. But they all flow from the delusion, is that right?
Yes.
And I want to make sure I know what the delusion is. Is the delusion that he thought he would feel better and his value would increase the more people he killed?
The delusion was that he would increase his self-worth by killing people. And a secondary thought he had about that is that this would help him become less depressed. So there are really two aspects of it.
Is it accurate or fair to conclude that the defendant then made a decision to substitute human lives for his increased self-worth and feeling better?
Objection. Calls for an improper opinion.
Overruled.
Go ahead, sir.
I think that's accurate.
Mr. Bruckler, I think today is a day when we have to stop at 5. One of the jurors has to leave at 5 and told my staff, and so we're going to have to adjourn. Doctor, can you return tomorrow?
Yes.
Oh. Okay, I'm being told that the juror does not have to leave at 5 today. All right, so then let me ask all the jurors: is there anyone on the jury who cannot stay past 5? No, Mr. Bruckler, how long do you think you have on your redirect? Oh, not super long time. That's why I was asking how long you think it's going to take you.
I think it would take me just in excess, more than 15 minutes. I don't know what a short time is, but.
In that case, we'll just stop then. I think it makes sense to just stop. Are you okay coming back tomorrow, Doctor?
Yes.
All right. All right, members of the jury, we're going to go ahead and adjourn for the day. Please keep in mind all my advisements that I've been giving you with respect to your conduct when you're not here. All of them apply tonight. Have a good evening. Get some rest. I'll see you tomorrow morning. Thank you. The record should reflect that the jury has exited the courtroom. Everyone may be seated. Dr. Metzner, are you okay coming back tomorrow morning?
Yes, I have a question for you. Am I okay in making plain reservations to leave the state on Wednesday morning?
Yes, we should be. I don't see how we don't get done with you by tomorrow.
Okay, I'm okay coming back.
If Mr. Brockler goes on with his redirect until Wednesday, I will stop him.
Thank you.
So you can make reservations.
Thank you.
All right, thank you. And you're free to leave, by the way. And by the way, I wanted to let counsel know that the reason why I decided to just adjourn for the day is one of the jurors indicated that she needed a restroom break. And so it was going to take us at least 10 more minutes to do that. My court reporter hasn't had a break for a couple of hours, and I'm sure she needs a break. And so I just decided it was best to just adjourn for the day. In terms of the emails that we talked about, when tomorrow are you thinking that you're gonna that they're gonna come up?
Actually, and I don't know if you're on a notice, we sort of standing a second ago, because I learned while Dr. Metzner was testifying some new information, and I do not believe that witness is available tomorrow, so I think it will be Wednesday.
Okay, great. Okay, that gives us some time, and so I'll pick a time tomorrow when it makes sense for me to make a ruling on that exhibit. And by the way, I did notice when you were standing up, Mr. Orman, although that doesn't always communicate to me, what I think it should. So I'm glad that you told me what it is you wanted to talk about. Is there anything else on behalf of the people at this time? Is there anything? Oh, Ms. Tish McGuire?
Thanks, Your Honor. Your Honor had issued an order about victim impact videos. And from my understanding of the court's order, it seems like you just wanted me to discover the new videos to the defense if they have objections to raise that with the court. But I wanted to double check and see if the court wanted copies of those by Wednesday as well.
No, not necessarily. Just discover them to the defense, and then I'm sure Ms. Nelson will raise the issue if she thinks there is an issue for her to raise. She can do it orally.
Thank you.
Okay, thank you. Anything on behalf of the defense at this time? Mr. King, do you have anything?
No, I don't, Your Honor. I think Ms. Nelson may have something, though.
No, she's saying no.
No, we're just trying to sort out what should become court exhibits. I'll get back to the court about that in the morning if we have some things to submit.
Okay. Yeah, I talked to my staff. There was one exhibit that was admitted, I thought it was, and it was displayed, and then there was another one that was just displayed. If you want to mark that as a court exhibit, we can do that. You did not offer it into evidence, you just displayed it, and I think appropriately. So the prosecution has done the same thing with other parts of the DSM-5, and I don't know whether the prosecution has marked those as court exhibits. Have you marked those pages or portions of the DSM-5 that you've used as court exhibits?
Not, Your Honor, because I actually had it come right out of the DSM-5.
And so did the defense, and so I'm not concerned about marking it, because I'm pretty sure that no matter when in the future this may be reviewed, somebody will be able to get a hold of the DSM-5 and figure out what excerpt was read and talked about. And given the record, I think it's clear what was talked about. So, but I'll leave it up to you, Ms. Nelson. If you want to mark it, just let my staff know, okay? All right. All right, the court will be in recess. I'll see you tomorrow morning. Thank you.
Good afternoon from us at 7 News. We are wrapping up today's trial coverage, and soon we will go speak to 7 News legal analyst Dan Recht. But in the meantime, let's take a quick recap of some of the things we saw today and what we know we can expect, at least in the morning tomorrow. As you heard there, Dr. Metzner was asking if he was okay to book a flight home by Wednesday. Of course, Judge Carlos Zamora saying if Brockler's recross continues until then, it'll be stopped. So he is certainly going to be wrapped up tomorrow. Of course, recross means there may be a redirect. We'll have to cross that bridge in the morning, but it does seem that Mr. Brockler is up there asking if any of the doubt that the defense team tried to poke in the holes of Metzner's testimony, if any of that changed his opinion. So all of these is it possible questions, Mr. Brockler comes up and says, possible or not, did it change your opinion? The answer over and over again was that it did not. We heard that Mr. Orman, the discussion about the emails was originally supposed to be tomorrow, or actually was at one point the discussion about the admissibility of them was going to be today, then delayed, then the judge wants to review them, and now he's going to give us a ruling tomorrow, and Mr. Orman says it looks like his witness wouldn't be available until Wednesday. So we're going to be able to hear about those emails and the information in them for the first time, emails we haven't seen before. It appears we'll hear that on Wednesday. In the meantime, is Dan ready, Erica? We have a minute to tap dance while we wait for Dan. He should be ready now. So let's say hi to Dan Recht. Let's ask him, first of all, Dan, if you can hear me, I want to congratulate you. You predicted at lunch that the cross-examination would be a very long process, and it seems you were right, and I wonder if you could reiterate for us the strategy behind that.
Sure, there's multiple strategies, and I'm not inside Dan King's mind, but even though Dr. Metzner in the end had the opinion that Holmes was sane, there was lots of pearls that the defense could get out of Metzger's examination and the statements that he could and did make. So they wanted to pick at his testimony and repeat for the jury the things that were helpful to the defense, and there was a lot of it. So there was the delusion and the psychotic episodes and the feces on the wall and the licking the wall, and those are the things that he methodically wanted to go over and highlight for the jury. In addition, what is important for your viewers to understand is they're trying to get statements from Metzger that can be used later in the trial to read to their expert or to repeat to the jury a month or two from now when they're doing the closing argument. Dan King can get up in the closing argument and say, now, it's been a long trial, but you remember when Dr. Metzner was under cross-examination, I specifically asked him X, and he specifically said Y. So some of the cross-examination doesn't impact the jury today so much as is helpful to the defense in their closing argument.
You talked about finding little pearls for the defense. Isn't that, that's another word for finding that reasonable doubt that they're trying to sow throughout this whole process, right?
Absolutely. There's going to be, Dr. Reed felt very strongly that Holmes was sane. Dr. Metzner pulls back a little bit and in the end says that he was sane, but is much more equivocal and talks a whole lot more about delusion and psychotic episodes, etc. And their expert, the defense expert, Dr. Gurr, is going to say he was insane. So the defense is going to urge the jury in closing argument, that's the stuff that reasonable doubt is made of. You have 3 different experts with 3 different opinions, and why is that? Because this is all, just a gray area, and if you aren't convinced beyond a reasonable doubt that the prosecution's proved he was insane, well then, that he was sane, then you have to find that he was insane, and therefore not guilty. Yes, you're exactly right, Marshall. That's the strategy.
Thanks. I understand then the recross that Mr. Brockler was doing before we got on the line with you, basically to ask, does this little possibility or that little possibility change your opinion? Is there anything else that he could do to restore the foundation of that part of his case?
No, he wanted to get the last word in, and he wanted to get Dr. Metzner to say, despite it all, he has the opinion that Holmes was sane when he was pulling the trigger.
One last question for you. With all the poking of the holes in Metzner's opinion, shouldn't we keep in mind that it was already, a holy opinion? It was already poked through because the judge said that we need to do another one so that it would be an appropriate ruling for the court to consider. And so in the end, as the defense, is it more important to poke the holes in what Metzner has to say or what Dr. Reed had to say in that final report that was accepted?
Yeah, I don't know. I mean, the defense certainly wanted to discredit him or emphasize his caveats so that it doesn't look so much to the jury as if there's these two strong expert witnesses for sanity. Certainly in the end here, Metzger, while he says that Holmes was sane, says it much more equivocally than Dr. Reed did. So that was the strategy.
Dan Recht, we thank you for your time this afternoon. Happy Monday. We'll see you again on Tuesday, midday, and be back tomorrow for the end of Dr. Metzner's testimony and hopefully a ruling on what these emails contain and how admissible it will be. We'll see you all tomorrow morning, Tuesday, at 8:30 a.m. with court beginning 10 minutes later at 8:40. Have a good night.